Hello, everybody. Hello, Nana Laura. Hello, she's a maker. Hello, Robert W. Scott. So good to see you. Yvonne. Hello, sweetie. You guys have been talking it up. Hello, Sean. I decided to start a little early. Hello, Joey Bag of Donuts. Yeah, I don't know if we'll get through this all in one part. It's kind of 5.5 hours long. Oh, but my gosh. Everybody call his village. Let him know he's missing. Yeah, I would really like to be able to start kind of earlier sometimes, but oh man, there's so many days where I'm editing up to the wire. I mean, heck, how many times have I come on and I'm like, yeah, it's still exporting. Hello, Sherry B, honey. Yeah, it's a long one. Yeah. She is eating from her slow feeder treat toy that someone sent her, and it's her favorite thing in the whole wide world because her wonderful kibble from I don't know who fits so perfectly in it. And she's learned how to go like this and get it out. Hey, Ava. Hello, Janet. Hey, Ava. You can go back to eating in a minute, I promise. My goodness. What they won't do for food, I swear. Oh, yeah. Absolutely. Spoiled. Yep. And let me tell you, these 4, when they're hungry, they are grumpy. They are very, very grumpy, especially Billy. Billy gets... He gets mighty swatty. Like he literally chases Ava through the house, going meow at her. Like... This is actually new. It's a Thunder shirt. So she'll wear it. Yeah, she now wears it all the time. Yeah, this is number 3. I love you. So yeah, she got a Thunder shirt as a present, and I don't know. I think it might help a little. I hope so. I hope it makes her feel more secure. Oh, you're going to need it. Oh no, you just wait. Her Halloween costume is coming. It's coming. It's supposed to be here Friday. So you just wait. All right, because it's so long, I am going to get right into it now. I'm sure people can funnel in. They'll put it on, 1 1/4 speed or something to catch up. But with as long as it is, I think we should probably do it. I guess for context, let me just explain real quick, okay? The defendant is an inmate. The rules of the prison are that your dentures can be replaced. It used to be every 5 years. Now it's every 7. Okay, you've got to make your dentures last. When he went into the Department of Corrections, his teeth were all messed up. And they made dentures for him. And he alleges they altered them, despite the fact that he told them that he filed them down with a Brillo pad. But now, because he alleges they altered them, he wants pain and suffering for him not having dentures. Oh, yeah, they are. Yeah, they are. My mom's never fit right. Never. So that's the skivvy. I'll apologize in advance. Y'all, I am sorry for what I'm about to put you through. Oh, shoot, I never took it out of this computer. It's done. I just have to eject. Told y'all. See, I'm a professional. Okay, safe to remove hardware. Got it. Doot, 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 doot. Okay. I'm not giving any more spoilers. You'll hear all about it. I promise. I promise. Truer words were never spoken. I am not passing up a chance to use my I've been to the law library.
Thank you very much. We are a couple minutes early. I will give Judge Schumann a call to see if he is ready to proceed. Until then, I will turn my camera and my microphone off until we are ready to begin. Thank you.
Thank you. Quick question for you, Court Clerk.
Yes, Mr. Stanley.
Yes, the judge was supposed to give me a memorandum of the decision that was recusing this judge from the petition. So therefore, again, can you read me what her order was? Because I've never received it. And what day did she make a ruling on a memorandum of decision?
Certainly, Mr. Stanley. So a decision was entered on 10/17, which I think was Thursday of last week. Hold on one second. Let me check. Yes, that was Thursday of last week. So it's probably, the judicial notice is probably still in the mail. And I can read it word for word if you would like. The foregoing having been considered by the court is hereby denied. The motion to disqualify Judge Schumann is denied for the following reasons. 1, the motion is procedurally defective. See Practice Book Section 123. 2, the motion fails on its merits. The plaintiff has failed to articulate in his motion during the 10/15/2024 hearing thereon any basis for the court to find that disqualification of Judge Schumann is warranted in this action. quote, a judicial authority is not automatically disqualified from sitting on a proceeding merely because an attorney or a party on the proceeding has filed a lawsuit against the judicial authority or filed a complaint against the judicial authority with a judicial review council, end quote. Practice book section 122B. Moreover, I apologize, Your Honor. Before we begin, I'm just reading Mr. Stanley, the decision provided by Judge Morgan regarding the motion to disqualify. So I just want to finish that before we begin.
Go ahead.
Moreover, adverse or unfavorable rulings are not in and of themselves evidence of judicial bias against a litigant. Tratzman v. Tratzman 144, Con App 789, 803, 2013. The burden rests with the party urging disqualification to show that it is warranted. Stefani versus Darian Little League Inc. 160 Con App 457-464-65 2015. The plaintiff failed to satisfy this burden. On the record before it, the court finds that there is no reasonable on the record before it, the court finds that no reasonable person would question Judge Schuman's impartiality on the basis of all the circumstances of this case by Judge Lisa Morgan. So with that, I believe we are ready to begin. The Superior Court for the Hartford Judicial District is now open and in session. The Honorable Carl Schuman presiding. Good morning, Your Honor.
Good morning. This is the matter of Stephen Stanley versus Dr. Cuevas et al. May I have the appearances of pro se parties and counsel, beginning with the plaintiff. Mr. Stanley, that's you?
Yes, the petitioner Stephen K. Stanley.
All right. Good morning, sir. And for the defendant.
Good morning, Your Honor. Stephen Finucane, Assistant Attorney General for the defendant, Dr. Frankie Cuevas, who is with me today.
All right. Good morning, Mr. Finucane, Dr. Cuevas.
And for the record, is the court aware that there is a pending appeal right now that was granted to cease and desist this hearing as of today's date?
No, I'm not aware of that.
Yep, I called the appellate court this morning and the defendant still has not responded to the appeal. That would be entry number 238, and that was a 9:30. It was entered to the appellate court, docket number AC 48073. And about 15 minutes ago, I had placed a call to the appellate court, and to date, the defendant has not responded to this appeal. So therefore, again, one, this case cannot proceed forward because there's an appeal pending. Secondly, I was moved to the East Sector at McDougal Walker Correctional on Thursday night, and my paperwork has been detained from Captain Ortego, and they reached out to him this morning, and nobody knows where my paperwork is. And secondly, I've reached out to a Herbert Santos for an attorney, maybe requesting for obtaining an attorney. So therefore, again, from the appeal and with the housekeeping matters still pending, never been addressed, this case cannot proceed any further because one, there's appeal pending. Two, there's housekeeping matters from motions to strike that go all the way back from the year 2020 up to date. And therefore, again, I've never yet had a hearing on my denied fee waivers that you denied all 36 expert witnesses to testify against the defendant to show cause that he is violating my civil due process liberty rights.
Mr. Finucane, are you aware of this appeal?
There is an appeal on the docket. My reading of that was it's yet another attempt at this jury trial thing that he's tried to appeal numerous times. In the time since Mr. Stanley's mentioned this, I did do a quick search on the appellate court website, which does reference an appeal. It looks like that is about an in-person trial and subpoenas for witnesses, both of which you've ruled on and Judge Morgan and other judges have ruled on. Also, we had a hearing last week with Judge Morgan on the motion to disqualify. And at the end of that proceeding, Mr. Stanley stated he would be rejecting today's trial date. these things all appear to me to be yet further attempts to delay this trial. The jury trial issue's been ruled on. The in-person trial issue's been ruled on. We have our exhibits submitted. I have a dentist here. We are ready to go. I think we should proceed.
Your Honor, I would like to rebuttal to that if I may. One,
All right, briefly.
The judge last week declined to hear any articulations, only articulate for you to disqualify yourself, which he wouldn't even address my further case flow. I mean, my further cases I have to support for disqualification of you. Secondly, she would not address any of my expert witnesses being certified to testify on my behalf, nor would she address the fact that I was maybe obtaining counsel. And I've got wind now. I've received it in the mail given to me today. The defendant filed a motion for a protective order and a stay all this case of this docket number, and it's dated September 30th, 2024. And he's even asking for a 30-day extension to all discovery has been ruled on, and he's asking for a protective order. And I'm holding that motion in my hand. To date, this was just given to me. I don't know why it's so late, but this September 30th legal mail just given to me today, where he's asking for a motion for a stay of discovery. He's asking for a protective order, and he's even asking for a 30-day extension to this case. So therefore, again, one, we've never addressed housekeeping matters of any and all motions because she refused and declined last week to clear the docket of all this housekeeping matters. So how can we proceed any further when it's never been articulated and there's been no final judgment on any of my motions for asking for now for maybe appointment of counsel? Two, I'm asking for the my top bone is gone. I asked you to grant me certain subpoenaed witnesses that would testify in their own certified statement that says, due to this doctor's negligence, denied me my civil liberty rights. The DOC Administrative Directory says that they will fix to replace my dentures in 72 hours. He made me wait 5 years. And now that person's statement, which you're denying me my right.
All right, Mr. Stanley, I will hear your testimony.
Barry, sum it up. That expert witness gave a certification statement that would have been addressed on the record today that due to his negligence, there's no bone left. So now I have no choice but for implant, Your Honor.
Mr. Finucane, did you file a motion to stay this trial?
No, Your Honor. So there's a little bit of confusion here. Mr. Stanley filed a nearly identical lawsuit that's pending in this court with a 24 docket number. In that case, I moved to stay discovery obligations. It looks like the original filing in that case that was intended to be in that case mistakenly included this case's docket number, but I filed a notice addressing that, correcting it. I've never moved to stay this trial date. We've been preparing. I will also note at the trial management conference with Judge Morgan, there was an issue with subpoenaing expert witnesses and 30 people. Be very clear, and Judge Morgan took note of this. There have never been any expert disclosures in this case by Mr. Stanley. There's never been any discovery conducted in this case. So we're ready to go to trial. We're not delaying. In fact, our reading is Mr. Stanley's obviously trying to not proceed today. We're ready to go.
Your Honor, there's a Brady violation and there's a Giglio violation. I've asked for discovery outside this court's discretion. 6.5 years of discovery. We're down to the wire, and now they're pulling this shenanigans that what I'd never asked for. I got the court now to compel now because now there's a set trial date. They have failed to supply me with this discovery for 6.5 years, just like they denied me my implants for 6.5 years, and I'm the one suffering. It's my pain and suffering. So for this case to proceed any further, the judge, one, would not take judicial notice of a housekeeping matter that has to address any and all motions pending before we can even proceed for trial. So if you even attempt to start for this trial today, we need to address any and all of my motions. We need to address why my expert witnesses are not here, because it's my civil and constitutional right under my Constitution of liberty rights for my expert witnesses to testify on my behalf, just like it's the defendant's right to have the defendant here in court. So how am I going to support my claim if you're denying me to support any of my expert witnesses to be forward? So therefore,
Right,
again,
I've already ruled on all your pretrial motions.
you have
so-
not, because one, you said, if I asked you nicely, it says in your motion, I have the paper right here. If I asked you nicely, you said, you would bring me into court so I could enter evidence as a full exhibit. I sent you a motion requesting for an in-person again. You failed to rule on it. You marked it off. So therefore, again, you have not addressed. I mean, we go all the way back to, number 120 of 10/19/2019, there's a motion to strike that's never been ruled on. All motions in the statute book have to be heard in 120 days. This is nearly 6.5 years old. You have not addressed anything because it's marked off.
Right. I believe I have addressed all motions at least
so
once.
tell me what your answer
So-
is to number 120, if you may. I have a motion to strike that's entered and it's marked off. So tell me what the response is to number 129 that was entered on 10/19/2019, motion to strike. What is the answer? Because on my printout from days ago, it was just 10/17, it says marked off. So what is the ruling on number 129, motion to strike?
I can't tell you from memory. But
Well, you can look at the file. You have it in front of you. Tell me,
Right,
you're
but
saying you ruled
see-
on it. So tell me the answer to number 129. We have
Today-
housekeeping matters that need to be addressed, Your Honor.
Right. Today is the day for trial, sir. I've
No,
already
today
ruled-
is the date for the housekeeping matters because the
Right.
judge refused and declined the other day to address any and all of these things. So
Right.
if you're making me go forward today, then I'm asking for a continuance because I'm going to obtain counsel. I have Herbert Santos, which,
Right.
my
I
my
have to tell
executor
you,
is down in Florida, is unable to produce a check for at least 30 days to hire an attorney, and
Right.
it's my civil and my constitutional right to obtain counsel on this behalf, as
Right,
well as I'm entitled to my discovery. You can smile all you want. That's the
no,
law.
I'm not
Right?
smiling. I'm just,
The supremacy clause says fairly clearly, I'm entitled to an attorney if I request that. And again, DOC has held my whole file. How are we going to proceed further today
Stanley.
when I was moved on Thursday to the East Sector and I don't have any of my file to proceed forward to this case today? DOC has moved me, and where's my paperwork? We cannot proceed further because I don't have my documents to proceed. And if you want to reach out to DOC, Captain Ortega, it was verified this morning that they don't know where my paperwork is. They're looking to find it. They were unable to come up with it before 10 o'clock this morning.
Mr. Stanley, if you'll let me get a word in. Unfortunately, Mr. Hubert Santos died several years ago.
Well, it's his firm. I take that
okay.
back. Not her.
Uh,
It's his firm.
understood.
I'm sorry.
Understood.
Okay.
But you don't have a right to appointed counsel in a civil case.
No, I'm
And-
going to hire one.
Right. I'm not going to delay the case because of a last minute request for counsel.
So how
So
about
we
my
should-
paperwork? DOC is
Right.
taking my paperwork on Thursday. Where's my document so we can proceed further? The
Right.
court needs to reach out, do a recess then, reach out to DOC to ask for Captain Ortega to produce my documents so we can proceed further today on this trial.
Okay, is that something that can be done this morning?
I don't know. That's your call. I've asked for it this morning, since 7:30 this morning, for them to produce it, and everybody's playing stupid. So now I need to know. They moved me to the East Sector Thursday night in this facility, so I'm in a whole different area, and I need to know where are my documents that were downloaded from my tablet to papers that they have not, again, produced, and which are now missing.
Mm-hmm. Is there a correctional officer there? I'm sure there is.
Absolutely.
All right, thank you, sir.
They want to speak to you. I know they're asking for a correctional officer, so I need you to speak. She's coming, Your Honor.
Okay, all right, thank you, sir.
They want to speak to you. I don't know. He's going to ask you right now. Your Honor, right here.
Good morning. Yeah, I just had a question for you. Mr. Stanley claims that he was moved to the East Sector, I think Thursday, and that he does not have his papers. Do you know anything about that, or is that something that,
I don't know anything about that, sir. That's not my department.
yeah, is there someone around who could provide us some information on that?
I could try to get you a supervisor, but that's
Yeah,
at least that I can do. I don't know. That's not my sector.
Can you verify that I'm in the east sector for the record?
right. I don't know what that means though.
Then,
But
You just got moved from one block to a different block.
Correct.
That's what that
Okay.
means.
right. Is it possible to get his papers so that he could have them today?
Sir, I
This
don't
morning?
know. That's not my department. He would have to write to property. I'm
No.
not sure.
See, this is actually a court hearing where, although
Yeah.
you're not a witness, but we need to go
I can
forward
try.
today.
I can
So
try
can
to
you-
see the, I can
Can
try
you
to
get me
see.
your supervisor?
Of course. Give me
Okay.
1 second. It's gonna be maybe between 5 or 10 minutes, if that's okay.
All right, so that is okay. I understand that. Can we take a recess until you let us know that your supervisor is there?
Of course.
Okay, so Tatum, can we do that?
Absolutely, Your Honor. Court stands in recess.
All right, thank you.
Captain Ortega. They called it.
That's Esquire.
We are now on the record.
Thank you.
Court is back in session. Sorry, Your Honor.
Thank you. Captain Ortega, thank you very much for being here. I did ask you off the record, we'll just repeat it, whether Mr. Stanley has all his personal belongings, including his papers.
I do not.
He has all his personal belongings that he had with him in H to the new unit in P. Yes.
Okay.
Explained it. Now, Your Honor, if I may,
Yes, sir.
from my tablet for 21 days today, that I had stuff sent in from CPT chat, a legal website out in the world, and they sent it into my tablet, and it was downloaded. And it was downloaded so small nobody could read it. And even
Is he talking about Chat GPT?
the captain himself, this is the 21st day now, said that he was not going to have the counselor recopied. He was going to have FOI reprint it to be available for today's date, because it's all case law stating of my constitutional rights being violated. So now we are down to the wire today, and as of today's date, I have not been given my paperwork from FOI through the captain, which I was verified from this captain, which he'll tell you, for 21 days I've endlessly requested for this case flow, all this case log, and there's cases that would support my case today. So I do not have all my stuff, because these are all documents, 60 pages of my documents that have not been provided to me, that I was assured that I would have them for today's trial, so I would be prepared and ready to go.
All right, so Mr. Stanley, all we need to do today is to hear your testimony. You don't need to provide any case law.
I
If you
do,
feel-
because I'm citing that case law to support my claim. I cannot proceed further until I have my documents in my hand to proceed further. The captain will hear today to verify that my documents have never been provided to me for the last 21 days, which I've asked to.
Sir, please don't interrupt. As I said, all we need is your testimony today.
Well, you're not getting it.
Sir, if you would let me finish, I'll try to address your question. If you're going to continue to interrupt, I can't find you in contempt of court. I don't want to do that. I want to go forward with the trial today.
Well, we can't until I have my documents.
Well, let me try to answer your question. We can hear your testimony today. If there are legal issues, I'll give you time to file a brief, and during that time, you can get your cases, okay? So
I'm not proceeding further today, as I told you, because I'm going to be speaking on my behalf today, and I would be supporting it with case law right up to date that would support every violation that you in this defendant has done to me. So therefore, again, my testimony cannot go forward until I have my documents produced and put in my hand, so I can pitch my claim to you as I proceed forward.
right. The Captain Ortega says you have all your.
No, he does not. So why don't you ask him right now if he's produced me my 60 pages of my documents that he said that he was going to give me for the last 21 days. Put him on the oath, or ask him right now, has he produced me these 60 pages? As he has not. He has not given me my documents. So get it on the record very clearly that the captain has not given me my documents to this date of my documents to proceed forward with this trial.
No, he
So
already.
we waited for him, so ask him the question. Did he give me my 60 pages that he was going to give me for the last 21 days.
Mr. Stanley, I can't do anything if you keep interrupting me, but
Okay,
he
so
already,
ask him that question.
I already did. He told me
You
that
did not.
all of,
You asked him, you only asked him about my paperwork. We're asking about my documents that he assured me he was going to produce to me before this trial, and he's going to testify right now under oath that he has not produced these 60 pages of these documents to support my claim.
Mr. Stanley, I've already explained to you that you can testify today as to the facts.
And I chose not to because I would be supporting all my documents.
I can't finish a sentence, Mr. Stanley.
Because why don't you take the boldness out of your head? Listen to me. We cannot proceed further. He's here on the record. Why don't you ask him on the record? Did he give me these 60 pages? It's a yes or no question. You're avoiding that for one reason, because you want to proceed further. We can't if I don't have my documents.
You've already explained to me what the
So
60.
then ask him the question.
Mr. Stanley, I can't do anything if you keep interrupting me. You just continuously interrupt me, one time after another. I can't do anything.
So
I'm
I'd
trying.
like to hear you ask the captain that question then.
I can't do anything if you keep interrupting me, sir.
I'm listening. You got my attention.
Good. I already explained to you that if you need case law, then you can file a brief after the testimony. Okay, so
You're not asking the question. You are avoiding it for the fact that this is an appealable matter on the record that you're violating my civil due process rights. You have the captain here under oath right now on the video, and you're refusing to ask him the question, did he or did he not give me my 60-page document? It's a yes or no. Okay, I'm shutting my mouth. Ask him that question then.
he already explained to me that all of your paperwork, all of your personal papers have been transferred with you. That's all you.
You did not ask. All right, I'm going to ask him.
No, you're not.
Captain Ortega, did
May
you
the captain be excused, Your Honor?
Yes.
Yeah, why
yes.
don't you ask him that? Why don't you ask me? Because you're violating my civil due process rights right now. He did not give me my 60 pages. He told you all he transferred me with the documents I had. The documents that he had, he has not given me back yet.
Just Captain, just to confirm, were all the papers that Mr. Stanley had in his cell? Excuse me, Mr. Stanley, I can't ask it if you keep interrupting.
Well, why don't you ask him the question about him? Did he give me back my 60 pages enlarged? Yes or no? That's not the question you're asking him.
Right. I can't ask a question if you keep interrupting.
Then forget about what he transferred me with my paperwork. Ask him if he supplied me back with my 60 pages.
All right.
That's the question.
I'm not going to ask him because you keep interrupting me.
Because you're avoiding the question. Why don't you stop avoiding the question and you answer the question for me then? Did Captain Ortega give me my 60 pages in large documents that he was going to produce me prior to this trial? Right. Did they follow me to the East Sector? Yes or no?
I will ask a question if you stop interrupting. All right, Captain Ortega, just to confirm for the record, were all the papers in Mr. Stanley's possession in his cell transferred to his new block on or about Thursday?
Yes.
And is that the question?
May he be excused, Your Honor?
Yes. Thank you very much, Captain Ortega.
On the record, Your Honor. Right. So you're going to ask him. I shut my mouth. Ask him. Did he produce my 60 documents back to me that he has?
Thank you very much, Captain Ortega.
You have not answered the question.
Right. All right, yes. Mr. Stanley, would you like to
testify? We're not proceeding further. This hearing is over.
Okay. Stanley has walked out of the proceedings.
Mr. Stanley has not walked out. Mr. Stanley is right here listening to every bullshit answer that you have. You're failing to answer it, ask the question, so we're going to get the transcript, and we're going back to the Judicial Review Council to hold you criminally prosecution of this case.
Yeah.
Your Honor, may I briefly make a quick record?
Yes,
for what? You're going to call the federal court and give them another complaint about what you did of your ex.
I would suggest, Mr. Stanley, I'm speaking.
Mr. Stanley.
You already reached out to the federal court, and now you're being criminally charged. Why don't you bring up that issue?
Mr. Stanley, I want to hear from Mr. Finucane for a minute. Thank you, sir.
For the record, we're ready to go today. We also have another trial date scheduled for Wednesday.
All right.
I would respectfully suggest that perhaps everyone take a minute and we come back Wednesday and we proceed Wednesday. I will note, I have grounds right now to move to dismiss with prejudice and ask for contempt. I would be well within my rights to do that. I
The only
am,
one who's
as an
acceptable, your
officer of the
expert, your
court,
conversation
as
is
an
what you
Mr.
have done
Stanley,
from the
Mr.
beginning.
Stanley, Mr.
As a-
Stanley, you're interrupting. Thank you,
as an
sir.
officer of the court, I'm
You're a liar. That's
doing
what
my
kind of officer
level
you
best.
are. You're full
I'm
of
doing
shit.
my
Mr. Stanley, you're out of order.
I'm doing my level best to try to move this case on the merits to judgment. We're ready. We will be ready Wednesday. If we do not proceed Wednesday, I will be moving for a dismissal with prejudice, meaning the other case from 2024 wouldn't be going forward either
The
if that were to be
other cases that
granted.
have nothing to do with
Mr.
this.
Stanley,
The
Mr.
court
Stanley,
failed to combine them together, so
Mr.
they're not,
Stanley,
they're not
please-
together, so the other
Mr.
case has
Stanley,
no bearing to
Mr.
this
Stanley,
case.
Mr. Stanley, please don't interrupt.
So he's telling you how to
Mr.
run your
Stanley,
courtroom now, Your Honor?
Mr. Stanley, I'm ordering you not to interrupt. Thank you, sir. Mr. Finucane.
And so I'm doing my level best to proceed on the merits. We're frustrated, for the record. We're ready to go today. I have a
You're frustrated,
dentist.
yeah.
I have
All right,
a-
Mr. Stanley, I just gave you a direct order not to interrupt, and you interrupted. So I may well
We
find
already
you.
know how biased you are, so you're gonna do what you want to do anyways. You're more corrupt than the goddamn state attorney with his ex parte conversation reaching out to the federal court, though. But you
Okay.
want to abide by that? First of all, you granted his motion to have this video by video in 4 days without me even objecting to it of his hearsay.
All right, Mr. Stanley, I find you in contempt of court for
That's
calling the
fine.
court.
Shove it up your ass too. How do you like that?
Okay,
All right, you're a bigger piece of shit than he is.
all right, I will get you counsel.
Yeah, whatever.
All right. So we'll have criminal contempt proceedings as soon
Fine,
as
whatever.
possible.
You shove it up your ass too. And we'll have the judicial review counsel there so you can give him your testimony under oath, how you're violating my civil due process rights of even having my expert witnesses appear in court.
Okay.
I would ask for
And-
dismissal with prejudice, Your Honor.
Yeah,
All
and
right.
I ask with prejudice that the state's attorney, for one, the Second Circuit Court has already made a fair ruling that when the Attorney General enters an appearance on their behalf, that their immunity is out the window. All right?
Your Honor,
But you're
Your
not
Honor.
abiding by that.
Your Honor, if I just may,
Mr.
I
Finucane.
think
I
Mr.
need the
Stanley,
court to reach
Mr.
out to
Stanley,
the captain
Mr.
to make it very clear that if
Mr.
we're coming back on Wednesday, that the court needs to make an order to have this captain produce my documents that I need to support my claim.
I would suggest, Your Honor, Mr.
I don't
Stanley
want
has,
none of your suggestions.
Mr.
You're
Stanley-
you're
Mr.
not as a
Stan-
defendant
Mr.
here,
Stanley,
so you have no right to
All right,
suggest
would the
nothing.
clerk turn Mr. Stanley's microphone off?
All right?
Yes, Your Honor.
Thank you, Mr. Finucane.
Your Honor, Mr. Stanley has now been found in criminal contempt and he has the right to remain silent. So what I would suggest is I have now moved on the record for a dismissal with prejudice of this case and their related cases. I have no objection to Mr. Stanley be giving time to brief that if he would like. And that way we don't have to proceed any further because he has the right to not speak any further.
All right, I think I might take your first suggestion in that we will attempt Wednesday to
Understood.
resume the hearing, and would be interested in hearing Mr. Stanley's factual testimony. But I agree that Mr. Stanley has a right or privilege not to incriminate himself, and so I will call the public defender and see if I can get him represented so we can have proceedings on criminal contempt. And I will make my order that he should show cause why he should not be held in contempt at this time. So for this morning, we will stand adjourned and resume with contempt proceedings as soon as possible. Okay?
Thank you.
We'll stand adjourned.
Court
Thank you,
stands
Your
adjourned. Thank you,
Thank you.
Your
And
Honor.
resume Wednesday at 10 a.m.
Thank you, Your Honor.
Thank you.
And guess what today was? Yes, folks.
We're on the record.
Thank you very much. All right, Mr. Stanley, are you okay if we proceed in just 1 minute?
Sure, go ahead.
All right. I will give the judge a call now and we'll be We'll begin in just a few moments. Thank you. The Superior Court for the Hartford Judicial District is now open and in session. The Honorable Carl Schumann presiding. Good morning, Your Honor.
All right. Good morning. Good morning, gentlemen. I see all parties and counsel appearing this morning. So, Mr. Stanley, I'd like to give you another chance to testify this morning. And assuming there are no problems, we could go forward with that. I do have the ability to mute your microphone if you interrupt or make inappropriate comments, but hopefully it won't come to that. So, Mr. Stanley, would you like to testify this morning?
Yes, I'd like to give an opening statement first about addressing Monday's issues that we had I believe I received a paper that said that you vacated that order, but I'm supposed to address that issue this morning before we proceed.
I'll give you a few minutes to address that, but briefly, because I want to go forward with your testimony. Go ahead, sir.
All right, do you want me to?
Yeah.
I'll be sworn in under oath.
For your testimony, I do, but if you wanted to address Monday's order, you don't have to be under oath. I'll give you a minute or two to do that, but I've vacated my ruling and I want to go forward with the trial on the merits.
Okay, Your Honor, first I'd like to start out with, I believe that the judge the other day, that we had the lady judge,
that would be Judge Morgan.
Thank you very much. She failed to address the issues about, I have 3 case laws, State versus, I'm going to spell the last name, OSTROWSKI, that's, 293 Connecticut, 261, 2009, and State versus Barlow, 296 Connecticut, 95, 2010, and State versus, it's MCGANN, 234 Connecticut, 1995. All these cases basically stating very clearly that when the judge is going to be one, there's still another pending grievance against you again with the statewide, with the Judicial Review Council, as we speak about being denied my access to the court for my subpoena witnesses. And I asked for you to recuse yourself for that reason alone. And secondly, I was going to call you as a witness to testify to the fact that, how are you denying my expert witnesses to support my claim of the defendant's misconduct in his, for you to provide me with proper dentures in a timely manner.
He wants to call the judge as a witness in his case.
As Administrator Directory says so. So again, I think that we've been butting heads, and again, very clearly, from what I stated on that case law, and I have case law that was just printed out this morning from it's a website, ChatGPT, and the supremacy clause says very clearly, federal laws and Supreme Court cases apply to state courts, and that's HOWLETT versus Rose, ROSE, 496 U.S. dot 356, 1990. That states really clearly, it is my civil and my constitutional rights, as I've been barking up this tree about, for 1, jury trial, 2, for my right to have under the clemency state that my expert witnesses have a right to testify, as well as my the Brady violation of my discovery, as well as this is a googly violation about the defendants clearly knew of their misconduct, what they were doing, and they proceeded forward now. And here we are, me now with no dentures, 12 and a half years later, barking up this tree, basically disputing with you, Your Honor, about for my constitutional rights to be upheld. So therefore, again, I don't believe that I should be held in contempt for arguing with the court, as in you, your judge, to want respect of my constitutional rights, for 1, discovery, 2, to be brought into court. You took the defendant's word that I threatened him, that's under appeal, within 4 days, not violate my civil due process rights to respond to that. You granted his motion to be on video, but yet though, you never even waited for my motion, which I had 30 days to respond to, which you failed to address, and then you marked my motion off. So therefore, again, if the defendant wanted to be on video, that was fine and dandy. But now I've never consented to this video. How am I've sent you pictures to this court again, Your Honor. I have the broken dentures here that there's no fax machine. There's no possible way that you or a jury, which I should have been entitled to, would review these broken dentures. And let's get one thing straight right here, right now, and I'll sum this up. I'm in jail. I have no access to power tools, as the defendant claims I've caused my own injuries, as his special defense, which his attorney claims, and I'm holding him to penalties of perjury, and therefore everybody will be sworn in. So that will be, no matter if his attorney general was filing on his behalf, who's going to be, we need clarification what I've submitted to the court, who's going to be held accountable for perjury, because the administrative directory clearly says that when you file a grievance, it goes in front of a grievance board. And I'm going to give you documents to support exactly what I'm stating, that he's answering the grievance that's supposed to be in front of a grievance board, that he's basically manipulating and stopping the access of my civil rights, how he got with my grievance application, and he's responded to it, and his signed document name is on it. So therefore, again, all the arguments I've ever asked for you is basically for you to have compassion about. It's been 12 and a half going on 13 years with no dentures. I have a medical report, which I asked to subpoena in an expert witness. A doctor came from Farmington Medical at another jail and said, due to this gross negligence of this defendant's negligence of not giving me dentures, now my top bone is gone. Now there is only one option. I have to now have implants. I'm still talking to you today, learning to re-speak with no dentures. So therefore, again, I'm asking you basically to have a little bit of compassion, to oversee my hostility, where I've just endlessly, you're talking a guy arguing with no teeth for the last 13 years now of gross negligence of this person that is being shielded under DOC, that I've tried to have his his medical license revoked.
All right,
And the only
Mr.
way it's
Mr.
not being
Stanley.
revoked-
Thank you, sir. I gave you a minute. I said
Oh,
a
I
minute.
understand.
You've taken 6, but I've
Absolutely.
heard. Thank you, sir. I believe all of the issues you've mentioned have been ruled upon. So I do want to proceed with the trial, and I assume you want to testify. And so we'll put you under oath. You can testify as to the facts, as to what happened, and then the defendant, through counsel, is allowed to cross-examine you. Okay?
Sure, and just one more thing, either you can have it on the record or not. We have the housekeeping matters that we've never addressed for certain things that, again, I feel that we should take a couple brief moments to address of why I'm being denied my subpoenas, which I believe I'm entitled to a hearing of, why you're denying me my expert witnesses to testify to support my claim of my affidavits.
Well, as to expert witnesses, there have been no expert witness disclosures. As to subpoenas, you filed an application for 30 or more witnesses and said the same thing for each of them. So I couldn't identify any that were particularly important. As I said in the ruling, I denied it without prejudice to reconsideration. So if you identify in your testimony any eyewitnesses to the events that you talk about, I would consider granting your application for a subpoena at that time. So let's proceed with the testimony, and I'll ask you to take the oath and then state the facts as to what happened. Okay?
Okay.
Thank you, sir. Clerk?
Mr. Stanley, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. Please state your name for the record, including the spelling of your last name and the address of the facility you're located in.
That's Stephen, that's Steven, Keith, Keith, Stanley, Stanley, at McDougal Walker Correctional.
Do you mind providing the address if you know it, Mr. Stanley?
Yes, that's 1153 East Street South, Suffield, Connecticut, 06080.
Thank you very much.
All right, thank you, Mr. Stanley. Go ahead and tell us the facts about what happened in your case.
Okay, the facts to my affidavits that I've submitted to this court is basically supporting that my dentures had broke due to the defendant's gross negligence of grinding him down with his power tools in his dental office. So therefore, again, I'm going to address the issue in a minute about his answer of his special defense stating that, one, I caused my own injuries and I had an injunction, and he says it was only a cosmetic issue, which it wasn't. It was a violation of my liberty rights of my medical needs to eat food in a proper manner. One, not just jeopardizing the bone in my mouth. Two, but jeopardizing my intestines about trying to, basically regurgitate food that is not properly chewed like a normal person would have. So therefore, again, we have the dentures and the pictures, which we're going to go over the exhibit. So if I could start really clearly with the exhibit list, so everybody can pull that up and we can address that issue. So we have Exhibit 1, inmates request 1 through 17.
Mr. Stanley, do you want to just tell us the date or dates when this occurred? Give us a time frame.
That would have been way back when I filed this claim, and I believe, what is this? This case started in 2018, so this was around that same date. It's been so long with no dentures and this case pending so long that basically I can't give you the exact date. The documents will speak for themselves, where we have grievances that are dated, and we have other request forms that are all dated that go back from, like, I'm looking at one request, Exhibit 4, it's 10/27/2017. And on, which these exhibits will verify dates, times, and incidents as we may proceed forward.
Go ahead.
So on Administrative Directory 8.4, it clearly says on page 2 and on page 3 that an inmate for dentures for any medical need will be seen basically and resolved within 72 hours as a emergency.
Objection. Mr. Stanley's reading from a document, not
Okay.
an evidence.
All right.
It is an evidence. It's part of my,
No,
it's Exhibit
no,
1
no,
of 1 through 17.
Sir, those are only identification exhibits. They haven't
So
been made
can I
full.
have 1 through 17 marked as a full exhibit for the court?
Let me just remind you that what I want to hear are the facts, not legal arguments.
These are facts, Your Honor.
Okay. All
So
right.
basically,
Your Honor, if I may offer a
Yes,
brief
please.
proposed
Mr.
solution
Finucane.
here. If Mr. Stanley is willing for our exhibits to come in as full
Absolutely not.
exhibits, then we would agree to his coming in as full exhibits. If there is no such agreement, I hope he has a witness to get his documents in.
Your
Okay.
Honor, as I may, and I wanted my subpoenaed witnesses because DOC would have testified to this fact. The defendant's exhibits that he wants to submit are missing clearly the gross negligence from the defendants were on exhibit. If you look at, if we just pull up inmate request, number 1 through 17. So as I'm referring to the Administrative Directory 8.4, that can clearly be brought up at any time, at anywhere, that it's part of the record, and this is basically DOC's rules and laws. So the Administrative Directory 8.7.
Wait a minute, Mr. Stanley. We have there are no exhibits fully admitted in evidence at this point. Mr. Finucane's suggestion is a very reasonable one, because then you won't have any problems with admitting your exhibits. Whereas if he can object, then there are a number of objections that I could foresee. Let me just finish. And this is a court trial, so if something is missing, I can weigh that. You can point that out. I don't have to rely on or credit any exhibit, but just administratively, it makes things a lot easier. So do you want to agree to that?
I do not, because he's missing half the exhibits I've submitted. You have my witness list. You've had my exhibit list for nearly a year. They've had it for over a year, so they know exactly what it contains of. They're only submitting to you a bunch of mumbo jumbo, 30, 40 pages of a dental, this and that. I'm submitting to you certified documents of DOC's policy and rules, even that this defendant has to abide by. So therefore, again, I'm asking for my exhibit entry number 1, inmate request 1 through 17 be marked as a full exhibit, because these are request forms that are signed from this defendant that we're going to get to the point when I cross-examine him, asking him under oath on the record, did he sign, like Exhibit 3, a grievance form, which basically he has no authority to sign on when it's supposed to go in front of a grievance panel. He doesn't have any of these.
Mr. Stanley, you can't argue about these exhibits. They're not in evidence.
That's why I'm asking you. So you're agreeing to enter his evidence, but you won't enter mine? What's wrong with that picture, Your Honor?
Mr. Stanley, I never said that. Please don't.
Okay.
Distort.
Your Honor,
Sir,
I have my exhibit.
Excuse me, Mr. Stanley. What I'm suggesting is that the objections to your exhibits would go away if you accept Mr. Finucane's proposal, which is very reasonable. And I would admit his exhibits, but I don't necessarily credit them. It just means that we don't have evidentiary issues, and then I would decide what weight to put on them.
So why should I accept theirs when they won't accept mine? Their evidence, their exhibits they're submitting is not, they're avoiding and they're disobeying. They basically won't show you the certification document. Your Honor, for one, if you're going to accept theirs, you must accept
Mr. Stanley, no, he said he will accept yours.
Well, I'd like to hear that again, because he wants me to accept his. I don't accept his, because his basically are not proper. It's not addressing the case at hand.
Right, but I can sort that out, but I'll ask Mr. Finucane to state your proposal again, sir.
Yeah, so I have a witness here to lay a foundation and to move my exhibits into evidence if I need to do that. To make things easier, I would be willing to agree to Mr. Stanley's exhibits being admitted as a full exhibit, all of them, if he agrees to ours coming in as a full exhibit, and then I don't have to do that and waste the court's time with the procedural questioning to get my documents into evidence. If Mr. Stanley does not, let me finish. If Mr. Stanley does not want to agree to that, he has every right under the rules to try to lay a foundation to get his documents into evidence if he has a witness that can do that. But I think it's just easier. There's no jury here. If the court thinks the documents are relevant or cumulative or not really on point, you don't have to credit it. You don't have to weigh it. But to avoid the procedural morass of this document, we have to spend 20 minutes laying a foundation to get it into evidence, or Mr. Stanley, I suspect, doesn't have witnesses for some of his exhibits to come into evidence. All that goes away if we both agree to each side's exhibits coming in as full exhibits. But I'm not agreeing to his things coming in if mine aren't coming in. I wouldn't be doing my job.
Your Honor, I've never gotten a witness list from the defendant. So basically, his witnesses are irrelevant because I've got no acknowledgement that there's been any expert witnesses from him. I wanted my expert witnesses to come in. So, basically, this defendant's bosses, and you are denying my subpoenas to testify against him, which they were agreeing to do so under a subpoena.
We're just talking about exhibits here. It's a very reasonable and kind of a standard suggestion in a court trial for both sides to agree that all the exhibits come in. And then, as Mr. Finucane says, it's for me to decide what weight to put on them. I might not put any weight on the defendant's exhibits. I might not put any weight on yours. But we just won't have to deal with evidentiary issues. Otherwise, I think you might have problems. So I think it's actually in your interest to agree to that. So would you agree to that?
Well, the problem I have, Your Honor, my expert witnesses you're denying. So how can I support any of my documents? I can't take your word. My expert witnesses would have testified to support my documents, Your Honor.
Right.
The judge wouldn't allow 30 to 40 random people to come in as expert witnesses? I'm shocked.
Right. Your documents won't come in unless if there are objections and you can't overcome the objections. So it'd be in your interest to agree to have your documents come in and let the defendant's documents come in, and I'll put what weight I think is due on them. So would you agree to that?
Well, first of all, you denied my expert witnesses to come in to support mine. They've never submitted any documents that are certified to come in now to be even credible to this case. So now you want me to basically grant this court my rights to my due process of having my expert witnesses, never mind juries.
All right,
to accept
I
it.
take that answer as a no. you
That
don't
is a
agree.
no.
Okay, thank you, sir. We'll proceed.
So as I may proceed with my documents that basically the administrative directory 8.4 says, and it reads fairly clearly, and you can pull it up online. It doesn't even have to be amended as a full exhibit. You can pull it up online. 8.4 says that emergency of dental for broken dentures will be done within 72 hours. It does not say anywhere in administrative directory that I have to wait 5 years, which I'm going to show in this defendant's own statement that he says I must wait 5 years. The only thing, when we go back to my injunction motion, entered months.
Sir, just tell me about the facts of what happened.
This is a fact. I entered an injunction motion stating this fact. The defendant, the attorney general speaking for the defendant, so this is his sworn testimony under oath, he stated in his documents of his entry.
Mr. Stanley, yes, thank you, sir. I just want to hear the facts as to what happened to you personally. I don't want to hear about legal proceedings because this is your testimony. So it has to be about facts.
And again, this is a fact that the defendant filed a motion to strike my injunction order, stating it was a cosmetic issue and there was no need.
Mr. Stanley, I just want to hear what happened to you.
Okay, Your Honor. The administrative directory says when my dentures are broken due to his gross negligence of grinding them down to make them so thin that they broke eating a peanut butter sandwich, I filed an injunction with the court asking the court to compel, to order them to give me my new dentures or to fix them or replace them. He came back and told me to write property due to the pieces being missing during a shakedown. I have almost every piece but one piece the size of a nickel. But as you will see, they were ground down from a power tool, which I'm in jail, so I have no access, let's get that straight, to power tools. So again, I asked for the court to make for an injunction order, which the court declined because the defendant came back with his motion to strike April 30th, 2018, saying it was a cosmetic issue and there was no need for an injunction order. That is so far from the truth. And he even states that with his special answer that he said that I caused my own injuries. So again, we have broken dentures that were ground down by a power tool, which I've submitted pictures that don't show nothing, which I wanted to be brought in. So now the dentures are so thin, eating a peanut butter sandwich, they broke. The defendant's sworn testimony under oath, penalties of perjury, said I must wait 5 years for new dentures. Well, the administrative directory 10.4 says, I take that back, 8.4 says that you are entitled to a new set of dentures every 5 years. But it says that for any broken dentures, they will be fixed or replaced within 72 hours. So the court took the attorney general's word of penalties of perjury for his defendant, stating that it was a cosmetic issue and I did my own damage. And that's a statement coming through. So then I filed a grievance with the with the grievance panel of DOC. And that would be in exhibits 1 through 17, and that would be exhibit 3. So if you could pull up exhibit 3.
Objection.
Sir, they're not in evidence.
I didn't say they're in, but I'm asking you to pull it up so you can review for yourself, so we can ask the defendant when he comes time, is that his signature on the bottom of a grievance form, which he does not have the authority to sign nor rule on. So we have exhibit 1 through 17, and I'd like the court to look at exhibit 3. That is a grievance form.
I could look at it preliminarily, but it's not in evidence.
And not okay. And then again, until we argue the semantics about it, then I'm going to ask for it to be entered as a full exhibit. So therefore,
Objection. Can we just be clear on the record? Mr. Stanley has offered 7 exhibits. Exhibit 1, just the record's clear. Exhibit 1 has 17 pages. There's no exhibit 17. I just want to make clear. There's exhibits 1 through 7 from Mr. Stanley offered or proposed, and exhibits A as an alpha through I as an igloo from the defendants, but there's no exhibit 17. Regardless, it's not in evidence.
First of all, one through whatever the numbers are the plaintiff, me. Any letters are the defendants. So again, exhibit 1 it says inmate request 1
Objection.
to
It's
17.
reading from a document, not in evidence.
It's not in evidence, sir. You can't rely
Okay.
on it. You can just
So
offer it.
again, I'm asking you to review it before we mark it as an exhibit. So as you see
Objection,
my
no
exhibit list,
foundation.
All right, it's sustained. I have no idea what it is. You need a
Okay.
witness to testify to it.
and again, so are you denying me my expert witnesses to testify of DOC administrative?
Excuse me,
director?
Your Honor. This is the court monitor. I'm afraid I'm experiencing some technical difficulty. May I please have a moment?
Yes. All right, let's
Thank
hope.
you. We can proceed again, Your Honor.
Thank you. All right, Mr. Stanley, no exhibits have been admitted in full, so you have to either try to admit the exhibits or just tell me what happened in
Well,
your own
first of
words.
all, as I've done many trials in the past, until we review them, then I'm asking them to be marked as a full exhibit once the defendant verifies that that's his signature on the bottom or not. So therefore, again, my due process rights, I'm asking you again on my exhibit list, 1 to 17. I'm asking you to pull up page 3 of 1 through 17.
Objection.
Well,
I think
I can do
he
that, but
means
it's not in
exhibit
evidence.
one.
You can't rely on it.
It's not being marked into evidence until I ask the defendant, is that his signature to mark it as
Okay.
a full exhibit? So
Okay.
again, why are you violating my due process rights when I'm trying to support a foundation here, Your Honor? I'm
All right,
asking you to review it. I didn't ask you to enter it yet until they review it and they confirm that's his signature. Then I would move for it to be marked as a full exhibit. So
Okay,
again,
so
we
we'll
have
do
my
that then.
exhibit list 1 through 17. Could the court please review page 3?
There's no purpose in my doing that, sir. It's not in evidence. You can
Okay, can I
perhaps,
mark page 3 as a full exhibit then?
Mr.
I don't-
Finucane?
Is he talking about exhibit 1, which has 17 pages?
I believe so.
I am. If you listen to it and stop interrupting me, I've said exhibit 1 through 17, page 3. How many times I gotta say that? Exhibit 1, page 3, okay? It's a
Yeah, we
grievance.
object. I don't think that is what he thinks it is.
They're all marked 1 through 17. So we're back to exhibit 1, okay? And we're looking at page 3. There's 17 pages, 1 through 17. I'm asking the court to look at page 3. I don't know
Yeah.
why we are
Yeah.
making this. This is going to be an all-day affair if we can't even look at a page that I've submitted as a exhibit months, if not years ago, and now we have an argument about it.
We object, and I would note for the record, my offer still stands of cross agreeing to exhibits, and I will note, I put in one of my exhibits more requests than Mr. Stanley does, including, I think, the document he wants to get in, which is a response from Mr. Cuevas. So if Mr. Stanley wants to reconsider, he's welcome to, but otherwise we object. This is hearsay.
It is
All right,
hearsay.
so again, can I get the court again now without being rudely interrupted? Because this is going to be an all-day affair. And on my exhibits I've entered, my exhibit list, number 1, can I get the court to look at page 3? Because properly we're going through the wrong format, because until I actually have everybody review it and they object or not, then I would ask for it to be entered as an exhibit. So I don't know why you're trying to sabotage my case, because I'm going through the proper format as I've done in criminal trials, and this is the same way I've done it.
Right.
So I'm asking the court to look at exhibit 1, page 3.
Mr. Stanley, I
Objection.
can look. I can look
You
at
can
it, but
object all you want. You can look. I haven't entered it as a full exhibit. There's
Right,
nothing to
but-
object about.
there's no purpose in my looking at it unless it's in evidence. Now,
Until I ask for the defendant, do they have verification that they agree to it? Then I would ask for it to be submitted
All right,
as a full
the-
exhibit. How
the-
can I
the-
enter anything as a full exhibit and if I haven't had them review it yet?
the objection is sustained. Please move on, sir.
So again, to the format of this case, I have a grievance that goes to the grievance panel that only DOC can rule on, not the defendant. The defendant clearly signed a grievance complaint with his name on the bottom, which again, the court is failing to acknowledge exhibit 1, page 3, where the defendant's signature is on the bottom of the document, denying me my right to fix my dentures and denying me of my new dentures, which is a grievance complaint that does not even go in front of him. It goes to a grievance panel. So therefore, again, he's basically fraudulently signing a grievance panel document that he has no access to even acknowledge, because this goes in front of a panel of DOC administrator for a grievance panel. So
Mr.
therefore,
Stanley,
again,
I want to hear what happened to you, okay?
I'm trying to get to that. So as I'm trying to walk you through these documents of him denying me my right to fix my dentures, I filed a grievance to the grievance panel so that I could have them address the issue. I don't know how he got a hold of it, but he fraudulently signed his name on the bottom of the document of a grievance that only goes to a grievance panel. It does not go to the defendant. So therefore, again, how can I have a fair ruling at the grievance panel when the defendant signed his own name on the bottom, denying me my right to new dentures? So
Mr. Stanley,
again,
that document is not in evidence, and I just want to hear about what happened to you.
I'm trying to, Your Honor, I had to go through the process of DOC Administrative Directory. When this defendant denied me my new dentures, of his negligence of breaking my dentures by grinding them down, I had to go through a process. I couldn't just reach out to court. I had to start the process of a inmate request form, and then it's followed up with a grievance form, which I'm showing you, and then it goes through 17 documents of filing paperwork to DOC, which this defendant clearly kept ruling on it, which he has no right to do so because he is a defendant. So how this is like, just to give you a scenario, Your Honor.
No, sir, just tell me what happened to you, okay?
Okay. So again, I'm filing a complaint with the grievance panel. He's ruling on the panel's behalf. That's like him sitting as a judge today in hearing and him denying all this when he's not the judge. The grievance panel was the judge. He fraudulently signed his name on the bottom of a grievance form that I'm asking you to look at, that we would submit into evidence as a full exhibit, where he fraudulently signed his name on the grievance form, where DOC Administrative Directory 8.4 does not give him the right to sign any grievance form that goes in front of a panel, just like we're in front of a panel of a judge. So therefore, again, now we're moving up to where I filed a complaint with this court. I filed an injunction order number 139 on 5/12/2021. The court denies it because the defendant filed a motion to strike on April 30th, 2018, that's stating it's only a cosmetic issue. So under penalties of perjury by his defendant.
Sustain. Mr. Stanley, would you just tell us what happened to you, not about legal matters, but just the facts?
That is the fact. I'm trying to get the court now.
But this is a case about your dentures. The legal.
Correct. So now I'm reaching out to the court now.
Right. So the legal proceedings you could address in a brief after the facts are heard, but the testimony
you want to
is
hear
about
facts, so I'm trying to walk you through this, but I can't really keep getting interrupted. So
No,
again, I try to get the court to intervene by an injunction to order that, look, the DOC Administrative Directory does not give him the right to rule on anything, nor does it give him the right to deny me my right of the 8th Amendment for dentures to be replaced. So therefore, again, by his penalties of perjury, his defendant filed a motion to strike stating it was only a cosmetic issue. I tried to explain that to the court, that I can't eat, that it's upsetting my stomach, that I'm trying to process food that's uneaten. The defendant came back again, stated under oath under penalties of perjury through his attorney that, again, I caused my own negligence of my own, I broke my dentures, and he says on his own answer of special defense, March 8, 2019, that he's leaving it to my proof, leaving me to my proof. And then he states fairly clearly that Mr. Stanley his own negligence, recklessness, intentionally misconduct broke my own dentures. Well, one, this defendant was the only one with power tools sitting in the dentist's office. He's the only one that ground the dentures down because after they were relined. So what they do is they do not fit my bone, Your Honor. Do I have your attention?
Yes, sir.
Okay, so the dentures do not fit my bone. So I send them back to Farmington Medical to have them relined. They come back to this dentist's office again. He has a little strip of paper and you bite down and he pulls it out and it leaves blue chalk on the teeth, which ones are not biting and which ones are. So he starts revamping the relined dentures that were done at Farmington Medical. So which teeth are hitting and which ones aren't. Then I'm explaining to him that they're as big as a block of wood. He says, I can fix that. He turns them upside down on the teeth side, and he starts grinding them out with a Dremel tool to make them thinner. Well, now you can hold them up to the light where you can literally look through them. So he went above and beyond by grinding them down. So he said, oh, they're much better now. They're not going to break. And I said, I think you went too far. He said, no, they're fine. Well, about a week or two went by eating a peanut butter sandwich they broke. So who knows if one piece the size of a nickel got lost in the peanut butter sandwich or what. I immediately go back to dental because the Administrative Directory 8.4 says that they will fix or replace them in 72 hours. He states that I must wait 5 years for it to fix my dentures. The Administrative Directory says very clearly that you are entitled to a new set. Hear me? Very clearly, Your Honor. A new set. That means an additional set every 5 years. It does not mean if you break your dentures, you have to wait 5 years. That means that on the Administrative Directory 8.4, they will fix or replace them in 72 hours. And again, I go through the grievance
Objection. Assumes facts not in evidence.
And again, as this is my story, and I'm telling the story. I'm not entering anything into evidence. I'm telling you my story.
Mr. Stanley, it's my job to rule on objections. The administrative directive, Mr. Finucane, is not in evidence, although that's the type of thing that I might be inclined to take judicial notice of.
I'm going to be asking you to take judicial notice when this is all over, all the exhibits where he fraudulently signed on a grievance form, which he is not part of the grievance panel.
Mr. Stanley, I'm not going to do that. But I might take judicial notice of a rule, like an administrative directive.
So
all right, go ahead, Mr.
All right, so the Administrative Directory says 8.4 that it will fix and replace them within 72 hours. So I tried to do this back to the dentist's office after he broke them under his own gross negligence with his power tools. Remind me now, I'm in jail. I don't have no bolt cutters, no sawzalls. I don't have any access to any power tools. So by his own gross negligence stating that I caused my own negligence and broke these.
And to be clear, he told the dentist that the dentist went too far. He knew. He educated that dentist, and by golly, the dentist just didn't listen to him.
That's irrelevant. It's a joke to this court to even say that. You can clearly see, not by the pictures, but I have my dentures, I can hold up to the screen. You can clearly see that they broke due to his misconduct of grinding them down. I don't have any access to power tools, so there's only one person that has access to power tools in the dentist office with my dentures, and it would be the defendant. So therefore, again, I reach out to the Department of Corrections stating, look, he broke my dentures, he refused to fix them. They said, well, you need to file a grievance. So I go through an administrative directory of filing a grievance, which now that goes in front of a grievance panel. It does not go in front of the defendant. He says his side, I say my side. I get the grievance request back. It's signed by the defendant. Therefore, again, so he intercepted the grievance process, signed his own name on the bottom saying denied when this thing goes to a grievance panel. That's like him signing off on this court order when he's not the court. So therefore, again, his fraudulently, basically his forgery on a document that should be entered as a full exhibit, he fraudulently posed himself as the grievance panel signing off on a document, which he is not. And I repeat, he is not part of the grievance panel. He is the defendant on the plaintiff that when we went to the grievance panel, and he signed the document, and that's his sworn statement on the bottom of it. And even his documents that he submitted to penalties of perjury said, I broke my own dentures, and he says it's a cosmetic issue. So therefore, again, I reached out to the court, asking the court who's going to be held accountable for penalties of perjury. And the court came back and said, the Attorney General is acting on his behalf. So therefore, again, the defendant's being held as penalties of perjury to this court to hold him liable for suits as well as disbarment of his medical procedures for the maximum of 5 years from any state or medical job in the state of Connecticut. So therefore, again, he fraudulently signed the document, which you're not accepting to accept it as an evidence, which it clearly shows his signature on the bottom, which I'm going to be asking him, is that his signed statement on the bottom? And I'm reading from what I see, not entering into evidence. He says that, oh, file a claim with a lost property thing, he's saying on the bottom. And denied says this appeal is denied. And therefore, again, that's his signature on the bottom that he signed when I'm filing a complaint with the grievance panel of DOC for my dentures. So I tried to reach out to the court again to get an injunction order to override all this, to get my dentures so I can at least eat. So now here we are 12 and a half years later. I have another exhibit, which I'd like to enter it as exhibit, but of course the state's going to object. And that would be, to do with my pictures. And I have on the same 1 through 17, I have a doctor's statement of DOC, exhibit 2. And the doctor says clearly, due to this gross negligence of being with no top bone of eating for 12 and a half years, Mr. Stanley's top bone has now deteriorated, where now it's called a palate. So Mr. Stanley has no palate to put a dentures on. So therefore, again, I received new dentures from another jail after I got out of this kangaroo process of this defendant in this jail, where I'm now back at, and he still works here to this day. So therefore, again, they couldn't understand why I was never given dentures, because he keeps saying in all my requests that the state's objecting to enter as full exhibits, that he keeps saying that, yep, you're on the list, but here we are, almost 12 and a half, 13 years later, and until I got to another jail where they couldn't understand it, and they wrote a statement, and they were willing to testify under oath that, look, Mr. Stanley's entitled to their dentures to be fixed within 72 hours. The only thing that the administrative directory says, and even in its own statement with penalties of perjury, that I caused my own negligence, he says that Mr. Stanley caused this damage, and he says I must wait 5 years. The only thing about 5 years is for a new set. That does nothing to do with fixing broken dentures, that he basically caused the broken issue. This is like having a flat tire. He was seen putting the nail in the tire, so he needs to plug that tire to fix it. He is the problem of this case today. He needs to be held accountable to the DOC Administrative Directory, as well as his fraudulently signing a Administrative Directory grievance form on the bottom when he's not even a grievance panel. So therefore, again, a question will be when he takes a stand under oath, which you're denying me my due process civil rights to cross-examine expert witness, stating fairly clearly, is he part of the grievance panel? And basically he is not, which we'll ask him that today on the record. 2, how is he signing a grievance form when he's not part of the grievance panel? And where does he have the authority to deny me saying 5 years to wait for a dentures that he broke to be fixed, when clearly the administrator 8.4 says within 72 hours it will fix or replace them on an emergency medical issue? All these requests endlessly all go back to him saying, oh, it's not a medical issue, no, it's a cosmetic issue, this and that, where we have now with the other pictures that were entered to this court. I bring both dentures, which, excuse me off camera for 1 second, which I'm going to grab the dentures to show you, because I know you can still hear me, but the pictures do not really show the captain came to the unit. No
objection to demonstrative evidence.
Right.
No, I'm not
there's
asking to
nothing in
enter
evidence.
evidence, Your Honor. So again, can I still proceed to tell my story?
Yes, sir.
So I had Captain Stanley, no reference, not related to me. Captain Stanley, same last name, came to the unit and took pictures, which we have in my exhibit list and the state has. So basically, I'm just showing you, Your Honor, what a denture looks like. If I could get your attention to look at the screen. This is the dentures. This would be the top.
Objection, this is a demonstrative exhibit.
Your
It's
Honor,
been
I'm not
disclosed.
answering as an exhibit. I am talking and telling you my story, and I'm just happy to show you what things look like. So as I'm telling my story, you can view what I'm trying to explain to you.
You
So
can't-
can
you
I
can't-
proceed?
No. Let me explain. First of all, occasionally I am not looking at you because I'm taking notes. So that's why I'm looking away, but it's no disrespect. But beyond that is the fact that there are no exhibits fully admitted at this point. Even showing something for demonstration purposes would make it an exhibit, or would require, let me finish, would require it to make an exhibit. This would go a lot easier if you would agree to Mr. Finucane's proposal, but otherwise I don't see a way that, let me just finish. I don't see a way that you could get your exhibits in.
Okay, well, one, I'm on video, which I declined to do so. So there's no fax machine here, and even if there was a fax machine, Me, how would I enter my dentures right here? An item as a full exhibit. If I was in court, I could enter this as a full exhibit. Everybody could review it. I have gloves that you could put on. You could review it for yourself. So therefore, again, my civil due process rights are being violated by being on video because the state opposed objected on number document 175.
Mr. Stanley,
Yep.
if there's an objection, it's my job to rule on it. I've already explained why you're not in court. It was Judge Sheridan's ruling. I gave you an opportunity to address the concerns that Judge Sheridan had, so that you could come into court. It was your decision not to do that. So that's behind us. We're doing this remotely, so you have to establish a foundation for any exhibit that you offer.
Okay. Your Honor,
yes,
so
sir.
as the court said in number, I believe it, I have the document in a minute, that they said that if I requested to the court, which I did in writing, which you marked off my motion off, which requested to be brought in, and I said that I would sit in the courtroom, quiet, respect the court, where they basically had 4 elements that they wanted me to proceed. I put it in writing, submitted it to the court. You yourself, Your Honor, you marked it off. So this has never been addressed because you marked it off, where I requested.
We're beyond testimony at this point.
Right.
So
That's
again,
true, but
as I'm telling my story, you said it's been addressed. It's never been addressed if you marked it off. So therefore, again,
Mr. Stanley, what pleading number is that?
I got a brand new one today. If you bear with me for 1 second.
Right.
If you look at number entry, no, wrong one. Bear with me.
Yep.
Yep. Yeah, I found it, Your Honor. I have an entry right here, and it's 1 through 3 pages, and it shows on well, I'm going to give you the date. It's 7/2/2024, and it's a 1 through 3 page, and it's referring to number 175, and that would be line 2. It says, and it gives me many issues about to be brought. It gives me 4 elements of being brought into court, which I put into writing and submitted to court, and you marked it off. So as it states fairly clearly, to be brought into court.
What motion or order number is that?
Well, first I'm getting to the court's ruling. This is number 175. They sent it to me.
I know what my ruling is. You said you sent some sort of letter that I marked off.
I did. I sent in a motion, and the court always marks them down. Motion C file or motion. They don't title it. So
Right,
therefore,
but
again,
what number or date is it?
well, it's kind of, and if you listen to me, I'm to explain to you. The court marks it down as C file or motions. They don't acknowledge it. So I'm not exactly sure about the entry, but I do have my motion.
What's the date?
I mean, it'd be a lot easier if the court would start marking things as defendant's request to be brought into court instead of just marking it, say, motion C file or motion for order.
Well, I don't have any control over that, but what is the date, sir?
This guy has got some audacity.
I'm trying to find that. If you bear with me for a minute.
All right.
If we were in person, you would be submitted in hand. I have an entry number of 10/4/2024, motion for clarification for the record for 1 under penalties of perjury. Then I have emergency relief. It's titled emergency relief red flag. In the court, I don't know how they marked it, but I see nothing in my printout of emergency relief red flag, and that's dated 10/1. And I have another one, 10/16, a motion notice to show cause. And again, it's just, I don't know, they just mark it down as motion C file or motion. So we have a 9/16 motion to show cause. And I believe I'm reaching out to you before line 1, I'm reaching out to you stating about my rights to a jury trial, wanting to be brought in to acknowledge this court order, what I was trying to do, to be brought in.
Well,
So if you look at it says motion, it says notice to show cause, and in my motion, it's dated 9/16.
Yeah.
So we'll start with that one first.
All right. I just can't find it based on that. I need a docket number, but here's my point, is I never saw a motion in which you satisfied the requirements that I set, which is to renounce prior threats and agree not to make future ones.
I'm holding it right here, Your Honor.
Okay.
My date is 9/16. However, the court filed it. The court didn't file as motion notice to show cause. So who knows how they filed it? Because if they filed it under what it's titled as, I would be able to direct you exactly where it would be. But when the court keeps putting down orders or petition or, they don't even mark it as it's titled. So it's kind of hard to tell you exactly where it would be. And I've been bringing the printout from this morning for an update so I could stay on par. But again, when it's not titled as how I filed it. So who knows how the court filed it? But my date is 9/16. So it'd probably be a week or two after that date, Your Honor. And it's a notice to show cause.
Let me look for it.
For the record, Your Honor, your
Yes.
ruling is at 2:13. I don't know if that helps. But.
Right. I do have that. Mr. Stanley says, and I required him to do 4 things. Renounce prior threats and agree not to make new ones. Ceases to interrupt the court, which you have not done. Ceases to raise issues that have already been decided, which you have not done, and otherwise complies with all court orders. So I would like to see your statement, but it's clear that you have not.
Well, I'm holding it right here. The court should have it. Plus, this also refers to your the court order 185 requesting for a jury trial for permission. And this addresses all the issues. This addresses my permission to the court for a jury trial. This is my permission to be brought in to enter things as a full exhibit.
As I said, you have not complied with my 4 requirements.
Well, I'm holding the document. I'm trying to, but you haven't ruled on it.
But Monday you just continue to interrupt me, and you continue to raise issues that have already been decided. So
how do you say it's been decided if one you granted the defendant's motion to have a video by video? All right. The law says I have 30 days to respond to it. You rule on it in 4 days. So where is that you gave me the right to respond in a proper manner, Your Honor? I'm just trying to go by my civil due process rights not being violated.
Right. I would like to see that document. It was apparently sent out September 16th. Tatum, I don't know if you can identify which one Mr. Stanley's referring to, but
Your Honor, I do see motion 234 that just on observation looks like. Mr. Stanley, can you read the document that I'm referring to, docket 234? There's a number 1. Can you read the first sentence of number 1?
Okay, on mine it says on the top, motion. It says notice to show cause. US.28.U.S.U.S.U.S.C 144, and it says motion to disqualify Judge Carl Schumann, and then it says special facts relied upon to addressing to be brought into this court, the reasons why. So on line 1, do you see that document, ma'am?
Right.
I believe I do. So, Your Honor, the document that he is referring to is motion 234 filed by the court on 9/20 motion C file.
Right. That's a motion to disqualify. That does not appear to be. Go ahead. But
it lays out the elements of all the things in that other motion where I'm requesting to be brought into trial, where I'm entitled to a jury trial. It's my constitutional rights. I cited a case this morning on the record that any federal laws.
All right, sir. Let me take a look at pleading 234. I can do that on my screen.
Your Honor, that was ruled on already too.
I know. Mr. Stanley contends that in that motion, he complied with the 4 requirements I set down. So let me take a look at it and see if that's.
And I will note, Your Honor.
Yeah.
I'm the one who filed the motion in question here.
Right.
I will note your first requirement is an awfully important one, and that has never been complied with.
Yeah.
There's
And
never
I'd
been a
like-
renouncement of threats.
I'd like to note for the record that with a pending grievances or any appeals in the case law, I cited really clearly that you should recuse yourself in a proper manner because of what's been pending with this case of the actions. And the case law I gave you this morning clearly states that any
Right.
federal law applies to a state court to be brought in person, which I cited.
Right. So, Mr.
Okay.
Stanley, I looked at pleading number 234. It does
Sure.
not address the 4 requirements that I set down. And you personally have proceeded to violate at least 2 of them. So, so your request to come into court Judge Sheridan's ruling remains intact. So let's proceed with the remote trial. Can you tell me more facts about what happened? Not legal proceedings, but just factual matters.
Correct. So again, back to administrative directory, the law that DOC abides by, rules, not a law, I correct myself, that this defendant must abide by, and inmates as well. So if I don't abide by these rules in this administrative directory, I'm put in SEG and I'm given sanctions, tickets, and on as it goes. So when we go back to the grievance process of a grievance committee, a grievance committee goes in front of a panel. This defendant cannot be, I repeat, cannot be part of that grievance panel. So he cannot sign on any grievance complaint form that would be a ruling from the grievance panel, which he did. And therefore, again, it's part of one of these, my entering my exhibits, not as a full exhibit, but being entered, that the court doesn't want to acknowledge, nor I'm trying to show by broken pieces that he ground down that I have no access to a power tool. So clearly, you can't say that Mr. Stanley ground these tools down where his defendant said, my gross negligence caused this injury because I have no access to power tools. Let's get one thing straight right here that I don't think anybody's going to object to, that I'm in jail and I have no access to power tools. So that.
I don't know. I've heard of people digging out of prisons with spoons. So I'm sure you could find something. They can make shanks out of toilet paper rolls. Like, I've seen some pretty shady stuff that's done in those jails and prisons. So I don't put it past the prisoner to be able to find a way to file their dentures down. It would not be that hard in the grand scheme of things compared to what they have to manufacture on a daily basis.
That's irrelevant. And I mean, that's a joke to you, Your Honor, but I'm the guy that's been without teeth for nearly 13 years.
I'm not laughing, sir. I'm just indicating that I think I agree with you that no one will object to that statement.
Okay, so again, my dentures being ground down after they were relined by a doctor at Farmington Medical to reline so they will fit my dentures. This defendant had me sit in a chair as he used little strips of like paper, but they have blue like ink on it. And you bite down on them as he pulls them, extracts them from your mouth, and it will show blueness left where, well, actually the blue is where the teeth are contact, and where it doesn't have blue would be the teeth that are basically, you know, they're touching or not touching, and that's his relevance to grind them down. So again, that's to do with the teeth, meeting teeth to teeth. So that's like a tire to the road. That has nothing to do with anything under the hood, as in being taking the dentures, flipping them upside down, and taking a power tool and grinding out where they just relined them, but on the opposite side to compensate because they were so thick. So now he says he's under the notion, and again, we're going to find out how long he was a dentist prior to that, because I feel he was just a rookie because they never fit from day one. And if he did the proper adjustment with having my dentures properly done from the beginning, there was no need for it being a reline. So therefore, having them relined again means that the problem started of whoever did the dentures to begin with to have them basically molded, which would be in his dental chair of him, of his access. So again, when they came back from Farmington Medical, that's where everybody goes for DOC, Farmington Medical out in Farmington, and they have their medical unit. So they relined them. So the top side of them now basically fits the bone better than it did before. Still not right, but better. So now he's adjusting where you bite down on the strips of paper to see where the teeth fit. and which ones need to be ground and whatnot. So yes, I did complain to him that they're as thick as a block of wood because I have a gag reflex by the back of my mouth, which some people do, so it's normal. So therefore, again, by this gag reflex, I'm complaining that they're too fat. So he says, oh, I can fix that. And he takes them from me again, grinds them down on the underneath where the teeth side are, not the teeth itself, but to compensate where they're then realigned. So they're thick. So now he grinds them down. So now they're broken, Your Honor. So now I go back to him again about the 72 hours to fix or replace them. I'm sitting in his chair. So now he cuts them in half with a die grinder. So all I have is the front piece to chew on, which means, I don't know if you know it or not, Your Honor, and I'm not saying you have dentures or not, but dentures are held in by suction, which is vacuum. So if you don't have the whole top of your mouth, this is the palate to hold them in, they fall out. So if you just have a front piece that goes over the front part of your mouth, like a kid's wax tooth that just snaps in the front to give you fangs, clearly when you bite something, they're just going to fall out because they're held in by vacuum as well as denture cream or denture glue. So therefore, again, cutting him in half was another joke of his negligence and his incompetence of being a medical director or whatever he claims he is. So therefore, again, so now he states to the court when I try to do an injunction because it doesn't work out at DOC process. So now we're at the court level, and I says, look, I need an injunction. I can't eat. I have heartburn now. I have an ulcer to begin with. I need new dentures. He comes back, his attorney general, speaking as penalties of perjury, under oath now, because he's an officer of the court, says that it's a cosmetic issue of his motion to strike. And then he says in his answer for his special answer that he says that Mr. Stanley caused his own injuries and that he leaves it to my burden to prove this. So one, I'm proving to the court that one, I am proving to the court that he broke them because I have no access to power tools. In my other exhibits, it would be exhibit 2 on that same one of 1 through 17. When you get to the package of exhibit 2, and it's the very first page. And I have a doctor they brought a doctor. Do I have your attention, Your Honor?
Yes,
They brought a doctor.
I'm taking
I know
notes.
you're writing. I know, I agree with it. I know that you don't have to be looking at me. So I'm being transferred now from DOC McDougal, and I'm being brought to Radowski because my level dropped. That's down by the casinos down in New London County. So I'm complaining to the dentists down there. This is before I get my new dentures. Here we are years later now. So I believe we're up to the year like 2020. And they could not believe it. So they said, well, we're not even going to touch you. We're going to have a specialist come from Farmington Medical. The specialist comes from Farmington Medical, and I'm not going to read it because you're going to say it's not as a full exhibit, but they bring a expert witness, which would have been my expert witness. Which
Objection, hearsay.
Right, you
okay,
can't
and again,
say-
it's hearsay. So I'm bringing a Farmington Medical examiner, a doctor that overrides this person, this defendant's ability because he is basically his boss. They bring his boss. I have a sworn statement now in those exhibits that he says, due to the gross negligence
Objection,
of,
hearsay.
and
Right,
again,
sustained,
it's a
sustained.
sworn statement, so it's a sworn statement. And the law says if it's notarized, it can be repeated to the turn of time, that there doesn't have to be any person present like a police report because it's notarized, so I can repeat it to the end of time. I have a notarized
Objection,
document from
All
a
right,
doctor.
sustained, sir.
And again, I'm stating the fact. I have a notarized document from a doctor that says, due to my dentures not
Sir,
being able,
Objection, hearsay.
Sir, I sustain the objection. You can't read it. It's not an exhibit.
and I'm not reading it. I'm moving on now. I'm past that.
Good,
So I'm
good.
not going down to him grinding it down. He said, now that this doctor
Well, you
telling
can't
me,
say what he
Objection,
said.
hearsay.
You can't say what
I
someone
have
said out of
first-hand
court.
knowledge, Your Honor. If I have first-hand knowledge, and I have a notarized paper that I'm holding in my hand, it's not considered hearsay, Your Honor.
It is.
So there,
Well,
okay.
That
so
is
again,
hearsay.
let me
The
get one thing
definition of
straight.
hearsay.
In their criminal court of law, if you shoot somebody, and this has been testified in my criminal case, if you don't
Sure.
have a sworn document, then it's considered hearsay. The author of the report has to be present, which I agree with you. But if you have a notarized paper, the Supreme Court and the Second Circuit Court has already confirmed that that document can be repeated to the turn of time. It's not
Sure.
considered hearsay.
I don't know anything about this document. There's been no foundation.
Okay.
It appears to be an out-of-court statement offered for the truth of the matter. It sounds like hearsay to me. So
Well, and
sustain.
again,
Please move
because-
on, sir.
And again,
Please move
okay, so because you're denying me my civil due process rights to bring in this expert witness, as I laid down a foundation showing you that it wouldn't be hearsay because he would be sitting in a court of law stating exactly what he certified in the document, that due to me having
No
no top
experts ever
dentures.
been disclosed.
Sir, you can't say what someone else would say or did say.
Well, I'm
Just tell
telling
us.
you what you told me. You said you're
Right.
denying me my expert witnesses to testify under oath what they said in a certified document.
Sir, that's not exactly what I told you.
Okay.
And
So are
we've
you
already,
denying me?
sir, you're
Go
interrupting.
ahead.
We've already ruled on expert witnesses. You've not made any
You've never ruled on
disclosures.
it because you never gave me a foundation why you denied my expert witnesses.
Sir,
because
I've told you several times, there never have been any expert disclosures. So, you're not entitled to call experts. So let's move on. Just tell us what happened to you.
So again, I'm sitting in the dentist chair now at Radowski. The doctors basically are refusing to even put their hands in my mouth. They said, we're not even going to address this. We're calling in a specialist. So the DOC directory 8.4 in their own report, that's not hearsay, which you can obtain through DOC if we subpoena them to court to testify on my behalf, that they said the doctor's basically telling me that due to you have no top bone, there's no place for top dentures to fit on your thing. So it'd be irrelevant to even proceed any further. So I file an offer to the state's attorney in this complaint, an offer way back in the day. Look, just give me my new dentures and we don't have to proceed further as we go. Well, now we're at the point now, due to his gross negligence of not having no top dentures, because he said I had to wait 5 years and it was way over. We've actually gone over 10 years before they actually gave me the dentures. Now there's no top bone left. So due to his gross negligence, grinding down and sabotaging my first set of dentures that he did with a power tool, and that I have firsthand now witnesses seeing him grinding them down, that is not hearsay because he did it while I was sitting there and I watched him what he did. Therefore, again, cost me my dentures to break, and they refuse to replace them because this defendant says in his own document that I have to wait 5 years. And he said that in a court of law under penalties of perjury of their motion to strike, that it was a cosmetic issue. So under penalties of perjury, under his own attorney general's behalf, which is penalties of perjury because he's speaking for the defendant, his motion to strike, page 1 says DOC Department of
Objection.
Corrections.
This is not
Sir,
about
That has been
speeding.
entered as a
Sir,
exhibit.
there's an objection. It's my obligation to rule on objections. This case is not about, the trial is not about legal pleadings. It's about what facts and what happened to you. So just tell us what happened to you.
So again, I reached back to DOC again, and as they declined to do anything about it, and I did the grievance panel process with the grievance panel, and the grievance panel never ruled on it because this defendant signed the document of the grievance panel. And so therefore, again, I reach out now back to the court, and the attorney general, under penalties of perjury, telling my story, files a motion to strike April 30th, 2018.
Objection,
On page 1
relevance.
says it's a
All right,
cosmetic
sir, there's an objection. It's my obligation to rule on it. I can look
It
at,
was already ruled on, Your Honor.
right,
that
right,
motion to
and
strike was
I
granted
believe
by
I
injunction.
sustained it, so that
did
means you can't go into it.
You did
But-
it. First of all, the judge already denied my injunction order. That's why I'm walking you through it baby steps. So that
Right.
order was already denied. So that was a court ruling. So I can refer to that because the document
Right.
that the defendant. under
Mr.
penalty-
Stanley, just tell us the facts as to what happened to you and your dentures.
Well, so far, because of his gross negligence, I reached out to the court and I filed an injunction order. And under penalties of perjury, the defendant filed a motion to strike document April 30th, 2018, which the court ruled on and granted it. And he says on his front document that was ruled on.
Objection,
And this
objection.
court-
Well, the objection would
How
be
dare you
irrelevant.
object when it's already been ruled on?
No,
Your
no,
Honor?
first of all, he's mischaracterizing the docket. I also don't know how any of this is relevant. We will stipulate that the docket entries say what the docket entries say, and the court can take judicial notice of that. But I don't know what any of this has to do with the facts and his testimony.
So, Your
Mr.
Honor.
Stanley, Mr. Stanley.
Yep, I hear you. You don't have to say
Mr.
any more.
Stanley,
I'd like the
Mr.
court to
Stanley,
pull up.
Mr. Stanley, excuse me, sir.
Yes, sir.
I can look at pleadings. I'm interested in what happened to you and your dentures, not what pleadings the other side filed. After the,
Right.
just a second, sir. After all the facts are heard, then you can file a brief and you can argue that they've made admissions or concessions or whatever you want to argue. But now I want to hear the facts about what happened to you and your dentures. Okay.
So before I can go,
just let me finish one more statement that
Certainly.
I have sustained the objection. I've ruled on it. That means you can't go into what they said in a motion to strike.
well, that's where I go back. I'm trying to walk you through this baby steps because then I go back to DOC to get dentures. So
Okay.
I reach out. So as I've been declined from DOC because the defendant signed off on a grievance form that he has no authority to. So I go back to the court for an injunction. They file a motion to strike, and on their page 1 says that they told the court it's a cosmetic issue. So the court rules against me of my objection.
All right,
Just get to
here's
keep
what
asking it.
here's what I'm going to do. I mean, the statement of a defendant would be an admission, but I realize the objection is also relevance. Probably
Your Honor,
is.
Your Honor, there's
Yes,
also a
Mr. Finucane.
mischaracterization here. Just to be clear, there was a TRO filed by Mr. Stanley. It's at 102. There was an objection filed by us, and there was a there was an oral argument on the TRO and Judge McQuasher ruled on the oral argument and the motion at 102.86. There was then a separate motion to strike at 105 that Judge Budzig denied. So to the extent we need to get into procedural posture from years ago on a motion that is long past operative, I guess, fine, but we need to get it correct. We can't mischaracterize a motion to strike as a opt to TRO, but none of this has anything to, if Mr. Stanley wants to make arguments about these things,
Right.
He has closing argument brief to do that. We only have a little bit of time here, and we're trying to get a lot of evidence in.
Your Honor, we're under the penalties of perjury.
Mr. Stanley, it's my obligation to rule on objections. If there are statements in legal pleadings that you think are important, I'm going to give you an opportunity to brief them. What I'm trying to find out are the facts of what happened to you and your dentures. So just tell us about what happened to you, not what.
So if I can stop being rudely interrupted. So I reached out to the court.
Well, sir, they're entitled to make objections, and I've sustained
Absolutely.
them, which means excuse me, sir, which means that
Certainly.
there's some merit to what they're saying.
So,
Go ahead.
okay, so basically, under penalties of perjury, their defendant said it was a cosmetic issue to the court. So under penalties of perjury, lying under oath to the court, saying it was a cosmetic issue.
Right, Mr. Stanley, sustained. What I'm trying to find out is what happened to you and your dentures. If they made a misstatement in their pleadings, I mean, it might be.
Well, that's penalties of perjury, and I'm trying
Right.
to hold this court accountable
Right.
to
But-
their lying, because now it costs, Your Honor, I'm asking you for a little compassion to bear with me for another 30 seconds to be where we're back to DOC. I'm trying to
Okay.
walk you through the elements of how this case came about, because
Right,
under
just-
penalties
just
of perjury,
Tell
Okay.
us what happened to you, sir.
I am telling you. So I've tried to. I reached out to DOC to have them give me new dentures. The
Right.
defendant on a grievance panel he basically signed off on their documents, so I never go in front of a grievance panel. So I'm now at Radowski. I filed a complaint again to the doctors, to the administrative directory. They bring a specialist from Farmington Medical to review me.
Right.
Therefore, again, the defendant in 2018 files a motion strike saying it was a
Objection.
Hey,
I know he's going to say it was a cosmetic issue.
right, but I'm trying to
I'll tell you
explain,
what.
now I have
Excuse me,
doctor-
sir. It's my obligation to rule on objections. You know
Okay.
what? I'm gonna let his testimony stand that it's a cosmetic, that the defendant said it's a cosmetic issue.
Okay.
And
So under
just
penalty-
second, sir, I'm ruling on objections. It's my obligation to rule on objections. And I'll attach what weight I think is due to it. I mean, it would be an admission of the defendant. I don't know whether the defendant said it. I don't know if it's relevant. Those are things that I'll have to assess in deciding the case. But just in an effort to move on, I'll allow that portion of Mr. Stanley's testimony. Mr. Stanley, you may continue, but tell us what happened to you, not about the legal pleadings. This is not a summary judgment motion. It's a trial on facts.
So, yes, I can understand how it sucks. I get your point, and I know you've got empathy for him, you know, because you understand. I watched my mom struggle with her dentures for years. I've known a lot of people who've had struggles with dentures. But here's the thing. It's not a medical emergency for the dentures. You're not going to die without them. And that is kind of the whole argument. You have a certain time frame you get new dentures at. If you break them because of your own negligence, then you don't get them replaced. They're expensive. And they are kind of a luxury. Look at how many people just have to suffer with bad teeth who are not in prison.
Correct. So the fact was he lied to the court under penalties of perjury, saying it was a cosmetic issue when it was not a cosmetic issue.
All right.
This was a fact of my medical issues. I'm asking for dentures. So now we're back to Radowski. 45 days being there, they closed the facility. I'm now being transferred to Carl Robson. Here we are now, 2016, 17, 18, 19, 20, 21, 22, nearly 6 years later, about, give or take a year or two. At Carl Robinson Medical cannot believe I've gone over this long with no dentures. So they try to accommodate me with new dentures. They make me do dentures, but the problem now stands. There is no top palate, which means there's no top bone. That's not hearsay. That's me holding my mouth and opening it, showing this court there is no top bone left for any dentures to sit on. So therefore, again, if this was addressed 12 and a half years ago, gave me new dentures, we wouldn't be here today. And I wouldn't be now asking for $100,000 of punitive damages, as well as him being disbarred and asking for now I have to go through a medical procedure of plastic being built up on the bone to give me implants, because now I have no bone left to ever chew again. So basically he caused me my right to have basically unable to chew. I've had an ulcer now. I have a medical report that verifies I have an ulcer due to eating and swallowing food that's not properly chewed, because how are you going to chew food on gums? I am speaking for myself.
All right, Mr. Stanley. Go ahead, Mr. Finucci.
He's not competent to testify as to medical causation.
Okay,
he can testify
myself, I cannot,
but not causation.
Mr. Stanley. Mr. Stanley, it's my obligation to rule on objections. Just tell us what happened to you.
Okay, so me sitting in front of you, my own words, I have no teeth in my mouth. So the only way I can chew food is by my gums. It's either that or swallow food whole. So therefore, again, if you get my medical records, which I will sign a waiver, I believe I already did, that will show I have an ulcer now due to this medical issue of swallowing solid foods, not being properly chewed, because I'm eating food on my gums because I didn't have dentures for nearly over 10 years, and now there's no bone left to put my brand new dentures that I have right in front of me today that will not stay in my mouth, and I can put them in to show you that they literally fall out even with glue. So therefore, again, if the defendant is unable to take the stand today to be cross-examined, I am asking you to grant me my right of my due process civil rights to bring in my expert witness to verify exactly what I've been telling you today of my statement of me being without dentures for 12 and a half years, Nobody chooses in their life to go around the world for a cosmetic issue alone. I'm going to smile with no teeth. Are you out of your mind? For you to even say it's a cosmetic issue when I'm unable to eat was unacceptable and irrelevant for anybody that's a medical doctor to even say that. And my own needs of having dentures, needing them to eat food because of my medical problem with my liver and my intestines now, my esophagus, and I have a problem because swallowing food whole or still being unable to eat it, right? The state might tell you, oh, well, DOC could grind my food up in a blender. Who the hell, and I'm going to tell you, would want to eat food in a friggin' blender, okay? You want to taste your food. Food is to be able to enjoy as you're eating it. And as you're eating an apple or an orange, it basically brings a smile to your face. When you're unable to even eat a potato chip because it's cutting your gums and the salt and vinegar is making you scream because it's like putting salt in a wound now because of eating food without dentures, this is irrelevant. So here we are 12 and a half years later. My own medical report is myself telling you that I still now cannot even eat food. I cannot eat food because I have no dentures to put in my mouth to this day because there's no bone in my mouth to put them on. So therefore, again, if the defendant is ready to be cross-examined, if not, I'm asking for one, my civil due process right to bring in my expert witness to verify this doctor's statement of this gross negligence and DOC's administrative directory, which they would come in to testify that it's DOC's administrative directory, which it says on page 2 and 3, 72 hours they will fix and replace. And him saying 5 years to wait for them is irrelevant.
Okay. I think you've stated the facts. There's not time for arguments, but I think you've stated all the facts. So if there are no more facts, then I would turn it over for cross-examination. If there are a few more facts that you wanted to add as to what happened to you,
No, I basically you have that, plus you have the complaint. But I think if you're compassionate enough to see, with me smiling, no dentures and no teeth, well, you can move on for cross-examination if we please.
Okay. It's just about time for our morning recess. So why don't we take a 15-minute recess, try to resume at 11:45. Okay?
Thank you. Thank you, Your Honor.
Thank you.
Court stands in recess.
Okay, we are on the record now.
Thank you.
All right.
Court is back in session.
Continuation of trial of Stanley versus Cuevas. Mr. Finucane, cross-examination.
Yes, Your Honor. Before I begin cross-examination, I just did want to update Mr. Stanley and the court. I've thought about Your Honor's point about the administrative directive, and because courts routinely and regularly take judicial notice of things such as administrative directives and government policies, we would have no objection to Plaintiff's Exhibit 3 coming in as a full exhibit, with one limitation essentially, which is to the extent there's any handwriting on it. We do not agree that that's part of the original directive. I assume Mr. Stanley did that. I can address that in cross, but we would agree to Plaintiff's Exhibit 3 and Plaintiff's Exhibit 3 only coming in as a full exhibit. I think Your Honor certainly can take judicial notice of it, and I do think it falls within the scope of relevance. Okay. And because of that, I mean, it's up to Your Honor, but I would, if Mr. Stanley did have any other things he wanted to testify into direct about it as a courtesy, I would have no objection to him reopening his direct for that limited purpose, or I can just continue with cross.
All right, that's good of you. Plaintiff's Exhibit 3 is admitted in full, unless there's any plaintiff's handwriting on it, or in which I would ignore. But I'll let the plaintiff testify on redirect if there's anything he wants to add concerning Exhibit 3. But right now, we'll proceed to cross-examination of the plaintiff by the defendant.
Thank you, Your Honor. Mr. Stanley, you realize you're still under oath, correct?
Absolutely. And yourself?
Sir, this is not an opportunity for you to ask me questions. I'm just asking if you understand you're still under oath, yes?
And I do. And for the
okay.
record,
Now, I want to be clear. This case, you have filed a complaint regarding your dentures, yes?
I did.
And in the short version is essentially you maintain that Dr. Cuevas did something improper with your dentures and they broke, right?
And they were what?
And they broke, right?
Absolutely, yes.
And then you also claim that after they broke, he somehow did something improper in essentially failing to get you new dentures as in a timely manner, for lack of a better phrase. Is that correct?
He made a statement denying me my civil rights, yes.
Is there, other than him allegedly doing something that caused your dentures to break and then allegedly thereafter not getting you new dentures fast enough, is there anything else that you maintain, that you actually claim in a civil action in court, Dr. Cuevas did wrong in this case, or are those the only two things?
Basically, just I want to cross-examine him about his statements under penalties of perjury of documents that you had submitted on his behalf. But that is
That's not an answer to my question. My question is, besides allegedly doing something that caused your dentures to break and allegedly failing to get you new dentures thereafter quickly enough, is there anything else specifically that you claim Dr. Cuevas did wrong as it pertains to this case? Or are those the only two things?
No, there's the grievance committee where he signed off on a grievance form where he's not a part of the grievance panel to jeopardize my right to bring this up to administrative directory to resolve this problem. So he fraudulently signed his name to a document that he has no authorization to do so.
Is there anything else besides that and the other two things I've already mentioned that you claim he did wrong in this case?
I believe that those would be the main three elements of this case, yes.
Okay, and you said they're the main three elements. Is there anything else you claim he did wrong in this case?
Besides anything to do with relevance of the dentures or denying me my civil rights to the administrative directory to fix or replace those. Those are basically the claims in the basic of the case, yes.
Now we've, I think, established now that one of your parts of your case is that you claim Dr. Cuevas did something to your dentures that caused them to break. We've established that's part of your claim, right?
Yes, that is the statement, yes.
Which denture did he supposedly do something and that then broke? Was it the upper denture? Was it the lower denture? Was it both? Was it neither?
You have they call it I forget how the crown, and everybody thinks a different way, but let's just state these for lower dentures and top dentures. So he altered the top dentures only, nothing to do with the bottoms. The bottom
and which one? Okay, so you claim he altered the top denture, yes?
Yes, nothing to do. The bottom isn't important. It's a part.
And which one is the one that broke? The top denture?
It's the top dentures.
And okay, and as far as him supposedly not getting you a new denture after, that's also the top denture?
That is correct, yes.
Okay. So the judge really doesn't need to be worrying about the lower denture as far as your claims. Would you agree with that?
That is 100% accurate, yes.
Okay. Now, what's your highest level of education completed, sir?
I'm going to object to that. That has no relevance to this case at hand. And basically, that's irrelevant to the case. So therefore, again, it's like, how many cases have you tried?
All right, it's overruled a witness's background and education is permissible testimony. Go ahead, Mr. Stanley, if you'd answer that.
Yes, I completed 8th grade, Your Honor.
Okay.
And any formal education completed after the 8th grade?
Nothing at all.
I'm sorry, I didn't hear you.
Nothing. I've only completed 8th grade level in school.
Okay. Now, given that testimony, you would agree with me that you have never been to dental school then, correct?
Well, you can't say that because I have. Basically, the doctor from Farmington Medical, when I was just brought into Farmington Medical nearly a month and a half.
You've never been to dental school, correct? You've never enrolled in a dental school,
I was not
right?
involved, but I did obtain, I did.
And you're not a dentist, correct?
I did participate in a dentures class. Yes, I did. From to medical about 2 months ago.
When you say a dentures class, is that some sort of education for patients about their dentures?
Yes, a licensed dental.
Okay.
A licensed dental doctor basically walked me through the whole elements of to do with this case at hand and about my bone being deteriorated.
It's not about, I'm not asking what you did. I'm asking if you've enrolled and if you've completed. Have you ever been in a dental school and obtained a degree in dental medicine? Yes or no?
No. And for
okay. And you would agree with me, you're not a dentist, correct?
Have you either for the record?
Sir, that's not an appropriate thing to say in trial. You don't get to ask me questions. You're not a dentist, correct? You're not you don't have a degree in dental medicine?
Than you are.
Yes or no, are you a dentist?
I am no more a dentist than you are.
That's not an answer, sir. Answer my question. Are you a dentist, yes or no?
That is my answer. I'm no more a dentist than you are.
Your Honor, I would ask for Your Honor to direct him to answer my question. It's a pretty basic yes or no question.
So if let me explain. If counsel asks for a yes or no answer, your answers can only be yes, no, or I can't answer it yes or no. Those are your three choices. That's the way I do it.
Okay, I cannot answer that at this time.
Okay.
Okay. You've never practiced dental medicine on another human being, correct?
I can't answer that at this time.
You think it's possible that you would forget doing that?
I can't answer that at this time.
Okay. When you graduated the 8th grade, your highest level of education, they didn't give you a degree in dental medicine, correct?
I do not recall.
Do you think it's possible? It's certainly not possible.
I cannot recall. That was over 50 years ago.
Okay. Now, you have mentioned in your direct, I believe, about dentures at another jail, I think you said. And I just want to make sure the record's clear of what we do or do not agree on. Do you agree that you have received dentures since filing this lawsuit?
Not proper dentures because there is no dentures to be made to fit a top mouth that has no top palate.
My question is not whether you believe dentures you may have received were proper. My question is, do you agree that you have received dentures since filing this lawsuit in 2018? Yes or no?
I have.
Okay, and where did you receive those dentures? What facility were you at when you received them?
In the year 2022, Carl Robinson, nearly 8 years after this complaint went in.
And were you also fit for dentures while you were at Corrigan-Redgowski?
I was not. They refused.
You were not.
They refused to touch me in any manner. They said they were not getting me involved in this case.
Okay, and as you sit here today, are you wearing your dentures?
I cannot. They're unable to fit because there is no top bone in my mouth, and my medical report states that really clearly. And I would sign a waiver if you need to extract that document.
So you're not wearing them?
I am unable to wear dentures at this time due to no top bone.
And also, you filed this lawsuit from McDougal, right?
I filed this immediately when the defendant refused to properly give me.
It's not my question, sir. What facility, I'm asking, were you in when you filed this? You filed this lawsuit from the McDougal prison, correct?
Correct. Exactly where the incident happened.
And at some point, I'm not going to hold you to a date, but at some point you then transferred to Corrigan-Redgowski, correct?
I did, as my level dropped.
And then you transferred from Corrigan-Redgowski to, was it Robinson?
It was.
And then from Robinson, you've since transferred back to McDougal where you are now?
No.
Where did you go after Robinson?
Went from Robinson to Osborne, and from Osborne back to Robinson, and from Robinson now back to McDougal.
Okay, and that's where you are now?
I am.
Okay. Have you ever worked in the kitchen at McDougal?
Off and on over 10 years.
Understood. And in the kitchen, you sometimes work preparing food, I imagine, for the other inmates or similar jobs?
No, I was basically a utility worker. So
Okay, and do you work in the actual kitchen itself?
100%, yes.
Okay, and there certainly are tools of some kind in the kitchen, right?
Each person that has the tools, they have to be signed out directly to that person.
Not my question, sir. Are there kitchens are there tools in the kitchen? Yes or no?
Yes, and I'd like to clarify.
Okay, thank you, sir. Now, sir,
Mr. Stanley, so if he asks a yes or no question, if at the end of his question, it's yes or no, your three answers are yes, no, or I can't answer it yes or no.
Okay, well, at this time, I cannot answer that because you're not giving me a fair opportunity to explain to the court that each tool is chained to a table.
Objection.
All right, sir, Mr. Stanley, you'll have a redirect in which you can explain
Absolutely.
things. Okay.
And for the record, he did answer my question, yes, Your Honor. Also, you have mentioned in your direct testimony today writings that you have written and presumably submitted to officials in the Department of Corrections concerning your dentures. Would you agree with that? You've mentioned that?
Endlessly that your defendant keeps,
Sir, it's a yes or no question.
I cannot
that actually, Mr. Finucane, was not clear because when you asked it at first, it didn't end with a yes or no. That's the rule I have. So
you
just
can continue. I'm
clarify.
fine with it. Sure. You can continue, sir. Continue your answer.
Excuse me?
Go ahead,
you can
Mr.
continue
Stanley.
your answer, sir.
Repeat the question, please.
You agree that you have testified on direct about submitting your own writings about your dentures to Department of Correction officials, yes?
I cannot answer that faithfully at this time because they were deferred.
Have you submitted?
They were intercepted.
Have you submitted or attempted to submit writings of your own to Department of Correction officials concerning your dentures?
I did, but they keep getting intercepted.
But you would agree that you've attempted to submit writings of your own concerning your dentures, right?
Endlessly, which they keep getting intercepted.
And would you also agree with me that when you attempted to file or submit those writings concerning your dentures, that was at least in part in attempts to obtain medical care of some kind or medical attention, yes?
At all times, correct.
Okay. You have also had the opportunity to review the defendant's proposed Exhibit C, currently marked for identification, right?
I don't believe I've ever received any of the defendant's exhibits.
Well, we sent them to you over months ago, and at the trial management conference, you have not claimed of not receiving them. So
you never stated on the record that you sent them either. So I don't understand what documents you're referring to.
Well, if I told you Defendant's Exhibit C contains approximately 35 pages of your own handwritten statements concerning medical care, would you agree that you've submitted at least 35 pages worth of written statements concerning your medical care?
I cannot answer that faithfully unless I see those documents.
Madam Clerk, can we show the witness proposed Exhibit C?
Yes, please hold one moment.
And for the record, what address did you send them to? Because on your last document of the same case.
There's no question pending, sir.
I'm asking you what address you sent them to.
You're not allowed to.
Right. It's
Madam Clerk, can you tell me the address that the documents were sent to?
Please hold 1 second, Mr.
For certification purposes?
I apologize. I just want to confirm. Can everybody see Exhibit C?
I can.
Okay, thank you. Attorney Finucane, is there a particular page that you're looking for?
I'm actually just going to go through each page one at a time and ask him if he recognizes his writing. So for the record, sir, we're showing you the second page of proposed Exhibit C. It has an exhibit sticker C on it. The first page is a cover page. Is that your handwriting, sir?
I'm going to object to these because these are not entered as exhibits, as full exhibits, so it's irrelevant of everything.
It's overruled. They have not been offered yet as full exhibits.
And again, as I referred to my exhibits, the same format, you denied to even me referring to them. So I cannot answer to any of these.
Sir, I've ruled on your objection. It's overruled. They've not been offered as exhibits.
Well, I've never seen this document before.
You've never seen this document?
Well, from you, as in you submitting it to me, I've never.
That's not my question. Do you recognize your handwriting on this document?
My handwriting?
Did you write part of this document?
I don't see my signature on that document, so I don't know what you're referring to about my signature. Where is my signature on that document?
I'm not asking for your signature. I'm asking, do you recognize your handwriting on this document?
I would have to say I can't clearly recognize this document, and I'd like for the court to take judicial notice on document number HHD-CD 24. 508.
Your Honor, this is not a filibuster.
Mr. Stanley.
I'd like to state my foundation for the objection.
Well, your objection is overruled. It hasn't been offered as an exhibit yet. You may proceed.
So I'm objecting to this question, and I'd like to offer my objection for the record for the court to take.
And I've overruled it because counsel is entitled to ask foundation questions. Proceed.
Correct.
Mr.
I have the right for an objection.
Mr. Stanley, I rule. I hear the objection. I hear a response. I rule. Then we move on. You haven't heard my
response because I haven't told you my objection yet. So give me the proper respect of my due diligence to give you the foundation of my objection so that you can make a fair determination of your due process and my due process civil rights.
I'll give you one sentence, sir.
Okay. I would like you to look at the other document of this same
case. All right,
case.
that's overruled, sir.
I've ruled sentence.
Mr. Stanley,
about 40 words.
Mr. Stanley, you are interrupting. I'm going to have to turn your microphone off. I don't want to do that. But counsel is entitled to ask foundational questions. The questions were proper. Your objection is overruled. Proceed.
I don't recognize this document.
Madam Clerk, could we please go to page 19 in the PDF? Sir, do you recognize this document?
I can't see the bottom. Can you scroll it up a little more? Whose signature is that on the very bottom?
I'm asking if you recognize the document.
I'm trying to see whose signature there is on the very bottom.
You're not answering my question, so I'll ask a different one. Did you type?
Scroll that down some so I can see the top of this document to answer this question fairly. So basically, this is a grievance form? Is that what I'm looking at?
I'm asking you, sir, if you recognize the document.
But it appears to be a grievance form. Can you scroll it back up some now, please?
Okay, please do that.
I'm looking at the bottom of it. This is a grievance form. I believe that it's from a grievance panel, but I'm looking at, I believe that's the defendant's signature on the bottom. That's not a grievance panel's signature.
Sir, I'm not asking you that. I'm asking if you recognize the document.
I do recognize this document.
Okay, thank you.
Oh my gosh. He wanted nothing more than to point out the dentist's signature there, as he's already brought it up a few times about, he's not allowed to sign on the grievance. And he had the audacity to act like he was shocked. Like, what is that I see on the bottom of that document? Isn't that his signature in the grievance line? On this document, I don't know if I recognize. Can you scroll up so I can see the top of it so I can know if I signed the bottom? Oh my gosh, this guy he is the tool he used to fashion his dentures.
Thank you. Now that you've established that, do you recognize
this exhibit as a full exhibit?
Oh, you want it as a full exhibit?
I have no objection to Exhibit C being admitted as a full exhibit.
Good. All right. Exhibit C admitted in full.
Okay. So now that Exhibit C is admitted as a full exhibit,
Thank you.
You would agree with me that on many occasions you have written to the Department of Correction officials attempting to get medical care for your dentures, correct?
Well, in my own words, I have written many times to many people of this dental issue, and even this grievance being, even lays out the foundation of my signed signature. Yes. So this would be.
And that would
include processes.
That would include on forms such as page 19 in Exhibit C as in Charlie, correct? That would be an example of you writing such a type of document, right?
Can I see Exhibit C?
You're looking at page 19 right now.
Is that Exhibit C I'm looking at? I thought this is Exhibit C, correct?
It's page 19 of Exhibit C, yes.
I recognize, well, I don't know about page, this grievance form that I'm familiar with, and I even have a copy of it, is only a 1 page. So I don't know about 19 pages. This is only a 1 page document.
Sir, I'm asking you the page that you're looking at, which for the record is the 19th page in Exhibit C. This 1 page is an example of you writing on a document or typing on a document in an attempt to obtain medical care concerning your dentures. Yes, it's an example of. Okay.
And for the record, this is Exhibit C.
Sir,
I need the clarification.
All right, I'll allow it.
This exhibit being entered, I'm only agreeing to this 1 page, not the complete trial, not his complete 19 pages or whatever it is. I'm agreeing only to this 1 page that I'm verifying that's my signature.
It's already an exhibit.
Well,
correct, as in 1 page, not all 19. I only agreed to this 1 page. Let's get that straight on the record.
I'll honor that request, even though I think that's not what you said originally, but if that's your position.
I recognize there's 1 page.
Well, then no, then I'm not going to agree. I'm going to withdraw the offering, and I'm not going to agree. Want to be difficult? Will be difficult.
Okay.
Because I'm not. If you're not agreeing, you were asking me if I recognize this 1 page. I recognize this 1 page. That's all I recognize.
All right. So, excuse me. I want to try to solve this. Exhibit C is no longer a full exhibit. If you want to offer it, Mr. Stanley, and if it's part of your requests, I would consider it, but you have to do that on redirect. Right now, it's cross-examination.
I tried to do that at the beginning, and you denied it.
Yeah, I know, because you did not establish any foundation for it. I'm not going to go back over past rulings, sir. We're not moving forward. This is cross-examination. Your job is to answer questions. Mr. Fanouken.
So, sir, I'm going to make it very simple. There's documents in here in Exhibit C that you are attempting to offer in some of your exhibits. There are also documents I will represent to you that are not in some of your exhibits. This is 35 pages of either what I believe to be your writings and on occasions responses thereto. I am willing to offer this. It's an admission by a party opponent, so I can offer it because it's your statements, and it's also attempts at obtaining medical diagnosis or treatment. If there is foundation for it to come in, I will offer the entire exhibit and you're welcome to agree or disagree, and or follow up with the judge on your own testimony if there's pages you don't think should be given weight. Does that sound like a plan, or do you not agree?
I do not agree because you're showing documents that do not have my signature on it that you want me to confirm are mine. There's no foundation of it being my document.
Okay, then I will get it in through a different witness, but don't complain to me when you're not able to testify it on read and redirect. So we'll move on from Exhibit C. Oh, by the way, in addition to medical grievances, you've also submitted your writings on things such as inmate request forms, right?
Only if I can verify them and see them, and you can confirm that you've ever gave me notice of them.
No, I'm just asking, to your recollection, do you remember submitting writings concerning your medical care on things called inmate request forms?
Which you denied and objected to, which is my exhibit number 1.
Yes or no question, sir.
See my exhibit list.
Mr. Stanley.
Yes.
If there's a yes or no question, your 3 answers are yes, no, or I can't answer it yes or no.
I cannot answer at this time.
Okay. So let's go to Exhibit C, page 20, please. Show the witness, or proposed Exhibit C.
I'm objecting to any exhibits being shown as the same respect you did with my exhibits. You denied to me because it's hearsay. Therefore, again,
That's overruled, sir. The exhibit has not been offered. He's entitled to attempt to lay a foundation.
so why, when it was my exhibit, you
Excuse
denied
me, sir.
the foundation?
I've ruled. I'm not going to argue every objection. I heard
But you
you.
can't show the same document that you're denying me to file, to even have one review.
Mr. Stanley, let me explain something to you.
Yeah, that it's been a one-sided kangaroo court as you are in the past. You're biased and being
All right,
prejudiced.
Mr. Stanley, please don't interrupt. I heard the objection. I heard your reason. I ruled on it. That's my ruling. Let's move on.
So, Madam
I
Clerk, could you
apologize.
please-
Yes.
What
Tatum?
page?
Page 20, please.
My apologies.
So, sir, do you see the page 20 on the screen?
I guess it's page 20. It doesn't say it, but I see it. I see a page in front of me.
Do you see that it has a date in the top right corner of 10/27/2017?
I do.
And do you see next to the previous action taken in about the middle of the page, it says Mr. and then it looks like your signature? Is that your signature?
That is my signature.
And so you
And-
wrote at least the top half of this document, yes?
Correct. And is there any verification on the bottom that I was seen at medical that day?
Sir, I
Because
didn't
I
ask you
don't
about the
know.
bottom. Sir, I didn't ask you about the bottom. You're welcome
Well,
to
you're
ask
asking me
any.
about a document, so I need
Sir.
to answer the full document.
You confirmed you wrote the top half. That's all I asked you.
I
If
wrote
you
the
want
top
to-
half, but it was never
Thank you.
answered.
If you want to opine on any other materials, you can agree to it, come in evidence and ask Dr. Cuevas about it. Until then, you can't. Okay. And so this is an example of you writing an inmate request form concerning medical care. Would you agree with that?
I would have to disagree and I would object to this because all these documents that you are submitting are hearsay at the time because they're not entered as a full exhibit.
They're not hearsay, Your Honor, because they're omissions by a party opponent. I'm
Right.
offering them against him.
Right.
They're hearsay because they're not entered as a full exhibit, so they're considered hearsay, just like
Right.
you ruled on me.
To the extent that's an objection, it's overruled. Next question.
Would you agree with me that this is an example of you filling out an inmate request form concerning your medical care?
I would have to say that's hearsay.
It's not his fault, guys. He has an 8th grade education and he had spent those years obtaining his dental license, medical license, and law degree. So you can't put it on him. He just didn't have enough time to learn everything that he immersed himself in that, middle school level.
Your Honor, I need an answer to this question.
All right, you didn't answer the question. It wasn't responsive. So Mr. Stanley, would you answer the question, please?
Basically, at this time, I cannot answer that truthfully.
Okay. And is that because you're just being difficult and you don't want to answer the question, or is that because you don't recognize your own handwriting?
No, because these are not full exhibits, as they're the same exhibits I tried to enter, which the court objected. So I'm objecting to answer any of your exhibits. So move on to your next question.
I'm not offering as an exhibit. I'm asking if this is an example of you submitting an inmate request form.
And again, I'm giving you the same answer that we said with my exhibits, that I cannot answer this faithfully at this time, because that's
not an acceptable answer, sir. I need a yes or no.
I do not recognize it at this time.
Your Honor, I'd ask for you to direct the witness to answer my question.
All right, I have. I'll do it one more time, but there may have to be another remedy if you don't respond. I am directing you to answer the question as to whether it's an example of an inmate request form that you filed.
I recognize that it's an inmate request form and I recognize my signature. That's all that I'm stating to this document.
Do you recognize that it says inmate request form in bold block type at the top of it?
That's what it says.
And do you recognize that in the right-hand corner, it says CN 9601?
Yep.
And so this is an example of an inmate request form by the plain text of the document that you admit that you filled out the top half, signed, and submitted, yes?
I believe that's true, that, and again, for the record, an inmate request form, I believe, has to be ruled and answered within 12 days. So again, I don't believe that this was out of a proper answer.
That's not my question, sir. You'll have an opportunity to address things you want on redirect that were covered in cross. My question is, this is an example.
Documents.
Mr. Stanley, just answer the questions, cross-examination.
This is a example of an inmate request form filled out and signed by you and submitted concerning attempts to get medical care. Yes?
I'm not certain.
Okay. Your Honor, I would offer Exhibit C as a full exhibit subject to connection with a further witness. These are all documents filled out by Mr. Stanley and submitted to get medical care or responded to by somebody concerning his attempts to get medical care or treatment. So they're both admissions by a party opponent. They're both admissions by a party.
Mr. Stanley, you're interrupting. I will hear you. Let me hear from Mr. Finucane. Go ahead.
They're both admissions by a party opponent for concerning Mr. Stanley's writing, and they are statements for purposes of obtaining diagnosis or treatment, all of the writing. Therefore, they are exceptions to the hearsay rule and they should be admitted in full.
Mr. Stanley, brief response.
I object to that because there's no follow-up where if he's saying on the bottom of a scene, show me the document that verifies that this would not be hearsay. Show me a document that would support this being true fact.
Okay, your objection's
hearsay.
Objection overruled, full exhibit. That's
but when I entered the same document,
Mr. Stanley, Mr. Stanley,
you objected to the same document I tried to submit.
The
same exact one you objected to, but you think that's a funny laughing matter when you're telling me now.
Mr. Stanley, I didn't object to anything.
You most certainly did. By 1 through 17 is the same document that you objected to.
Mr. Stanley,
objected to both sides of any exhibits being entered as full exhibits. This is already been asked.
Mr. Stanley, you're interrupting again. I told you not to interrupt. Here's my response: is that Mr. Finucane has laid a proper foundation. You did not do that. But listen to me. But listen. If you want these exhibits admitted, then let's agree that they should be admitted and not waste time with evasive answers and improper objections. We can just move on to the facts here.
All my exhibits to be entered that would show a doctor's certified statement saying that this defendant deliberately violated my civil rights under the 8th Amendment and ground them down to cause this injury.
Okay, you're not listening to me, so we're just...
Let me be clear. You want to grant your exhibits, but not mine. That's what I'm hearing from you.
Right. Okay, so this page is admitted in full. I'm not sure how we're going to do that, but this is page...
Or these are complete documents?
No, just the page, but if you want to...
What is the entry number of this
Mr.
page?
Stanley, you're interrupting. If you want to agree, if you want to take a look at...
I want to know the entry number of this page.
This is page 20, I believe.
And entry number 1.
That's defendant's exhibit C, page 20. But if you want to take a look at the other pages here, we could save a lot of time and effort if you would agree to them. I will admit them if there's an agreement. So you want to do that?
If you agree to let in all of mine, I'll agree to let in all theirs. Do we all agree on that?
Okay. That was the offer that Mr. Finucane made at the beginning of this trial. But I guess better late than never.
Well, no, because you want, the only way that you agree is if I agree to theirs, then you agree to mine. That's the only way this is happening. I object to theirs. First of all, it was my point.
Mr. Stanley, you're interrupting. Mr. Stanley, you're interrupting.
Can I have the court take
Mr. Stanley, you're interrupting.
Yes, sir.
Okay, thank you. I'm a flexible person, and I'm willing to entertain an agreement now, even though we've spent a lot of time without unfortunately arguing about things that you may now agree to. But if you want to agree to the admission of the defendant's exhibits, then all of your exhibits will be admitted too. So do you want to do that?
I do, Your Honor.
Good. All right. So,
And Your Honor, just so I'm clear on the record,
yes, sir.
we agree to plaintiffs 1 through 7 coming in as full exhibits, so long as he agrees to defendants A through I as an igloo coming in as full exhibits.
Just for the record to be clear, I've never received, because of his certification on his last document of this same case, he served all the paperwork to himself at 165 Capitol Ave.
That's not true. That's
It
not
is.
true.
Okay, so if the court would take judicial notice to pull up the other docket, you pull up his appearance form. His appearance form
Mr.
shows.
Mr. Stanley, I heard you agree. So I'm going to admit plaintiff's exhibits 1 through 7 in full and defendant's exhibits A through I in full. All full exhibits. Thank you, Mr. Stanley. Thank you, Mr. Finucane.
Thank you, Your Honor. Thank you, Mr. Stanley. Sir, do you have plaintiff's exhibit 3 in front of you, or should I ask the clerk to put it on the screen?
I've never received nothing from you, so you have to put everything up on the screen.
It's plaintiff's, your exhibit 3. Do you have your own exhibits, or should we put it on the screen, sir?
I believe that was the 8.4 directory, correct?
Yes, correct.
Yes. Can we put it up on the screen so we're all on page with this same document?
I'm okay with
Please.
that. Okay. So the first page, we're just going to run through page by page quick. The first page, nope. Madam Clerk, if you could scroll up, there we go. It looks like it says exhibit number 3, DOC 8.4 directive 1 to number 4. Did I read that correctly?
You did, thank you.
You wrote that, right?
That is my writing correct.
Okay. And when you say number 1 to number 4, are you referring to the page numbers?
I am, thank you. Yes, I am.
And that does not include the cover page, correct?
I believe it does, because the second
Well,
page.
if we could go, okay, we'll go to the next
cover
page.
page is 1 of 4, it says.
We'll go to the next page. So the page 2 for the PDF, top right-hand corner, it says page 1 of 4, correct?
No, that's page 1.
I understand that, but the exhibit contains the cover page as a page. So I just want to make sure we're clear in the record. If you're going to refer to pages in this, I'm going to ask for you to refer to either the PDF pages, which are in the court's 205 versus page 1 of 4. Does that make sense? Can you do that for me?
I'm holding my documents in my hand and I have 4 pages, and that what you have on the screen would be page 1.
Okay, that's clear enough. So if we could, Madam Clerk, go to page 3 of the exhibit, which is going to be page 2 on the directives page numbers.
No,
Sir,
that's
do
not
you?
page 3. Page 3 is marked page 3, and it says 3 of 4 on the top.
Sir, it says page 2 of 4, right?
Correct. And you told Madam Clerk to go to page 3. We're looking at page 2.
Right. So in the right-hand corner of the document, it says page 2 of 4, correct?
That's exactly how I formatted all my documents being entered.
That's the magic question right there. Okay. So if the court's aware, you're aware, I'm aware, my client's aware, the clerk's aware, and anyone reading this record is aware, they may be off by a page. Would you agree if there's a cover page?
Well, not from my paperwork that I'm holding in my hand. That is page 2, exactly what I'm holding right here in my hand.
Okay. Okay. I think it's clear enough for the record. So on page, we'll call it 2 of 4, the directive page, page 3 of 5 on the PDF page. It says section 5, oral care services, and then under subparagraph A2, it looks like there's an arrow and some writing. Did you put the writing on that page?
I did. That's my marking on the document. Yes, it is.
And if we go to the next page.
4 of 4, correct?
3 of 4 and 4 of 5.
Yep,
3 of 4,
okay.
directive 4 of 5. Same thing, the writing here, however faint, that's in handwritten, not typed. That's your handwriting, right?
That is my arrows with my circling items. Yes, it is. That's my.
Understood. Okay, and if I told you that other than the cover page, which you have acknowledged you wrote, and other than those other handwritings, this is the same or the same a copy of the Administrative Directive 8.4 contained on DOC's website, you would have no reason to disagree with me, right?
I agree with you 100% on that. Correct.
Okay. And so the court, if the court wants to, it can take judicial notice and cross-check it with the DOC website, just so everyone's clear what we're looking at, right?
Correct. I have no problem with that at all.
Okay.
Now, you do realize to my complaint.
There's no question pending.
There's no question pending, sir.
Okay.
When you came into prison, this most recent time, first of all, do you remember when that was?
2012, April 22nd, 2022. I mean,
Did you have dentures at that time?
2nd, April 22nd, 2012, for the record.
And so when you came in on or about April 22nd of 2012, did you have dentures at the time?
I did not. 2 weeks prior to that date, I was at Farmington Medical, which my medical report, which I granted you to obtain, shows that my teeth were just pulled 2 weeks to the day prior to going to jail. Within 6 weeks, it was ready for my dentures.
So when you came in, you didn't have dentures. This most recent time coming into prison, you didn't have dentures.
DOC never pulled any of my teeth, correct?
Okay. Also, you've maintained in your direct, you've maintained in your direct examination, your own testimony. I believe you have used the phrases negligence, gross negligence, and the 8th Amendment. Do you generally recall using those words this morning?
I do, and I'm repeating exactly what the doctor's statement says.
Objection, move to strike that last part, non-responsive, and it's here.
I'll disregard the last part of the answer. Next question.
So, do you, not asking what you think someone else believes, do you believe and claim that Dr. Cuevas violated the 8th Amendment by being supposedly gross negligent or negligent?
Absolutely.
Okay. Or by allegedly not following DOC policies or practices?
100% of the documents that we're looking at
Thank you.
now on the screen.
Thank you, sir. Also, sir, you realize that when you filed this lawsuit, you very well may need to testify, correct?
Excuse me?
When you filed this lawsuit, you understood that you very well may have to testify in court like you're doing today, right?
Absolutely.
And you knew that you'd have to swear an oath to tell the truth under penalty of perjury, correct?
I do, and I was already sworn in, as you know.
And you also knew that when you did that, when you made accusations and then swore an oath to tell the truth under penalty of perjury, essentially you would be putting your credibility at issue in this case, correct?
I believe everybody's credibility would be subject to that penalties of perjury.
Including yours?
Everybody's, including myself, yes.
Okay. And in assessing, the person assessing your credibility would be the fact finder. For today's purposes, the judge, right?
Well, under duress, yes, it is a judge instead of a jury.
And so while we're discussing your credibility and on that topic, you would also agree with me that you are currently incarcerated for a conviction of 100 counts of violating a protective order, right?
And that has relevance to my dentures. How?
Because it impeaches your credibility under the rules of evidence.
First of all, anything that I'm in jail for, we're not crediting how many cases that you've been in front of the judges violating people's civil due process rights either.
Sir, I'm not the convicted felon and I'm not the one answering questions. You agree with me that you have those convictions, right?
I do. Pending an appeal. Pending appeal. So they're not relevant as we speak.
Your Honor, I would just note for the record under Rule of Evidence 6-7, we believe they are relevant, but Your Honor can give that whatever weight you wish, if any.
Your Honor, I'd like to object if I may.
And Your Honor, I tender the witness.
Oh, okay. All right. So
We
the
have a
objections,
pending objection, Your Honor.
right. I did hear your objection.
You did, because I haven't stated it yet.
Well, let me complete my answer. The general rule is convictions of more than 10 years are not admissible impeachment unless the defendant is still incarcerated on them, which he is. So I tend to think that I'd have to double check the rule. Let me do that right now.
Can I now state my objection on the record?
Yes, sir.
Okay, my objection is that anything under appeal subject to habeas relief, therefore again, as him stating I threatened him, which is under appeal, is irrelevant to the case at hand. And I would take the person for George Floyd, we even take the football player that was in Massachusetts, his appeal was pending when he hung himself in jail, and the case went away because it was under appeal. Our Second Circuit Court has
Thank you, sir.
I'm not done, Your Honor. So
well,
give
no,
me my
sir, I've heard your objection.
You didn't, because I didn't cite the case law of the Second Circuit Court that says it's
Sir, I've heard your objection. The fact that the case is even on direct appeal does not prevent impeachment by prior conviction. Your case is not on direct appeal. So the objection's overruled. The convictions are old, but the rule does provide that the 10 years runs from release from confinement, which hasn't happened yet. So I'll take all of that into consideration and attach what weight I think is due to it. Redirect, Mr. Stanley.
Yes. Do I have now the defendant on the record?
No, it's your opportunity to testify in response to any of the things that came out during cross.
I do, and then I have the right to cross-examine the defendant, correct?
Well, it would be your case, so you would have the right to call the defendant as a witness.
Well, I am calling him right now as we speak, Your Honor.
Okay, so you don't want to provide any redirect. That's your option.
I do briefly. I have a couple. Okay, if I may, Your Honor, is
Go
the
ahead.
court aware? I should say that is the defendant himself aware that his attorney?
No, sir. This is redirect testimony, so it would be any facts, not questions, but facts. Let me finish because I'm trying to help you by explaining this. Any facts that you want to testify to that are in response to the testimony that came out on cross.
I do. I would like the record reflect and take judicial notice that there are 2 cases pending at the federal court and the attorney general.
Sir, you can make legal arguments in a brief that I'll let you file at the conclusion of the testimony. What I wanted to hear, whether you have any facts to testify, not legal arguments, but facts to testify in response to the testimony that came out on cross.
I do, Your Honor.
Go ahead, sir.
Okay, Your Honor. For one, we are in a habeas court right now as we speak under penalties of perjury of the defendant and the attorney generals that fraudulently have charged me and held me on a invalid warrant, no valid warrant for a search and seizure.
Objection. This is not.
Your Honor, there is no valid warrant for 12 and a half years now of me being incarcerated. Unless the attorney general can show there's a valid warrant that I'm in jail for.
Objection relevant.
Well, let me rule on the objection. To the extent that the plaintiff is attempting to explain his prior convictions, I will allow it and overrule the objection. Go ahead, Mr. Stanley.
Your Honor, to this date, we are now back at the habeas court. This defendant's attorney gave a testimony to a federal court of law. I'm holding the documents in my hand. And to this date, we are now back at the habeas court. There is a pending motion to show cause, and it's now back at the appellate court for them to show cause that they can produce any valid warrant of me being in jail now, going almost 13 years now. And as of to date, with 2 of my direct appeal attorneys and my other standby counsel that's appearing in court, they will testify. There is no valid warrant that ever obtained my phone records, nor to hold a body in jail for 12 and a half years. So I've been falsely incarcerated in imprisonment on illegally obtained evidence that Judge Stanley T. Thieger, and I went in front of him yesterday again, Stanley T. Thieger testified on Exhibit 17 of the docket CR-12-239071 that barred the state's attorney to using my illegally obtained evidence because there was no valid warrant. So one, I have a judge's order, and two, the state has never produced to this day a valid warrant. So for the record, for impeachment purposes, I've been illegally incarcerated for 12 and a half years.
Okay. Any other facts you'd like to testify to in response to cross-examination?
Yes, just basically for the record, a brief thing. We're back to the defendant's exhibits that he put up for the court to take judicial notice now. On the exhibits that is administrative directory that's on the screen and a couple of pages before, I'm asking you, Judge, to take judicial notice of DOC's administrative directory. And it says any broken dentures or any type of issues, it's a 72-hour emergency relief. Nowhere, as the defendant stated in his documents, in his statements, that I had to wait 5 years, does it say in the administrative directory, does it say you have to wait 5 years to fix or replace broken dentures? So therefore, again, let me just finish this up, and I'm very clearly.
Well, I just want to ask you this. I don't have to take judicial notice of it because it's a full exhibit, but what paragraph are you pointing to or referring to? Can you tell me?
If I may, Your Honor.
Yes, sir.
We have
this is exhibit 3.
Yes.
On page 204, doc number 2,
okay.
Says 72 hours for emergency care. And then we get to page 3 or 4.
Well, hold on. I'm on page 2 of 4. There's no is it under, it's a little hard to read, but 5A2, urgent care.
So we're going to go to number 5. And it's on number 2 of A. So we're at 5A2.
Okay, I see that. Thank you. What else?
Basically, that any emergency care is within 72 hours.
Not being comfortable is not an emergency. Just because you deem it an emergent situation doesn't mean that it necessarily is. You are not going to die from having to mushmouth your food.
So nowhere on any of these documents does it say that any dentures to fix or replace them, like the defendant stated in his sworn under penalties of perjury, that it 5 years to fix or replace them. The only thing that he manipulated the court, which I want to make it very clear in these documents, that you're entitled to a new set, additional, every 5 years. Nowhere does it say in here, under his injunction motion, which his motion to strike, it says
Sir, I don't want to hear legal arguments. I do want to hear any facts, but sir, don't interrupt. Is there a paragraph that you're referring to about a new set in 5 years?
No, that's what he kept stating under oath on his penalties of perjury of his motion to strike, that he says I'm not entitled to it. It's a
Sir, I think he answered my question, but you went on obscuring the answer. Does this administrative directive have anything about a new set every 5 years?
You would have to follow up farther with DOC, but I know for a fact, reaching out to them, Sir,
my question is, does this administrative directive have a paragraph about that or not? I just don't know. I'm not clear.
It's available, but I don't believe it's in this document, which my expert witness would have testified to that.
Okay.
So
all right.
Again,
any other facts?
So under penalties of perjury of the defendant, because the Attorney General filing on his behalf, so now he's speaking for the defendant under his penalties of perjury, lying under oath to the court, that I have to wait 5 years for a new for these dentures to be fixed or replaced, was basically a fraudulent lie. And all my requests, even the grievance form that I filed, which you'll see he signed, and if you reach out to administrative directory, I wish we could have an expert witness of my administrative directory, DOC, to testify that a grievance would have, this grievance form that he showed you was signed by the defendant, which he is not authorized to do so.
Sir, any facts in response to cross-examination?
Basically, just to the point that, asking the Attorney General, how many cases have you tried of you being attorney?
Sir, you didn't hear what I had to say. By the way, I allow redirect and recross, and that's it. But redirect is an opportunity for you to state any facts, not ask questions, but state any facts in response to cross-examination. Do you have any?
Yes, I do. It's the fact that the Attorney General has lied under oath on the defendant's behalf before. He's committed penalties of perjury.
Objection, lack of foundation.
Sustained. It's not in response to cross-examination.
I'm ready to cross-examine the defendant if we may now.
So no further testimony on redirect?
At this time, no, Your Honor.
Okay. Any recross, Mr. Finucane?
No, though I would note that Mr. Stanley just said at this time, this is the time.
Right.
So
This is the time, but
And as I said, I was preserving my right to do so. As I said, under oath, not at this time. So listen to me very clearly. Not at this time.
I heard it. I can make a decision.
Thank you, Your Honor.
Thank you. So it's time for any recross, if any.
no, thank you, Your Honor.
All right. So we've completed the plaintiff's testimony, and I also want to be guided by time concerns here, to see what we do next. But what would, do you have any witnesses? Let me just ask that, Mr. Stanley.
That's a joke, right?
I'm not joking, sir.
I have 36 witnesses that you failed to answer and grant my subpoenas when we've never had a hearing on my denied fee waiver.
Right.
So violating my civil due process rights.
I've explained my ruling on that, sir.
So you never gave a ruling on my subpoenas. We never had a hearing.
Sir.
We never had a hearing.
Sir, I thought you said you wanted to call the doctor as a witness.
I wanted to call the doctor just like I wanted to call the doctor from Farmington Medical, and I wanted to call the administrative directory of DOC.
Right. So if the answer to my question, I think, is yes, I'd like to call the doctor as a witness.
And my first witness, yes.
Right. So let me just ask about time concerns. Yes. Tatum, I mean, it is getting towards lunchtime for staff, which I want to grant. We would normally resume at 2:00. Can we do that, Tatum?
We certainly can, Your Honor.
Okay.
Whatever you'd like.
All right. So rather than start the next witness and have to recess for lunch, I think the better decision is to recess now for lunch and resume at 2:00. And you're going to call Dr. Cuevas at that time, Mr. Stanley?
I am, Your Honor. Thank you.
Good. All right. We'll stand in recess till 2:00.
Thank you, Your Honor.
Thank you.
Court stands in recess.
We're on the record now.
Court is back in session. Good afternoon, Your Honor.
Good afternoon, everyone. We will now proceed with calling a witness. I believe Dr. Cuevo. Mr. Stanley, is that who you'd like to testify?
That's one of my first witnesses, yes.
All right. So, doctor, if you would take the oath.
Dr. Cuevas, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Please state your name and address, your business address for the record, including the spelling of your last name.
My name is Frankie Cuevas, last name spelled C as in cat, U as in uniform, E as in echo, V as in Victor, A as in alpha, and S as in Sam. I work at the McDougall Walker Correctional Facility in Suffield, Connecticut.
All right, and doctor, your first name was Frankie?
Yes, Frankie.
I see. Okay. And I will state that I will allow defense counsel the opportunity to conduct a direct examination of the doctor on any matters beyond the scope of Mr. Stanley's direct for the purpose, if you want, for the purpose of not having to call Dr. Cuevas in your case in chief. But that's up to you entirely, Mr. Finucane.
Understood, Your Honor.
Good. All right, Mr. Stanley, go ahead with questions about facts.
Yes, okay. A little bit of background history. Are you aware of your attorney's filings to the Federal Court of Law of ex parte conversations to try to sabotage two of my cases where 6 judges had to recuse?
Objection, lack of foundation.
Right. Just ask questions, sir. That's an argumentative statement.
It's the same thing about my schooling. It's a little bit of a background history. So I'm asking the defendant, is he aware of his attorney's filings of improper filings to the Federal Court of Law of ex parte cases of 6 judges recusing themselves? Were you aware of that?
Objection, relevance assumes facts, not in evidence.
Right. Why don't you ask him about what he does for a living?
Well, I'm going to first start just like with my schooling. My schooling or my dental background history or me working in the kitchen had nothing to do with my dentures, but you let proceed. So let me just give my foundation of a little bit of background history.
Your question contains an argument. Why don't you can ask him a fact question if he's aware of some filings, but don't argue what the filings say.
Okay.
Right.
It's a fact. Are you aware that your attorney filed paperwork on nobody's behalf to the federal court where 6 judges had to recuse themselves for his misconduct?
Objection. We disagree with the premise of the question.
You're assuming some facts, not in evidence, Mr. Stanley. Excuse me, sir. Sir, why don't you just ask him facts about what he did in this case?
Well, because I'm trying to lay a foundation just like you did. My schooling had nothing to do with this case, and you permitted it. Please allow me the little bit of...
Mr. Stanley, I've already ruled on those objections. Go ahead.
You granted them to rule on my schooling that had nothing to do with dentures. So
I'm not...
don't you give me the same leniency and latitude to ask the same foundation of the Attorney General's misconduct to see if he's done anything wrong?
Mr. Stanley, I've ruled on your objection. I've told you that you can ask him about his educational background, just like Mr. Finucane asked you about yours. And I'm not deciding this solely on educational background, but it is
Okay, so with his job, and I agree with you 100%, just like me working in the kitchen was my job. So now I'm going to the Attorney General's job.
I'm not a party, Your Honor. This is not relevant. This is a giant waste of time.
Mr. Stanley, I've ruled on your objection. Next question, sir.
Yes, are you aware of my medical background history?
I don't understand what you mean specifically.
As far as unable to eat because no dentures, are you aware of my medical needs?
Well, it seems you're able to eat.
No question.
You can certainly eat.
It's a yes or no question. Are you aware of my medical needs? Yes or no?
Objection, asked and answered.
Well,
again, are you aware of my medical needs?
Mr. Stanley, Mr. Stanley, it's
How
my...
does he know I can eat? Okay.
Mr. Stanley, Mr. Stanley, it's my role to rule on objections. I will, and I'm going to rule in your favor in part. So if you'd let me say something, it might help you out occasionally. And I will allow you to ask yes or no questions. And you kind of clarified it second time and added yes or no. I will allow that. But the doctor then should answer yes, no, or I can't answer yes or no. I also want to tell you that you probably want to get some information from the doctor, and that might not be the best way of doing it, but I'll allow you to do it the way you want. So go ahead.
So are you aware of my medical problems of me having an ulcer? Yes or no?
So it's yes, no, or I can't answer it yes or no.
I can't answer yes or no right now.
Have you ever seen me eat without my dentures? Yes or no?
I've never seen you eat.
Have you ever seen me working in the kitchen around power tools before? Yes or no?
I've never been to the kitchen at McDougal. Yes or no? I've never seen you. I've never been to the kitchen at McDougal.
Have I ever had any access to any power tools in your office?
I can't. No, not in my office. Certainly not. That would be a severe violation of security.
Did you ever let me use any power tools in your office?
No,
Did you ever let me use any power tools to grind down my own dentures or cut them?
I'd never allow you to touch any of my tools in the dental office.
So all the time that I was asking for new dentures, you were the only doctor I have ever dealt with in the dental's office, correct?
That is incorrect. You saw Dr. Tuttle at McDougal as well.
Okay. All right. Have you ever worked on the grievance panel before?
I answer grievances as my normal job duties.
So I'm going to ask the question again. Are you part of the grievance panel?
I don't know what you mean by panel, but as
Okay.
part of my normal duties, I answer grievances.
So basically, are you a grievance coordinator?
No, that is a
So
separate
then
job, but
you
I
do not
answer
have-
grievances.
You do not have the civil liberty rights to answer any grievances then, correct? If you're not on the board.
That is incorrect. I answer grievances as my normal job duties.
So are you a grievance coordinator to answer a grievance?
Objection asked and answered.
I'll allow a little latitude. Go ahead, Mr. Stanley.
Are
Ask
you
question.
on the grievance panel?
I don't understand what you mean by panel.
So if I go in front of the grievance board, arguing a fact of a grievance, are you on that board to make a ruling of the 3 to 5 grievance panel members? Are you one of those? Are you appointed grievance panel member?
When grievances are served
That's
that
not
have
my
to do with,
question.
I
All
don't
right,
know what you mean by
Mr.
panel.
Mr. Stanley, if you ask a question, the witness is entitled to answer it, and I'll allow reasonable
And I want a
latitude.
yes or no answer.
Excuse me, sir. Excuse me,
Okay.
sir. If you ask a question, the witness is entitled to answer it, and I will allow a reasonable latitude for the witness to answer.
Okay.
If you want it,
I withdraw that question.
okay.
I'm going to
fine.
rephrase it.
Okay.
Yes or no? Are you part of the grievance panel?
If you mean panel by I have to answer grievances, yes.
No, that is not what I'm asking. When I file a grievance and I go in front of the grievance committee, it's a committee. Elected officials, are you one of those panel members? Yes or no?
Objection, assumes the facts not in evidence. He hasn't established there is a panel.
Okay.
You entered the grievance panel. First of all, he opened the window because in his exhibit C, the grievance, he submitted as a full exhibit. So I have a right to go there now. He opened the can of worms for us.
Just ask your question. If you want to make a yes or no question, say so as you did last time. And then just a second, and then the witness can answer yes, no, or if it's unclear or uncertain, he can say, I can't answer it, yes or no.
Okay, so are you part of the grievance panel? Yes or no?
I can't answer that because I don't understand what you mean by panel.
Are you an elected grievance panel member? Yes or no?
I can't answer that. I don't know what you mean by the word panel.
Is your job title, is it a grievance coordinator or are you a dental provider? Which one is it?
My job title is lead dentist for McDougal Correctional Facility.
So you are not a grievance coordinator, is that correct?
No, that is a separate job title.
So basically, if somebody files a grievance against you, it goes in front of a grievance panel, correct?
That is incorrect.
So if I go to say for beating somebody up and I object to my ticket, you're telling me I don't go in front of a grievance panel?
I have no idea what happens in that scenario.
Well, you just said that you answered them, so you should know this question. So you're
I answer dental grievances because I'm the lead dentist at McDougal Correctional Facility.
But you are not a grievance coordinator to answer grievances at the panel, correct? Yes or no?
I don't understand what you mean by panel.
Okay, your title, is it a grievance coordinator?
Objection asked and answered.
Yeah, we've already had that question, sir. Next question.
So you stated on the record you are not a grievance panel member, correct?
Objection, mischaracterizes testimony.
You're misstating the facts, Mr. Stanley. Let's move on.
Well, the fact is you are not a grievance panel member, correct?
I don't understand what you mean by panel member.
To make a ruling on a ticket that's being opposed and objected for a grievance.
What do you mean by ticket?
Okay, so if somebody files a grievance and they don't like the answer, they have a right to go in front of a grievance panel members, which is 3 to 5 members. Are you one of those members? Yes or no?
Objection. Assumes
Sustain
facts
your,
not in evidence.
Mr. Stanley, you can only ask questions. You can't make statements.
Okay. So if I file a grievance against you and I'm not happy about your services, would you rule on that panel?
Correct.
You
I'm
would
the
rule on
first
that
step.
panel?
I'm the first person that the grievance goes to because it's a clinical decision. And I'm the lead dentist at McDougall Correctional Facility.
So at the bottom of a grievance where it says for a grievance coordinator to sign, that is not for your signature, correct? Grievance coordinator?
Any clinical decisions about dentures or dentistry go to the dentist.
So if I file a grievance, as the state's attorney has filed on your behalf, a grievance, right here. So it says, a DOC administrative remedies for a grievance. You are not authorized to sign on a grievance for a grievance panel member, correct?
I sign on those all the time because it's a clinical decision on dentistry.
So why would you sign in where it's for the grievance panel member then? You're not a grievance
Objection.
panel member.
Assumes facts not in evidence. We've covered this
Sustained.
now.
It is in
Sustained.
evidence, you submitted it, Your Honor. The state entered this as a full
No,
exhibit.
Sir, I sustain the objection because there's no evidence he's on a grievance panel.
Correct, so I'm asking the question now, so how are
But
you
you-
signing your name to a bottom of a grievance panel member spot where this is a grievance, only a grievance panel member can rule on?
Objection, mischaracterized.
Sustained.
evidence. Assumes
You're,
facts not in
you're
evidence.
making statements or just ask questions.
Is this your
Your
signature
Honor,
on
Your Honor,
bottom of this grievance?
If it helps,
Yes.
we are not asserting an exhaustion defense in this case in any manner. I don't know if that helps move it along, but we're not asserting an exhaustion defense.
That may
I'm
help.
trying to lay down a
Honestly,
foundation,
not,
Your Honor.
excuse me, sir. That may help. I'm honestly not sure what this is about anyways.
I'm laying down
but-
a foundation of his misconduct, of him signing on a grievance panel when he has no authorization to do so. And my next subpoenaed witness that you're denying would be the grievance coordinator to state he has no authority or ability to sign on a grievance because that can only be by a grievance coordinator. The document has been entered as a full exhibit. It shows his signature on the bottom. So again, on this exhibit that your attorney general filed, is that your signature on the bottom?
Objection. What page are we on?
That's really my question. What are you referring to? You can't just say this. You have to refer to the
The
exhibit
state
number.
entered exhibit C.
Okay.
I believe, I'm not sure what page this was. They filed a grievance on mine. If you look at mine 1 to 17, this is page 3 on mine. If you want to pull up my exhibit list. So my first exhibit list, number 1 to 17, this is page 3. And the state confirmed it's exactly a mirror image of mine. So
It's exhibit C, page 19, or exhibit 1, page
Can the
4.
court pull this up on the screen, please, if we may?
Oh, okay, just 1 second while I get those exhibits.
I can only pull up one exhibit at a time, so I know that it is filed more than once. Your Honor, I would ask for your guidance, which exhibit you would like me
All
to
right,
share to
we'll
screen.
do it from the plaintiff's exhibits. And Mr. Stanley, was exhibit 1 what page?
It was page 3, Your Honor. It says
Okay.
confidential.
It's page 4 in the PDF, just for the record. the cover page.
Okay. Okay, I believe I see it.
Mr. Stanley, can you confirm this is the document that you were looking at?
That is it. Thank you, Court Clerk, Madam Court Clerk.
All right, so the question was whether it's the doctor's signature at the bottom. Doctor?
Well, we go to the reasons where it says reasons. And do you want me to read that for the record, or do you want me to have the defendant read it?
I would have the defendant read it.
Okay, so on the bottom where it says reasons, would you please read that? Out loud or to yourself, it does not matter.
It would actually be helpful if you read it out loud because it's very light on my copy.
Okay, I can certainly read that, yes. Where it says reason, Inmate claimed pieces of CU, which means complete upper, were thrown out during a shakedown. Inmate encouraged to file lost property form with the DOC.
Okay, so do you have, so my question to you is, where is the document of an IGP for a grievance that backs up exactly what you're stating, that I have lost pieces that basically were thrown out? Where is my statement that said that to you? What document?
I don't understand the question.
Your Honor.
Go ahead, Mr. Stanley. Do you have
Like the
another?
court to take traditional notice on the bottom where only a grievance coordinator would sign off on it. He actually signs in their spot, and this is under a IGP, and you can see the number what the complaint was. So his statement was for me to file a lost property claim slip. When this grievance, if you read it on the top, it clearly says, I'm unable to, I need due denture.
Mr. Stanley,
Yes,
just ask questions. You'll have an opportunity to file a brief in which you can make legal arguments.
Well, at the end, I'm asking the court to grant me 1 week's time to file a bill of acceptance for everything that has taken place in this case today. So back to this grievance form again. This is a grievance coordinator form, is that correct?
No, it doesn't say, it just says signature. It doesn't say signature of grievance coordinator.
Correct, so where it says IGP, did you give me that IGP number?
No,
So who initiated that IGP number?
the grievance coordinator put the number on, but I answered the grievance.
So you answered the grievance, that's you stating that the pieces were lost, correct?
Correct.
Okay, so why are you signing on the bottom where it's administrative directory for a grievance coordinator to sign? You did
It
not.
does not say signature grievance coordinator, it just says signature.
It says you have, right, it says you have exhausted DOC administrative remedies, which is this grievance of this IGP number. So basically, again, you are not authorized to, on the panel, to answer grievances, correct?
Objection asked and answered.
Okay, so the answer was on that was yes for the record, that you're
It was not.
authorized as the grievance panel member.
Objection, it was not yes.
Right. Don't make statements, Mr. Stanley. Just ask questions.
Okay, so you stated on the record that you are not a grievance panel member, correct?
Objection, he did not state that.
Right. He did
I'm
not.
asking that question.
Mr. Stanley, let's move on. You just keep asking the same questions
Right,
over
so
and
let's
over.
get an answer to this so we can walk this through.
If you ask a
Are you
proper,
part of the grievance
excuse me,
panel
sir,
member?
excuse me, don't answer that question. If you ask a proper question and there's no objection, I will make sure the witness answers it, okay?
Okay,
Thank
I'm
you.
asking the defendant if he is part of a grievance panel member, yes
You've
or no?
asked that several times, sir.
Objection.
Ask a different question.
Can the court reporter read back the answer to that question then?
No. I know that you've asked about a grievance panel
Right, so
several
I'm asking
times.
the court to read it back so I know the answer.
And I'm denying your request. Do you have another question of the witness?
I do.
Good.
So on administrative directory, on 8.4 says an emergency dental will be seen within 72 hours. Are you aware of that?
Yes,
So did you see me in 72 hours?
I don't know when I saw you. I have my
Well,
clinical
you're-
notes of when.
Well, the question was, the administrative directory says when I file it, that I'm to be seen in 72 hours. Did you see me in 72 hours upon my dentures being broken?
That's not what the directive says.
That's what I'm asking you. Did you see me in 72 hours? Yes or no?
I don't understand. I can't answer
When my
that.
dentures broke, did you see me in 72 hours of this emergency relief?
I'd have to go to my notes.
Well, can you do that? Because I need an answer.
Mr. Stanley is welcome to pull up exhibits and question the witness if he'd like.
I don't have to pull up nothing. I'm asking a question on the record. We're under penalties of perjury here. So did you see me in 72 hours upon my emergency relief of my broken denture? It's a yes.
Objection asked and answered. He said he
Mr.
doesn't
Stanley,
remember.
Mr. Stanley, Mr. Stanley, Mr. Stanley. He said he needed to look at his notes, so.
So it's not been answered.
Let me
then. So why
finish, sir.
would he
Mr.
put it
Stanley,
down? It's
Mr.
been
Stanley,
answered.
Mr. Stanley, please don't interrupt.
Well, I expect the same.
Mr. Stanley,
Attorney
Mr.
General.
Stanley, Mr. Stanley, please don't interrupt. I'm trying to say something. He said he needed to look at his notes, so it's up to you as to whether you want him to look at his notes to refresh his recollection. Do you want him to do that, or do you want to move on?
As I said, for the record, I need an answer. So it's already been asked and answered.
All right, then go on to the next question.
While he's looking through the notes, can I get the court to pull up?
Mr. Stanley, I just asked you, do you want him to look at his notes? And you didn't, you said it's been asked and answered. Now,
And
do
I
you
said
want him,
yes.
Mr. Stanley,
yes.
Mr. Stanley, do you want him to look at his notes?
For the record, if you go back to the court monitor, the answer was yes. So why do you keep
Mr.
asking
Stanley,
when it's
Mr.
been asked and
Stanley,
answered?
Mr. Stanley, answer my question. Do you want him to look at his notes to refresh his
What
recollection?
happens now? Yes. What don't you understand?
Mr.
Yes. I need an
Yes.
answer. Yes or no?
Okay, so you want him to look at his notes. All right, so
I'm
Doctor.
asking him, did he see me in 72 hours of emergency relief?
Mr.
Yes.
Stanley, listen to me. He said
I
he
answered
need,
your question.
Mr. Stanley, you're out of order. Listen to me. He said he needed to look at his notes. Do you
Five
want,
times now. I said,
Mr.
look at
Stanley,
your notes.
Mr.
Five
Stanley,
times.
Mr. Stanley, you're out of order. He
How many
said,
times do I have to tell
Mr.
you
Stanley,
about him to look at his
Mr.
notes?
Stanley, you're out of order. I'm about ready to strike the testimony because you won't listen to me. Now, let me complete my sentence. I think I know what you want, but it's not clear. You asked him, did he see you within 72 hours of the time your dentures broke? He said he needed to look at his notes. Do you want him to look at his notes?
For the record, 7 times, yes. What don't you understand about that? Yes, look at the records.
I'll overlook your rude attitude and ask the doctor.
Rude.
Yeah.
I
I'll
will
ask,
overlook your violation of my due process civil rights, of my subpoenas, my expert witnesses, and my discovery.
Mr. Stanley, you want him to look at his notes. Doctor, would you look at your notes to refresh your recollection on that?
Thank you.
Yes, sir.
For the record, Exhibit B as in Bravo contains Mr. Contains Mr. Stanley's dental records. Does Mr. Stanley have a page in question he'd like to have viewed?
Go
I
ahead,
do,
Mr.
which I
Stanley.
was trying to bring to the court's attention, but I was rudely interrupted. If we go back to my same exhibits, Exhibit 1 of this same filings, page 1, and we would have the next question that would answer everybody's question. But as I keep getting rudely interrupted of my line of questions. So if we look at my exhibits 1 to 17, this is page 1. Do we confirm this is an inmate request form? That's a yes or a no answer.
Mr. Stanley,
Okay.
do you want it? I thought you wanted him to look at his notes to
Correct,
refresh
and I'm
his
trying to
recollection.
speed up the process of showing you that we can lead him to his answer to my question, which I tried to answer you.
But only he knows how to refresh his own recollection.
That's why I'm
Um,
bringing up the documents that show.
All right.
this is-
All right, take a look at that, see if it refreshes your recollection.
So is that an inmate request form at McDougal Walker Correctional CN 9601?
Mr. Stanley,
Yes or no?
Mr. Stanley, you've asked a question. Do you want an answer to it or not? You asked a question about whether he saw you within 72 hours. Do you want an answer to that, or are you withdrawing that question?
He doesn't want an answer. He just wants to argue. And he doesn't even want to really argue. He just wants to be right. You're just supposed to all agree with him. Just don't argue with him. Just treat him with the respect he deserves.
No, I'm still waiting for that answer.
Okay, so he said he needed to look at his notes. Now let him look at his notes. Go ahead, doctor.
Can you go down, scroll, just scroll.
Yep.
keep scrolling. I just want to make sure there's no document. Yeah, okay, so that's for Dr. McDonald. Okay, so scroll up. Okay, so I saw you on December 22nd, 2017 at approximately 11 o'clock. Patient seen in response to grievance. Patient claimed that CU broke. Patient claimed that CU pieces were thrown out by DOC during shakedown. Patient also claimed he has a portion of his CU. Did not have portion at this visit. Patient vacillated between having denture portion with 3 teeth and 8 teeth, ? Suggested to patient he file a lost property form with DOC to determine final disposition of CU. Still within 5-year rule for 10 December 2014 appointment. Grievance completed. And then I signed it.
Can we pull that
Doctor,
document up
just
under-
just 1 second, excuse me, Mr. Stanley. Doctor, could you tell me what you're reading from?
It's Defendant's Trial Exhibit B, page, I believe, 072. Yeah, 72.
Okay, thank you. Mr. Stanley, go ahead.
Yes, can you pull that up on the screen? Because I don't have defendants B. I don't have any of the defendants besides my own exhibits. And mine are numbered. There's a letters. So I need to see that document
Okay.
that we're referring to the 5-year rule.
Dr. Cuevas, can you confirm this is the right document?
Yep, that's what I was just reading from.
So whose handwriting is that in?
That's mine.
So that's not my statement at all. Is that correct?
I quoted you in it, or I took what you said.
Let me rephrase that. Is that my writing or my signature on that document?
No, those are my clinical notes.
So do you have any document to verify what you're stating on that, on your document there today?
I don't understand what you're asking.
Well, you're telling me the 5-year rule. What is this 5-year rule about? Can you elaborate for that, please, for the court?
Yes, the 5-year rule is the rule that we follow for replacement of dentures.
Is that for an additional set or is that for the 72-hour emergency relief?
I don't understand what you mean by 72-hour emergency relief.
Well, from what I'm reading, DOC Administrative Directory, it says you're entitled to a new set every 5 years. So is that what you're referring to, or are you referring to the 72-hour emergency rule that's saying I need to wait 5 years? Because I'd like you to pull that document up so everybody can see I have to wait 5 years for emergency relief.
Can you parse that out into?
Okay, you stated there's a 5-year rule. This 5-year rule, is that for an emergency relief of 72 hours?
The 5-year rule has to do with dentures.
Is that for an additional set, or is that to fix something under the 72-hour emergency rule?
There's no 72-hour emergency rule for replacement of dentures or repair of dentures.
So if we go back to Administrative Directory, page 3 and page 4, it says emergency relief will be done within 72 hours. So you're telling me that's not DOC's directory? On page 2 of 4, which we were at before, Your Honor, to take judicial notice, that was number 5, paragraph 2. It says urgent care within 72 hours to fix or replace. So this 5 years, where are you coming up with this 5 years? I have to wait 5 years. What is this 5 years? Where does it say in the Administrative Directory that emergency relief for to fix broken dentures you have to wait 5 years? Where are you finding this on your statement to support this so it isn't a penalty of perjury?
Okay, so let me explain. There's no such thing as emergency denture repair.
So there's no such thing about a 5 years to wait to fix broken dentures, is there? Because where are you referring that to? Because I would like to look that up right now.
That is in the dental manual.
The dental manual says it will fix or replace them in 72 hours, and it says
no, it does not.
The Administrative Directory 10.8.4 says that you're entitled to a new set every 5 years. So are you telling this court today that I have to wait 5 years to fix broken dentures? Is that
I'm
your
certainly not
statement?
saying that at all.
Okay, so under penalties of perjury today, do I have to wait 5 years to fix my broken dentures?
No,
So why would you say I have to wait 5 years to fix my dentures?
you have to wait 5 years for a new set,
For a new
and now it's
set,
7.
but not to fix the broken ones, correct? Or to replace them?
Can you rephrase that?
So under penalties of perjury, for my injunction order I had, which you opposed objected saying it was a cosmetic issue, you told them plain and simple, I have to wait 5 years to fix them. Where does this say that in administrator directory, it takes 5 years to fix broken dentures or replace them?
You're saying two separate things, replace
Okay. Where in the
and repair.
administrative
So those are two
directory-
separate
listen to the
statements. I
question.
need you to separate them.
Listen to the question very clearly. Where in the
Okay.
administrative directory does it say when dentures are broke that it takes 5 years to fix or replace them?
It doesn't say that in the Administrative Directive 8.4. I'm looking at it.
Well, 2017, you told the court on your own thing that it was a cosmetic issue and that you told the court I had to wait 5 years. So did you lie then or are you lying now? Which one is it?
The 5 years is to replace a set of dentures.
So that's not to fix broken dentures, correct? Or replace them?
If I can't fix them, you have to wait for the replacement time of 5 years. Or
This guy watched way too many TV drama court hearings before he was incarcerated. Because right now he's just playing the bad guy attorney role.
now it's 7.
So if the dentures are broken, you're telling me a person has to wait 5 years to fix or replace the broken dentures? Is that what you're saying?
I'm certainly not saying that at all. That's
Okay,
what you're saying.
So in 2017, you told under penalties of perjury, it was a cosmetic issue, not knowing my medical background of my stomach and everything. You said it was a cosmetic issue. Yes?
Objection, mischaracterizes testimony and evidence.
Let's go back
Well,
to your-
just a second, Mr. Stanley.
Yes,
Let me
sir,
rule,
Your
because
Honor.
I'm going to rule, Mr. Stanley, I'm going to rule in your
Yes.
favor. If you would be quiet and let me rule on objections, I will. The witness, Mr. Stanley asked, did he say something or not? It's for the witness, not for counsel to answer whether or not he said it. So the objection is overruled. Dr. Cuevas, did you say that?
According to so can he please, instead of adding replace or repair, those are two separate issues. If he says replace and repair, he's combining an issue. Replacing and repairing are two separate issues. If he keeps adding them together, that's two separate things. I can't answer that question.
Okay, I thought the question, excuse me, I thought the question was about a claim that you or your attorney may have called this a cosmetic issue. I thought that was the gist of the question.
Okay, here, let me clarify. He doesn't have a denture. When he first got incarcerated, he didn't have a denture. So we can all agree on that, correct?
We're not arguing that, Your Honor. So objection.
Okay.
We're arguing about fixing or replacing broken dentures.
So can I answer that in two separate statements?
Yes.
Okay, so there's a 5-year rule. Now it's a 7-year rule for replacement of dentures.
So let's take this in baby steps, if I may. So that is the 5-year rule, and that's for so if I have a set of dentures now, I can get another new set every 5 years, correct?
No, now it's 7 years.
Okay, so back then it was 5 years though, correct?
Yes, that was the rule
Okay,
for replacement
so-
of dentures.
So under administrative directory of DOC's policy for medical, under 72-hour rule, if somebody breaks their dentures, do they have to wait 5 years to fix them or replace them if they're that broken?
Can you clarify what the 72-hour rule is?
Absolutely. So emergency medical relief, as it says in the 8.4 directory, page 2 and 3 and 3 and 4,
Okay.
says
Okay.
72 hours emergency medical relief.
It says
So my
urgent
question-
care, just to be clarify that, right? Are you reading that paragraph? Because I just read it. It says urgent care.
Yep, we're at page 3 of 4, and we're at number 6, and it says dental classification.
What exhibit is this?
This is back to the
Great.
integrated directory.
I'm sorry, Mr. Finucane, there's 3. I see your hand signal. Thank you. Okay. Go ahead, Mr. Stanley.
So under the 72-hour emergency medical relief, where does it say anywhere that a person has to wait 5 years to fix his broken dentures?
It says urgent. It says urgent care.
Correct.
And denture repair is not urgent care. That's routine care. Right above it.
That's your claim. But you said you just testified you don't know anything about my medical history, correct?
Denture repair is routine care. Denture repair is not urgent care.
You don't know anything about my medical background for my stomach, do you? Yes or no?
According to the dental manual and the Federal Bureau of Prisons dental manual, denture care is considered routine care. It is not considered urgent care.
So are you aware of my medical background history of my stomach? Yes or no?
I may have reviewed your chart at some point in the past, but again,
did I ever sign a waiver
denture
for you
care.
to look at my medical chart of my medical needs?
Can you repeat
Have
that?
I ever gave you a waiver to have you look at my medical chart? Because it's a HEPA violation if you looked out without my
Objection,
consent.
he's his dentist. It's a
Mr. Stanley,
ridiculous
just ask questions.
Okay. So again, you have no acknowledgement of my medical issues of my stomach, correct?
I reviewed your medical history whenever I saw you.
But you don't have any access to my medical history about anything to do with my body besides my dental chart is the only thing you can review, correct?
That is incorrect.
So you have access to my medical chart?
Your
Because
medical
that's a
chart is
HEPA
part of your
violation.
dental chart. That is correct. I have
Dental
access
chart.
to it.
Correct, but you don't have anything, you don't have any legal rights to my medical history besides my dental, correct?
Objection, argumentative. It also calls for a
It
legal
is not, it's a
conclusion.
HEPA violation, Your Honor.
I'll allow it. Go ahead, doctor.
I have going over your medical history is part of being a dentist. I do that whenever I see a patient.
So if I have AIDS or something like that, you have acknowledgement, you have access to that medical acknowledgement? Are you saying that on the record?
If you scroll down to 8.4, it says HIV on it. HIV exam level 7, that's AIDS.
Correct.
I have
And
access
you-
to that.
and
I
you
must
have-
know that.
You have a right to under the HEPA law. Did I ever sign a waiver for giving you right to extract my medical records?
Your medical records are part of your dental records. I have to review them
Absolutely
as
not.
part of
Under the
seeing you.
HEPA law,
Objection,
absolutely
argumentative,
not.
All right,
accident.
Mr. Stanley, if you ask a question, the witness is
Okay.
entitled. Mr. Stanley, if you
Yes,
ask
Your
a
Honor.
thank you, sir. If you ask a question, I'm going to allow the witness a reasonable opportunity to answer it. You interrupted him. So go ahead, Dr. Cuevas, finish your answer.
Yes,
We're back to
as
the
part of being a
74.
dentist, if you
Mr.
had
Stanley,
AIDS or
Mr. Stanley.
HIV,
Go ahead, start again, doctor.
yes, as part of being your dentist, if you have AIDS or HIV and you are coming to me for treatment, I must review that information along with all the other information and be familiar with it because dental treatment does have an impact of people with HIV and AIDS. If you look at 8.4, it says HIV examination. It's on, I don't know what page 4 of the document.
Okay, so
A known HIV infected inmate shall be
Okay.
referred to and examined by the facility dentist
I'm gonna
within
give you
72
that.
hours.
I withdraw the rest of that question, okay, with HIV. But again, under HEPA law, you have no right to my medical background history, do you?
That is incorrect.
So you have a right to all my medical history?
Correct. It's part of your
Under
dental
HEPA?
chart.
So you're stating that today under penalties of perjury, correct? That you
I
have a
have to
right to
review
my
your medical
file?
history. I have to review your medical history. I have to review your
No, that
medications.
is not
I have
the
to
question.
review your
Mr.
father's
Stanley,
Stanley.
Mr. Stanley,
I
Mr.
withdraw
Stanley,
the question. Now,
Mr.
listen to the
Stanley,
question.
Mr. Stanley,
Yes.
listen to me. When you ask
Yes.
a question, I will give the witness a reasonable opportunity to answer the question. Please do not interrupt the witness.
Okay.
Mr. Stanley,
withdraw that
Mr.
question, Your
Mr.
Honor.
Stanley,
I
Mr.
withdraw
Stanley,
the question.
Mr. Stanley, listen to me.
Yep.
The witness did not complete his answer. I'm going to allow the witness
And I
to complete
withdrew
it.
it, so there's no reason to carry on. So I want to move to my next question.
Please do.
Okay, so under the HEPA law, do you have a right to my medical file?
Objection asked and answered.
Sustained.
No,
Next,
because I withdrew it, he never answered the question.
Mr. Stanley, I've sustained the objection. Your next question, sir.
Okay, under 8.4, page 3 of 4, paragraph 9, line 9, it says dental emergency service. Did you give me emergency dental service?
You didn't present with emergency.
Excuse me?
You did not present with emergency.
So in 72 hours, you did not see me?
You did not present with a dental emergency.
Well, how can you make that determination if you never saw me?
I'm the dentist. You never came in with a fractured jaw. You never came in with giant facial swelling. You didn't come in with any myriad of respiratory distress.
So if
You
you
came in
never
for
saw
routine
me, you
treatment.
never
Mr.
knew-
Stanley, if you ask a question, I will allow the witness a reasonable opportunity.
Okay.
Mr. Stanley, listen to me. If you ask a question, I will allow the witness a reasonable opportunity to answer it. Please do not interrupt. Dr. Cuevas, would you continue with your answer?
In all the times that I saw you, you never presented with a dental emergency. You presented with routine dental care.
Okay, so my next question is, so did you, if you say you had access to my medical file, are you aware of my ulcer and my medical needs of my stomach? Then you were aware of that, correct?
I
Yes or
reviewed
no?
your chart and saw
Yes or
no
no?
emergency issues.
Yes or no? Were you aware of my medical stomach problem? Yes or no?
What stomach problem are you specifically referring to?
You said you had access to my medical file and you reviewed it. So you stating under oath today, penalty to perjury, you were aware of my medical issues of my stomach problems, correct?
Objection assumes facts not in evidence.
No, yes or no? You said you had my file. You said
Mr. Stanley, would you rephrase the question?
Okay, you said under oath, penalties of perjury, that you had full access of my medical file. So when did you review my medical needs of my stomach problems that I've had prior to this 72-hour emergency relief?
Two things. You never presented with a dental emergency.
Well, you just said that you reviewed my
That's the
medical
first part.
file.
Mr. Stanley, you
Yes.
asked two questions, and so the witness isn't, which is improper, but we let it go. So the witness is entitled to provide answers to both parts of them. Please do not interrupt the witness. Dr. Cuevas?
Okay, so again, you never presented with a dental emergency. That's the first thing. Number two, when I reviewed your medical history, there's no contraindications for me treating you in your dental record. So I could have treated you for your condition for dental wise.
But you chose not to, correct?
I made clinical decisions based on your history, correct?
So basically then, you overlooked my medical needs of my problem of my ulcer in my stomach, that you said you had my medical file. You took upon yourself, in your individual capacity, to go outside your job authority, job description. Listen to the question now very clearly. You
Objection,
stated
compound
under-
question.
Sustained.
Here's the question.
Sustained. Mr. Stanley, you
Can I
asked two.
finish asking my question?
Yeah, no, because you already asked two questions. You can only ask one at a time.
Right, so let me finish the question before you tell me it's been asked or answered.
Sir, I just ruled. Now ask one question.
You didn't even let me finish the question, so how are you telling me? it's
Sir,
been
I'm
asked
not going to
or answered?
argue with you. All right, next question.
So where did you find in my medical chart of my medical conditions of my stomach that it was a cosmetic issue? What page and where in my medical file did you find this?
I don't understand what you mean.
You said you have access to my medical file. So tell me where in your medical file, under my medical conditions of my stomach, that you chose that it wasn't a medical emergency relief, that I could not eat.
Okay, So let's break that down into several different answers. Number one, you never presented with a dental emergency. Number two, you didn't have dentures when you came in, so you spent not over 9 months
That's not my
before you were
question.
sentenced. Okay.
That is not
All right.
my question.
All right,
I
Mr.
have
Stanley,
the
Mr.
answer.
Stanley, Mr. Stanley, you ask a question, the witness
So
is
why
entitled.
answer
Mr.
it when I
Stanley,
name the deal?
Mr.
That's not
Stanley,
even the question.
Mr. Stanley, please don't interrupt me.
So
You
can we
asked,
stay on
Mr.
track then?
Mr. Stanley, please don't interrupt me. You asked a question. I will allow the witness a reasonable opportunity to answer it. Please do not interrupt the witness. It'll be for me to determine whether the witness is answering the question. So far, I have found that the witness has been responsive to the best of his ability to answer your question, so I'm going to allow him a reasonable opportunity to answer. Dr. Cuevas.
Okay, so you came into the Department of Corrections without dentures.
That is not my question. Objection.
Okay.
Mr.
I asked you
Stanley,
about my medical
Mr. Stanley,
file.
Mr. Stanley, please do not interrupt the witness.
Then answer
What?
the question. That was
Mr.
not the
Stanley,
question. The question
Mr.
on the
Stanley,
record was,
Mr.
where in
Stanley,
my medical file
Mr.
did you
Stanley,
see
please
it was
don't,
not a
Mr.
medical
Stanley,
emergency?
Mr. Stanley, please don't interrupt me. Do you understand that?
Well, you clearly are
Yes
not
or no,
understanding
sir?
my question.
Do you
I didn't say
understand-
about when I came into
Mr.
jail.
Stanley, Mr. Stanley, do you understand the rule, do not interrupt the court?
Well, do you understand the rule of due process?
Mr. Stanley, answer my question. Do you understand what it means not to interrupt the court?
Well, it must mean the same answer.
Mr.
of due
Stanley,
process is
answer my
violated.
question. All right,
I
Mr.
said
Stanley,
with your own question.
Mr. Stanley, here's what I'm going to say. If you don't follow my directives, I'm going to say that you have waived your right to call this witness and examine him because you're not following the rules. The rules are very simple. I'm allowing you some latitude. I've actually overruled some of the defense objections. It's very simple. Just let me rule when I'm asked to rule and let the witness answer when he's asked a question, okay?
Okay, I'm withdrawing the question and I'm asking a brand new question. And this is my question. Where in my medical file did you see under my medical issues in my stomach that it was not a medical emergency? What page and what document are you looking at that you looked at my file?
I don't understand when you keep saying medical
You said-
emergency. If you had a medical emergency, you would have gone to the emergency room. You don't have a medical emergency and see the dentist. That's contraindicated. That's
You said you
contraindicated.
have my file, correct?
I don't have it sitting in front of me right now.
You said you reviewed my medical file, correct?
Correct, I did.
So were you aware of my medical needs of my stomach? You
I
said you
don't
reviewed the
treat-
file.
I don't treat
Let him
stomachs.
answer the
I'm a
question,
dentist.
Mr.
I
Just
treat-
a second, Doc.
I
Just a
treat
second,
dental
Doctor.
conditions. Sorry.
Yeah.
So, a yes or no question? Were you aware of my-
Mr. Stanley, don't interrupt me. Do you understand that?
As well as I understand my due process violations being violated, I sure do.
Good. All right. So I'll expect that you will not interrupt me in the future. And if you do, I reserve the right to say that your examination of this witness is complete because you're just not following the rules. So you interrupted the witness. If you ask a question, I will allow the witness a reasonable opportunity to answer the question. This witness has not been verbose or loquacious. He's answering the questions directly. You may or may not agree with the answers, but I find his answers to be reasonably responsive. So I'm not going to allow you to interrupt his questions. He's answering the questions. Okay?
So then, where is the answer to my question about what medical file are you looking at of my stomach problems that said it was in a medical emergency? What page, what document are you looking at to make that determination?
The fact that you came to the dental clinic
That's not my
means you don't have
question.
that.
I'm asking you of the medical
Mr.
file.
Mr. Stanley, you are interrupting the witness. Do you understand what that means?
I want him to answer my question.
Do you
I'm
understand,
not asking about-
sir, answer my question. Do you understand what it means not to interrupt the witness? You understand that?
Yeah, can I get my question answered
Right.
then?
All right. So do not interrupt the witness. Do you understand that?
Answer the medical file question.
No,
Now can I
you,
take the
Mr. Stanley, you interrupted the witness. Allow the witness an opportunity to answer. Do you understand that?
Go ahead, let's hear what you got to say again about my medical file of my medical conditions of my stomach only.
Okay, so number one, if you are coming to the dental clinic, that means you're not presenting with a medical emergency, because if you were, you'd be seeing the medical providers and or going to the emergency room. So that's number one. So you didn't have any medical emergency when you come to the dental clinic. Number two, I'm a dentist. I treat dental conditions. I review your medical conditions, and if I have contraindications for dental treatment, I don't give you dental treatment. If you have medical conditions and you start bringing up medical conditions, I oftentimes tell inmates or patients that seems to be a medical issue. You should seek treatment with your medical provider.
Okay, are you done?
Was there? Yes.
Okay, so again, on the administrative directory, page 2 of 8.4, it says medical emergency relief in 72 hours, and it's under the caption of dental screenings. So did you see me in 72 hours of this emergency relief when it says for dental care on 8.4 directory? You saw me in 72 hours, yes or no?
No, because you never presented with a dental emergency.
So basically, with my paperwork that I kept submitting to you, where you keep saying that I'm not indigent or that pieces are missing. So if we could, for the court clerk, madam, on my exhibit 1, from 1 to 17, can you pull up page 1, please, if you may?
Certainly. Mr. Stanley, so I think we've previously discussed that the numbering is just slightly off because of the cover page. So I'm going to display page 2, and can you confirm that this is the right document?
I'm sorry, which exhibit are we on?
I believe plaintiff exhibit 1, page 2 of the PDF.
I don't see it. Okay, here we go. No, that's not it. I'm talking, oh, wait a minute. Yup, that's the one I'm talking about. So if we review this document, for the record, this is an inmate request form, CN 9601. Is that correct?
If you're looking at the same document I am, that's dated 10/5/2017, that has your name on it and your inmate number, that is the document I'm looking at right now.
Okay, so basically it's reading in my own handwriting, and I signed it. 5 times waiting to dental of my dental tops are broken. No answer. Need new dentures. So that's on 10/5. So that I'm stating that's the 5th time. So if I'm stating that on 5 times, if we scroll that up a little more for the record, please. Somebody wrote on here, not indigent. So you mean to tell me I have to be indigent to be seen by medical?
No, certainly not.
So why would somebody write dental staff, not indigent?
The person probably looked up to see if you were indigent or not, but you can certainly see me when you're indigent. I see all indigent patients.
So basically, by my own handwriting, and not hearsay, because that's my statement with my signature on, stating that this is my 5th request now, writing to be seen. So if I'm saying 5 times, it clearly I was not seen in 72 hours, correct?
You're discussing routine care, which is not urgent nor
I did
emergent.
not say that. We scroll that
No,
back
I'm
down
saying
again.
that because I make the clinical decision about that. Dentures are not emergent care.
Madam of the clerk, can you scroll that down? Thank you. So I'm going to read in my own handwriting. 5 times waiting to dental of my dentures top are broke. No answer. Does that sound like that's just a routine, or does that sound like something that could be an emergency of 5th time, no answer, broken dentures?
Still not an emergency. Just because you want it to be doesn't make it so.
That is routine.
That's routine. So
Yes.
basically, you make me wait 5 times on writing is routine?
Dentures are routine.
Wait a minute, let's go back to the request now. Answer the question. You're telling me it's routine to write 5 times before I get an answer?
It is routine denture care. Denture
That's
care
not-
is routine care.
Listen to the answer, yes or no. Is it routine to make an inmate wait 5 requests, yes or no?
I don't make determinations about when inmates
Listen
are,
to the
get their
question.
answer.
I'm asking
We-
you
we
questions.
answer-
You just said it's routine.
Let him
Why-
finish his answer.
I don't have any routine about responding to inmate requests. When
So
when I get them and I can answer them, I answer them. If I get a request 5 times from the same inmate within 2 or 3 days, and it's a weekend, or I'm on vacation, or I'm in another facility, obviously I cannot answer them.
So if we have other request forms that backdate from dates over and over and over of different dates of medical staff that you again signed, they clearly are not within days apart. Would you agree to that?
Objection, assumes facts not in evidence. It has not been established that he signed this. In fact,
Your
he didn't.
Honor, all these exhibits have been entered in as a full
All right.
exhibit.
So ask,
One-
excuse me, if you want a ruling, I'll try to make one. You can ask about the exhibits.
Your Honor, exhibits 1 through 17 are entered as a full exhibit. And
Right.
you can see, I want the court to take judicial notice that there's 17 different docket numbers, 17 different pages requesting for medical relief. Can the court acknowledge that as a full exhibit?
Well, I do have 17 pages to exhibit 1, but this is not the time for legal argument. Just ask questions about
I
facts.
am.
What?
So
No, you're
again-
not. Excuse me, sir. You're just asking me for information. Ask the doctor about what he did.
I'm asking you to take judicial review of this document. So
Well, it's
basically,
It's
on
a
an
full
inmate-
exhibit.
On an inmate's request form, writing 5 times, where do you determine that it's not indigent and it's no medical need to be seen if a person's writing you, telling you 5 times waiting for dentures?
Objection, assumes facts not in evidence.
Right.
He has
He
not
didn't-
established,
he
he
didn't-
responded to this.
Right. He didn't. That's true too. But he didn't determine whether you were indigent or not.
He says right here on the inmate request form, not indigent.
Right. But you assume that in the question. So ask another question about what he
Okay.
did. Ask
So
what the
basically-
doctor did.
With DOC's Administrative Directory 8.4, again, back to waiting 5 years. It does not say you have to wait 5 years to fix or replace broken dentures. Does it say that?
Okay, let's parse those two because you keep adding fix or replace into the
Okay.
sentence.
So
Okay,
listen to the
so-
question then. I'm gonna walk you.
So in the
through
dental
question.
manual,
No, he's going to answer the question, Mr. Stanley.
so
Okay.
in the dental manual, there's a rule that replacement of dentures, you have to wait 5 years from the last time
That's fine.
you got them,
That's
but now
fine.
it's 7.
Mr. Stanley, don't interrupt. Go
I
ahead,
need you to
doctor.
clarify that.
Okay,
Just
so
let him answer the question, sir.
okay,
Go
so
ahead, doctor.
in the dental manual, we have a policy that says there's replacement of dentures. You have to wait 5 or now it's 7 from the years from the last time you received a set of dentures from the Department of Corrections.
So.
Now, there
here's
is
my next
no,
question now.
there is no
Mr.
time
Stanley,
period.
Mr. Stanley, thank you.
There is certainly not written in the dental manual that a patient must have their dentures repaired in 72 hours. That is nearly impossible to do considering this is a Department of Corrections facility. People take vacations. The lab is not open on the weekends. When you do denture repairs, the dentures are sent out from the facility to central office, which is then picked up by the denture lab.
So where does it say in the Administrative Directory, 8.4, that if a person breaks his dentures, he has to wait 5 years to have those fixed or replaced? Because from what you're
Nowhere.
telling me and what I'm reading, 2-part question here. You're telling me 5 years and now it's 7. Is that to fix them or is that for an additional set? Let's get that ground rule right now? Is that to replace them or is that for an additional set?
Assuming replacement, because if you need a new denture, that means the denture you have doesn't work.
Well, couldn't it be too that if your dentures don't fit, that you get a new set every 5 years? Yes?
That's not the way we practice, no. You review the denture, see if it's serviceable.
Okay, so basically if somebody's mouth has changed, within 5 years, they're entitled to another set of dentures, yes?
When you evaluate the denture to see if it's serviceable.
And again, so if it doesn't fit anymore and it's unserviceable, every 5 years he can get a new set, correct?
If you get approval from the dental director.
Correct. So where in the administrative directory does it say if dentures are broke, you have to wait 5 or now 7 years? What page are you referring to that?
It's not in the AD, it's in the dental manual.
And where does it say that in the dental manual that a person, if he has broken dentures, he has to go without dentures 5 years? What page, what document? Because I'd like to see that on the screen.
I think it's 1.6. There you go. Oh, you had it. So scroll down page 1. So Exhibit D. All right, scroll down. Scroll. Okay, here we go. So on Exhibit D, page 4.
Can you put it on the screen, please? Okay.
Yeah, all right. So administrative directive, it's the dental manual E6.01, oral care services.
Yep, what line are we looking at? Replacement?
Correct. It's
So
page
replacement
4.
7 years. So now my question to you is, listen to it very carefully. Where in this paper that you're showing me, if a person breaks his dentures, broken them now, where does it say you have to wait 5 years to fix them?
It doesn't say that there, but
Well,
if
where
it's
does it say I have
serviceable,
to
we
wait?
repair it.
So where does it say a person has to wait 5 years and has to go without dentures 5 years if they break? Where does it say that?
It looks at, there's denture repair, scroll down a little bit, right there. Repair of dentures shall be provided to sentenced inmates and has 12 or more months left on their sentence.
Okay, so if I have a 30-year sentence, does that apply to me?
Of course.
So I have 12 months or less?
Yes, if you have 11 months left for you to go home and your denture breaks, you do not get the denture repaired.
Okay, so that doesn't apply to me if I have a 30-year sentence then, correct?
Correct.
So basically, my discharge is 2043. So that line you just said to us has nothing to do with what my question is, correct?
Correct.
Okay, so where in this document that you're showing me that if a person breaks his dentures, he has to wait 5 years to fix them? Where does it say that?
If the denture is unserviceable, then and we can't repair it, then you have to wait 5 years. And now
Tell me where it says that. Where does it say that? When it's broken, he has to wait 5 years?
Where it says replacement of existing dentures shall occur only once in any 7-year period from the date of delivery of the existing dentures. Exceptions shall be considered when the absence of dentures shall create an adverse condition that could jeopardize the inmate's health. To be eligible for replacement of dentures lost in transit, misplaced, or stolen, an inmate must file a formal incident report with custody, documenting the inappropriate disposition of the denture. Incident report demonstrating custody's acknowledgement of loss must accompany prosthetic requests submitted for approval for it to be considered.
So now listen to my question again, because you wasted the court's time and my time. So
Objection,
where
argument.
Sustained. Mr. Stanley, just ask questions.
All right, where in this paper does it show if you break them, you have to wait 5 years? Because you just said a replacement of every 5 years. Where does it say if they're broke, a person has to go without dentures 5 years? Because it doesn't say that.
If you can't repair it, then it's a replacement.
The word replacement
So where does it say a person has to go 5 years without dentures if they break? Show me what line that
Objection
says.
asked and answered. We've answered
Right.
this.
Right, Mr.
No,
Stanley.
you have not answered that question. I'm
Yeah.
asking you, if I have no dentures, where does it say I
Mr.
have to
Stanley,
wait 5 years?
Mr. Stanley,
Yep.
the objection's been ruled on, it's sustained. Next question.
Okay, so where in this document does it show if I have no dentures, I have to wait 5 years for a set of dentures?
Where it says replacement.
No, if I don't have dentures, where does it say I have to wait 5 years
Oh.
to get dentures?
No, it doesn't. You have to be sentenced and have a sentence of at least, here. Okay, the inmate's earliest release date is minimum of 12 months from the time of first impression is taken. Prosthesis construction.
Okay. So if I've been sentenced nearly 13 years and I've gone without dentures now nearly 10 years, where does it show in this document I have to wait all this time to get dentures if I don't have any?
It doesn't say that. If you,
It doesn't
according,
say
if
that,
you
does it?
have, if you have dentures.
Mr. Stanley, let the witness finish his answer. How many times do I have to tell you that? Go ahead, Doctor.
Let me describe the process to you. Okay, you come into the Department of Corrections. This may sound familiar to you. You don't have any teeth, you don't have any dentures, okay? The rules were you get examined, you look at all the person's teeth, make sure all the other teeth are in good condition, make sure that they don't need any other work, any other fillings, any other extractions, anything like that. Once they are stable, they need no other dental treatment, extractions, fillings, or whatnot. Then you can go ahead and submit a request to the dental director for approval to go ahead and make dentures for that patient if the patient also qualifies. There's also certain rules about numbers of missing teeth. If they have stable occlusion or with 8 or more posterior contacts, then that person doesn't qualify for dentures. In your case, when you had 0 teeth on the top and you were missing many teeth on the bottom, once you had all your other dental work done, which happened with you, you had other fillings that needed to be done, then the request was submitted to the dental director. The dental director evaluates the case, looks at the chart, and says, okay, the person appears to qualify for dentures. When do they discharge? If they discharge in less than 12 months, then we do not start a denture. If they discharge greater than 12 months, then yes, we get approval from the dental director to move forward and make dentures. And then making the dentures is a multi-step process.
So that whole statement has nothing to do with the question I just asked you about. I already had the dentures. They were broke. Where does it say in this paperwork that you're showing I have to wait 5 years to fix them?
Objection asked and answered. Can we please move on?
Mr. Stanley, we've already been over this subject.
You
Do you have
didn't,
another?
because he didn't answer it. He's answered about when I come to
He has, Mr. Stanley, he's answered it. Can you have another subject you want to
I
ask
do,
about?
and I'm gonna go back to the question. Where in this document does it show I have to wait
Objection.
5 years to fix my broken dentures?
Right.
I'm not
Objection.
talking about when I come in, when I
Right.
get examined, what's wrong
Right.
with my teeth. We already have broken dentures.
Mr. Stanley, I've ruled that you've already asked and that question and it's been answered. So let's go on to another topic.
So back to the administrative directory again, it says 72 hours, so for emergency relief. So if you didn't see me in 72 hours, how are you determining I didn't have a medical issue about my stomach where I needed teeth?
Objection asked and answered. You just asked the same things.
Right, Mr. Stanley, we've already been through this. Let's go on to
All right.
another topic.
You said you had my medical file. So what page are you looking at of my medical file that shows you my medical problem with my intestines? That you
Objection asked and answered. He's just
Mr.
asking the same question.
Sustained. Mr. Stanley, we've already been through this. Let's go on. Do you understand what I mean when I say let's go on to another topic?
Do you know what the HIPAA law means?
Sir, answer my question. Do you understand? Okay, good.
Well, this is a new question.
Well,
No, nobody knows what the HIPAA law is. The HIPAA law does not exist.
it's not a new topic. We've been over these topics over and over.
We
You
have
keep
not.
asking.
This is a law in place.
Mr. Stanley, you're interrupting me. Don't interrupt me. Do you understand that? Good. We've been over these topics. You ask the same questions over and over. Let's move on to another topic. Ask him about when he saw you and what he did. That's what I need to know. And after
Okay,
all, I'll just
yeah.
add this, that this is a trial to the court. So,
Well, it was supposed to have been a jury. Let's get that straight.
Mr. Stanley, listen to me. Please don't interrupt. Do you understand me? This is a trial to Mr. Stanley. Don't interrupt. This is a trial to the court, and you should listen to what the court wants to hear, because that's the most important stuff or information that I need. So what I need to know are the facts about what this doctor did when he saw you. So why don't I ask about that?
Okay, back to your answer of March 8, 2019, your answer of special defense. First special defense, you said.
Objection, reading a document, not an evidence.
Well, the answer would.
Can I finish answering my question before I get ruling and
Mr. Stanley, please don't interrupt me. I'm about to rule in your favor. Why do you keep interrupting me when I rule in your favor? If you just restrain yourself a bit.
You don't even know what the answer is of my question.
Mr. Stanley, don't interrupt me. Mr. Stanley, don't interrupt me. I was about to rule in your favor. If you would just restrain yourself a little, this might go a little easier for you. I was going to say that I will allow you to ask about the answer because that's essentially the defendant's admissions. So go ahead with your question.
So before I get rudely interrupted from everybody, back to your special defense of you under penalties of perjury, you said the plaintiff complaint fails to state a claim upon which relief can be granted. So how can it not be granted that I'm asking for $100,000 of your negligence? And two, why can't it be granted about a medical relief due to my medical issues of my stomach for new dentures because I'm unable to eat?
Objection, compound question.
Sustained.
All right.
It's also not.
One at a time then. Where in your statement you're claiming that I'm not entitled to relief?
What are you talking about?
Your special defense, first special defense question. And I just read it to you. So how are you stating I'm not entitled to granted, that I've never stated a claim for relief? Here's the question. Have I or have I not for 12 and a half years asked for new dentures?
You have asked for dentures and they've been denied. And then they were ultimately approved. And then you received dentures.
Correct? Listen to the question. Yes,
Mr. Stanley, don't lecture the witness. You interrupted the witness twice, so I did not hear his answer. I'll ask the witness to answer the question again, doctor.
Okay, so he asked for dentures. They were initially not approved. They are eventually approved by the dental director. He eventually got dentures made. And you currently have dentures.
Who denied me my dentures to be fixed? You, or give me somebody's name that denied me?
Dr. Benoit, the dental director.
And what is his name that denied me?
Dr. Benoit, the dental director.
So why do I?
It was in the appeal for the grievance. I don't understand what you're talking about.
Well, I filed a grievance about this because the final process would be, when I'm not getting anywhere with the dental, to file a grievance. So I filed a grievance saying that I'm unable to eat, and you signing the document stated that I'm not entitled to the dentures. I don't see anybody else's name but you signing on a grievance form, and you're not a grievance coordinator.
Objection. We're doing ask and answer.
Mr. Stanley, don't make statements, just ask questions.
So on your first statement, you stated statement claim for relief cannot be granted. How can it not be granted that I'm entitled to new dentures of my broken dentures?
Oh, because dentures have to be approved by the dental director. The dental director makes decisions on approval. I submit the denture request for approval. It either gets approved or denied.
And did you deny that from the very beginning on all these requests?
I evaluated the situation considering what I saw at the time, and I made recommendations on treatment. I treated you appropriately. Any denials of dentures ultimately come to the dental director.
So the dental director didn't state on your motion to strike April 30th, 2018, there was a cosmetic issue. Did the director say that? Or is that your sworn statement under penalties of perjury?
Well, let's just put it to you this way. If you can function now and function for many, many, many years without dentures, and you function for many, many years without, and you can conduct every single
Mr.
daily...
Stanley.
Answer the question.
Mr. Stanley, don't lecture the witness.
Then answer my question.
Mr. Stanley, don't interrupt me. I'm allowing the witness a reasonable latitude to answer questions. I find he is staying within that latitude. So, Doctor, if you would continue with your answer.
And the life without dentures or with dentures, dentures can be considered aesthetic. If they're non-functional, if you're not using them every single day, then yes, they are aesthetic.
So let's get one thing straight. Yes or no? Are you a doctor to do with anybody's medical issues of stomach problems? Yes or no?
Certainly not.
Okay, so you have no ability to rule that it's just a cosmetic issue if I have a medical problem.
Argumentative, assumes facts not in evidence.
All right, Sustained. Rephrase the question.
Yes, so under penalties of perjury, you stated in 2018 that it was a cosmetic issue. That is your statement that you stated under penalties of perjury, correct?
If you're not using a denture every single day and you're only using it for visits, then
Mr.
yes.
Stanley, don't excuse me. Mr. Stanley, don't interrupt the witness. Do you understand that?
Well, then he stick to the script.
Mr. Stanley,
That's
Mr.
not the
Stanley,
question.
Mr. Stanley, do you understand what it means? Don't interrupt the witness.
Are you going to give me the respect when I ask?
Mr. Stanley, Mr. Stanley, answer my question. Do you understand what it means not to interrupt the witness?
Well, I'm just referring to due
Mr.
process.
Stanley,
I'm just going by what you do.
Mr. Stanley, do you understand what it means not to interrupt the witness?
The same as due process, I guess so.
Okay, good. So don't interrupt the witness. If you keep doing this, I'll say that you've completed your direct examination, okay? Go ahead, doctor.
Okay, so yes, if you're not using your dentures every single day, then they are essentially aesthetic.
So, are you in my cell every day to see if I'm using them or not? Yes or no?
No, I'm glad I'm not in your cell.
So yes or no? Are you a medical examiner of my stomach? Yes or no?
No, I'm a dentist.
So you have no knowledge of my medical problems with my stomach? Yes or no?
I can certainly say that I've never gotten a
Yes
referral
or
from
no?
a medical provider saying that you have a dental emergency.
All right.
It's yes or no. What's the
All right.
answer?
Doctor, yes, no, or I can't answer it yes or no.
Okay, what's the question again?
The question is, do you have any acknowledgement of you being a medical examiner to my stomach? Yes or no?
I'm not, I am a dentist.
So you're not a doctor for anybody's stomachs? Yes or no?
No.
So you have no acknowledgement, and you can't state today under oath the penalties of perjury of my medical problems with my stomach? Yes or no?
I reviewed your medical history and
yes or no?
Your dental.
So
Well,
yes,
I
so
can't
doctor,
answer that,
yes,
then.
yes, no, or I can't answer yes or no.
I can't answer that.
Thank you very much. So basically then, under penalties of perjury, you lied either then in 2018 or you're lying now. Which one is it?
Objection, argumentative.
Sustain. Objection sustained. Next question.
So basically, you had no acknowledgement of my stomach, but you stated under oath under penalties of perjury, it was a cosmetic issue. How can you state that?
Objection, asked and answered, and at this point, I would ask that he either move on and actually move on, or that we conclude his direct examination. This is getting ridiculous.
Okay, so it is ridiculous, because if you have no acknowledgement of my stomach.
Mr. Stanley, you can't make statements. You can only ask questions. That was the first
So
one.
the question is, you didn't have no acknowledgement of my stomach problems back then, correct?
No serious stomach issues that will interfere with dental treatment. No.
As far as you knew, because you're not a medical doctor, correct?
I reviewed your medical chart.
But you've never reviewed my stomach problems. You just stated that under oath.
Two things. I reviewed your medical chart and there was no contraindications for dental treatment.
Well, so you say, but you cannot produce that document of my medical records under HEPA violations. Is that correct?
Objection. Can we move on
All right,
from this?
sustained. You've exhausted, Mr. Stanley. All
There's
right,
two
go ahead, Mr.
questions.
Stanley.
There's a yes or no question. Were you lying in 2018 saying it was a cosmetic
Objection,
issue?
argument.
Are you lying today?
All right, Mr. Stanley,
about my medical issues?
Mr. Stanley, we've exhausted this. Mr. Stanley, we've
Yes,
exhausted.
sir.
Thank you, sir. We've exhausted this topic. Unless you have any further questions, then I'll say direct examination has been concluded.
I have many questions still to go, Your Honor.
All right, let's ask about what the doctor did when he saw you. That's what I wanted. That's what I'm telling you. That's what I want to know.
I'm moving on to my exhibit list, if I can walk it through it. This is my case, my exhibit list that you entered as full exhibits. So
Right.
Can I proceed in my own format?
To a certain extent, but you are going into areas that don't relate to the complaint, and it's my obligation to
The complaint-
keep Mr. Stanley, please don't interrupt. It's my obligation to keep this trial on track. So far, we really haven't talked to the doctor about what he did when he saw you, and that's what I need to know to decide this case.
All right, when I was in your office with my dentures being so thick, did I, once again, just for the record, I had no access to any power tools, correct?
No, you did not have any of my dental tools in the dental office. That would be a security violation.
So how did my dentures then get ground down in your office in front of me while you holding the medical tools?
I've never adjusted your denture.
So you never ground my dentures down with a Dremel tool?
No, and my records will reflect that.
Your records or a video will show this?
My dental records, my clinical notes.
So basically your notes are not a video that will show you with my dentures in your hand altering my dentures, is that correct?
Of course not, because I never altered your dentures.
You most certainly did, and that's not hearsay, that's my statement.
Objection, argumentative.
Just ask questions, Mr. Stanley.
So then how did my dentures get ground down when in your office and I walked out with the dust all over me from my dentures? Who did it? Who ground them down then if I didn't do them?
Again, according to
It
my
was
clinical
clear-
notes and whatever I did, it's written it down in my clinical notes. I never adjusted your dentures.
So there's no video of this, is that correct?
There's certainly no video of me adjusting your dentures. That is very correct.
So is there a video that we can get the recording from your office?
No,
So there's no monitors or no cameras in the medical office?
in the dental office, there's no cameras.
So why should
And
we
it
take
certainly
your
wouldn't
word-
show me, it certainly wouldn't show me adjusting your denture because I never adjusted your denture.
Well, if there was a video showing you that you with a die grinder and a Dremel tool in your hand grinding my things down, wouldn't that be relevant to this case?
Again, I never adjusted your denture. My clinical notes showed that clearly.
Your notes could be fabricated too though, correct?
That is incorrect. That would
So
be
you
against
mean to tell me
dental
we're
practice.
believe your notes over my notes?
Number one, I'm a clinical dentist. I write down what I do as my clinical note. That's part of being a dentist. Whenever you see a medical provider, they write down their notes. You write it down after you're done with the appointment. You write down what you see, what you do.
So does
That's
that
part of
mean
being a
you don't
dentist.
lie? So where in your
I didn't hear
document
that.
says under sworn oath that you're not gonna lie? Where's it say that?
Can someone clarify what he means?
Yeah.
I don't
so you
understand. I don't understand. Excuse me. I don't understand the question. Ask another question about what he did. Go
So
ahead.
basically, are we supposed to believe your records over my records when I'm the one with no dentures?
Correct,
Miss-
because I'm
Miss-
the dentist
Miss-
in the Department of Corrections with the license.
So basically, you can lie and get away with it, and you're telling me that I'm not telling the truth?
Objection, argumentative. There's no foundation.
Mr. Stanley, just ask him what he did or what
Are
he
you
saw.
calling my records and me going without dentures a lie?
Every single note that I've written, I wrote it.
I asked you about my records. Stop twisting the thing. I asked
He's-
you, are all my files that I found with this case for exhibits, are you telling me that my statements are a
Miss-
lie?
Mr. Stanley,
Yes.
he's not, Mr. Stanley, whatever the answer was, I don't allow one witness to comment on another witness's credibility, so it's not a proper question.
Why should I believe your statements over my statements then?
Sir,
Objection.
just ask him. It's my duty to decide who to believe in this case. So just
Okay.
ask. So excuse me, sir. Just ask him what he did, what he saw when he, what he observed when he saw you, what he recommended, what sort of treatment did he give? That's what I want to know.
Have you ever reviewed my broken dentures?
When you came in for if we could go to my clinical note.
Go, absent objection, go ahead.
Do you mind
B is in
providing?
Bravo.
Thank you.
Okay.
It's on page 72 of Exhibit B.
Right.
Okay, let me read it to you again. Patient seen in response.
I'm asking you a question.
I'm reading my clinical notes.
Okay, go ahead.
All right. Patient seen in response to grievance. Patient claimed that CU broke. Patient claimed that CU pieces were thrown out by DOC during shakedown. Patient also claims he has a portion of his CU. Did not have portion of this at this visit. Patient vacillated between having denture portion with 3 teeth and 8 teeth ? Suggested to patient he file a lost property form with DOC to determine final disposition of this complete upper CU. Still within 5-year rule from 10 December 2014 appointment. Grievance completed.
So again, you're not a grievance coordinator, correct?
No, I'm the dentist who answers grievances.
Okay. So again, I never consented to your document that you're reading to the court now as considered hearsay, because I've never signed off on that. Where on that document?
Objection. This is a full
All right.
exhibit.
See on this
All right.
document where my signature is.
Mr. Stanley, we're going to take our afternoon recess for 15 minutes. And I consider direct examination to be complete because you're going over the same material over and over. But if you do, listen to me, if you do have a new area, I will allow you to ask about it. But we've covered 3 or 4 areas sufficiently. And so I consider direct examination complete on those areas.
It is not, Your Honor, but I have the doctor's referral that overrides what he's stating in the doctor that we need, that you entered as a exhibit.
Mr. Stanley.
That we haven't even addressed yet, Your Honor.
Mr. Stanley, if you'd listened to me, I was responsive to that. If you have a new area we have not gone into, I will allow you to ask that, but we're not going to go over the same stuff again. Stand in recess for 15 minutes.
Court stands in recess.
Oh, you might go over the same stuff again. Just have this feeling with this guy. You guys are cracking me up. Oh my gosh. I love you guys so much. Oh, you make this so worth it.
Okay, we are on.
Thank you. Court is back in session. Good afternoon, Your Honor.
Okay, thank you. Mr. Stanley, let me ask you this. Did you see Dr. Cuevas at any time other than December 22nd?
I was just going through all my notes that the court has from exhibit 1 to 17, and he keeps referring to that I need to file a lost property claim, and he keeps saying that I was seen, but I was never seen. And if we refer to my next document that I'm going to submit for Modowski, his boss, the director of DOC, that stated really clearly due to the bone loss. And I would just like to sum up for the record that he keeps referring to the 5 years with this administrator.
So Mr. Stanley, my question is, did you see Dr. Cuevas at any time other than December 22nd, 2017?
What year, Your Honor?
Good.
What year was that? What year was that, Your Honor?
Well, the visit that he just talked about was 2017.
Yeah, he keeps putting down all my notes. It says, you're on the list to be seen. His supervisor says you're on the list to be
Right.
seen. He states that I need to file a lost property claims thing. I don't
Right.
understand.
But Mr. Stanley, my question is, did you have a dental visit with Dr. Cuevas at any?
Absolutely not.
So
No.
the only time, so the only visit you had was on December 22nd, 2017?
The visit I had is when I got my new dentures back from Farmington Medical, and he was readjusted, which he says he never did, which he used his little blue strips to put in my mouth.
Right, but my question is, did you see Dr. Cuevas for a dental visit at any time other than December 22nd, 2017?
No, one time I went there myself with a pass, and he's holding his body alarm, and he's saying, you got 30 seconds to leave from pulling an alarm, like to announce the whole jail, like somebody's been murdered or something. So he cried like a little bit to give my statement. To get.
All right, so Mr. Stanley, did Dr. Cuevas write any notes in your chart other than this note that we've talked about on page 72?
Well, we have many things he's wrote in his chart, but again, he says that I was seen on such a date. And if we pull administrative directory videos going into medical.
Right, but my question is, did Dr. Cuevas write any notes in your chart other than this 12/22/17 note?
I've never been seen, and I have verification from DOC, his administrative directory, which I want to subpoena in for my next witness, which we
right,
need to
but my question is, did Dr. Cuevas write any notes in your chart other than December 22nd, 2017?
Besides what he wrote, I have no clue, but as far as I'm concerned, anything he wrote is hearsay, and it's a bold-faced lie.
Right.
So yeah. I don't know what he wrote
I'm
in the chart.
I'm going to ignore that. I appreciate if you answer my questions.
Well, I have no access to that chart, Your Honor, so I don't know.
All right. All right. Well, let me just, to try to move this thing along, let me just ask Dr. Cuevas, sir, whether you saw the plaintiff on any occasion other than December 22nd.
Yes, I did, Your Honor.
And what were those dates?
If you go to the exhibits, I wrote down the chart notes. I saw him several times in the clinic and saw him several times after that date as well, or attempted to treat him, but I certainly wrote my clinical notes.
Oh, okay.
So there's a date.
Go ahead.
There's a date, 23 June 2016 at approximately 10 o'clock. It's on page 73, sorry.
Okay, page 73, June 23rd, 2016.
Yes, at about 10 o'clock.
All right. And the next time, doctor?
Oh, let's go down, sorry. Other direction, at least. One moment, Your Honor. That's
yes.
Dr. McDonald. Let's go down. 20 May 2016 at approximately 10:15. It's a page 74 of Exhibit B.
Okay, I guess we're going in reverse chronological order, but that's
Your
okay.
Honor,
So,
if you
Mr.
want,
Panuchin? Yeah.
if we look at Exhibit B,
right?
It might help if we just start at the end and work backwards because it is in reverse
see.
chronological order.
I see.
That's not my first one. My first one's a little bit further down.
So if we go like base, we go to
scroll up. Yeah, now scroll up.
Well, the reason I'm asking is I'm going to allow Mr. Stanley to ask about other visits, but we've exhausted the topics on 12/22/17, administrative directive, the grievance that you may have signed. So when was the first visit in connection with dentures, when the issue of dentures came?
26th of February 2016 at approximately 1:30 p.m. It's on page 75 of Exhibit B.
Okay. So are those, you've mentioned 3 visits, are those the 3 visits, the only 3 visits before 12/22?
I also attempted
that's a different year.
I can clarify that for you if you may.
Well, page sometimes there's smaller notes.
No, I was wrong. That's back in 2016. So I'm just trying to get to topics that we haven't addressed yet concerning dentures.
Your Honor, if I may.
Mr. Stanley, go ahead.
Okay, on my exhibits 1 through 17, if you look at page 5, he even writes on it, whoever does, it says scheduled for 1/8/2018, his name next to it for broken dentures. But yet I get to call around in the year 2021, and I still don't have dentures over the 5 years.
Mr. Stanley, I don't want to hear arguments. I'm just trying to identify areas that I'm going to let you ask questions about. We've exhausted the other areas. Excuse me, sir. Excuse me, sir. I'm just trying to identify areas that you have not asked about. So I'm just trying to find out when the first visit occurred in which the topic of dentures came up. Was that 26/16?
I believe goes all the way back to 2016. And if you look at my exhibit 1 through 17, page 5, he even states scheduled to be seen on 1/8/2018 for broken dentures.
Well, unfortunately, I don't have a clear answer to my question. I'm trying to find out when the doctor saw you concerning dentures. I don't have a clear answer to that, but I will allow you to ask about other visits up until the time of your complaint, which was filed in February of 2018, I believe. And after that, there are no more issues concerning liability. So, Mr. Stanley, if you want to ask about some other visits, you may. Otherwise,
thank you, Your Honor. On my
yes,
exhibit 1 through 17, it's page 5, and it's a 11/24/2017 request form. And it's dated on their bottom 12/1/2017, and it says in their own handwriting, scheduled 1/8/2018, doctor, his name, for broken dentures.
All right, you want to ask about that? Ask the doctor.
For the record, this is page 6. There's a numbering issue, but it's page 6.
Yeah, no, I see it. Go ahead, Mr. Stanley. Ask the doctor about that if you have any questions.
Can we put that exhibit up on the screen if we may?
Sure, Tatum.
Yes, Your Honor. And
Mr. Finucane, we're looking at the plaintiff's exhibit, which is fine. I don't know if this is duplicated in exhibit B or not.
I believe it would be in exhibit C, Your Honor, but I have to double check.
Okay, that's all right. Don't worry about it. I have it in front of me.
So basically, could we scroll that down a little so we can see the top of this?
Absolutely.
Okay, so I believe this was the document that the Attorney General was referring to about failure to answer my many complaints of a June 2017 request. And as you see, it was stamped November 25th, 2017. If we could scroll it up a little bit more, please. And you'll see on the bottom where it says scheduled 1/8/2018, and it has this defendant's name next to it for broken dentures. And on the bottom, they answered it on 12/1/2017.
Is there a question?
There is. So if I was scheduled for the new dentures, for broken dentures, why did that not take place?
I didn't write that.
Well, somebody from medical wrote that.
Yes, that's Ostenheimer, but that's not me. That's not my handwriting. That's not my signature.
Okay, but somebody wrote that. That was a request. I had many other ones from Richter Leitner. I believe that she was your boss at that time. Rikel Leitner, Laghtner. She signed off on many of these request forms. Is she your boss or supervisor?
Raquel Leitner was my supervisor, correct.
So very clearly, most of these request forms are signed by her, stating that I was on the list for new dentures of 2018. So were you aware of any conversations with your supervisor and myself?
She mentioned you, yes, but as far as going back into details, I answered the grievances as I got them. I made clinical decisions based on how everything was presented. I reviewed the charts with her when she asked me specific questions. So yes, we did discuss many things about you.
So you were aware of my medical problem with my stomach that was brought to her attention?
Objection asked and answered. Please move on.
Well, you
All
said
right,
that.
next,
You addressed these
that's
issues.
sustained, Mr. Stanley, that's sustained. We've been through this. Do
Okay.
you have do you have questions about other visits?
Yes, I do.
Good.
Are you familiar with Doctor? I'm going to spell the last name. It's Kasabji. He's from Farmington.
That's, you mean Dr. Kasabji? He's the current dental director.
Correct. So basically, he is your above supervisor of a supervisor. Correct.
He's the dental director, yes.
Correct. So if he's stating in a document that very clearly his signed sworn testimony of my next exhibits would be in Exhibit 2, page 1, and he's stating that the bone is gone due to those dentures, would you object to that statement from him, or him coming in to testify under oath about what he says?
If you look at the bottom, it was signed by Dr. Leslie Bumpus, DDS, on 12/9/2020 at 1:54 p.m. So he didn't write that. That's Dr. Bumpus.
12/9/2020, correct? You had?
Yes, it says electronically signed by Dr. Leslie Bumpus, DDS, on 12/9/2020 at 1:54 p.m.
And if you read this document, they were bringing this doctor in to verify of my medical needs. Were you aware of that conversation?
I didn't see you at that date or afterwards.
I was at Radowski, so I never said that I saw you this day. Were you aware of Radowski medical issues bringing in this doctor to evaluate my medical needs?
Again, I didn't see you after you left McDougall.
So again, you were not aware of any doctor's appointments or any doctor statements or me brought to Farmington Medical about his medical needs, correct?
Again, I didn't see you certainly after you left McDougall.
So are you aware that I still didn't get dentures after 5 years when your statement saying, which I above and object, that clearly states a new set, but you're stating that where it doesn't say anywhere in the administrative director, and my question to you is that, are you aware I didn't get dentures to the year 2021?
I know I offered to do the dentures for you and you kept refusing.
Can you show me a document where I ever refused your service?
Sure can.
Okay, so you have a signed document from me that I'm refusing medical treatment?
It's
Not a hearsay. I want to see a signed statement from me refusing medical treatment.
okay. So on okay, we're going to Exhibit B,
Listen to
page
the question.
65.
I only want to see a signed statement that's signed by me.
Please let him answer the question. You asked the question.
All right, Mr. Stanley, you asked the question. Let the witness answer.
Okay.
All right, excellent, thank you. So it's Exhibit B, page 65. It's my clinical note when we switched to electronic health record. The note says, patient called to start impressions for a complete upper, CU. Patient refused treatment by this provider. Patient refused to sign refusal form for treatment. Refusal form signed by myself, dental assistant, and nurse supervisor.
And you have
I signed it,
So here's
and I
the
signed
question.
it in September.
Here's my statement.
Mr. Stanley, let the witness finish his answer.
All right, it's electronically signed by Frankie Cuevas, DDS, on 09/14/2018 at 11:38 a.m.
So back to my initial question, I asked you, show me a document that I signed that I ever refused medical assistance from you. Can you produce that, yes or no?
You didn't sign it. I signed it with the dental assistant and the supervisor.
Question. Do you have
No, you wouldn't sign anything I put in front of you.
Do you have a yes or no question here? Do you have any document showing I signed refusal?
No, you wouldn't sign it. I offered for you to sign, you refused to sign.
No.
Wait, he was difficult? I find that hard to believe.
So the answer is no. So again,
Okay.
we're going to rely on your hearsay testimony today, correct?
Objection, it's not
Sustained.
hearsay.
Mr. Stanley, just ask questions. Don't make statements.
Okay. So basically, why would we accept your records over my records when I'm the one without the dentures?
Mr. Stanley, it's for me, you don't have to answer it. It's for me to decide what evidence to credit. Do you have questions about any other visits, sir?
I do. Have you
Good.
ever reviewed the pictures of my dentures that were cut and sawed in half that I submitted as full exhibits? That would be exhibit 5, 6, and 7, pictures of the dentures.
I'm looking at them now, at the exhibits you submitted.
So can you look at, well, on the picture, it's up in the top left-hand corner, it says exhibit 6.
Your Honor, can I just clarify for the record
Right.
and for Mr. Stanley? We do have 4 pictures of dentures, which are marked exhibits, plaintiff's exhibit 4, 5, 6, and 7. I just wanted to clarify. For
Right. So I think the plaintiff asked to put up exhibit 6.
Well, that was my writing, exhibit 6, I don't know.
If it helps, I just showed the doctor all 4 pictures.
Oh, thank
here.
you. Right.
Okay, so that's a picture of the dentures, an exhibit 6. Is that the way dentures come when they come back from Farmington Medical?
I don't understand the question.
Is that the way dentures come back from Farmington Medical when they make them?
I don't. Oh, is that the way dentures typically look when they're in one piece? No, certainly not. That's 3
When
pieces.
they're made, when they come back from Farmington Medical being processed, is that how they come?
Oh, the dentures we send out don't go to Farmington.
So basically, do they come back looking like that, or are they one piece?
When we send out a denture to be completed, it does not look like that, but dentures don't go to Farmington.
But you're not the one that actually produces them, correct?
I don't understand that.
Do you make the dentures at McDougal Walker in your office?
Oh, no.
Okay, very good. Can we move to exhibit 7, the picture 7? I know it's a hard picture to see because it's black and white. Oh, that's very hard. That's why I wanted to be brought in where I have the pieces. So if we look to the piece that's to the right, the large piece, I don't know if everybody can see it. I'm holding the picture in my hand. You can barely see it, but it looks very wavy down here at the, oh no, thank you very much for that. Not the teeth part, but the part that it takes down. Can you see where it's like wavy, like it looks where it was broke? And everybody acknowledges that for the record. I know it's a picture and it's hard because
Objection, I didn't hear the last part of the question. If it could just be restated, please.
I'm asking if everybody can see the item to the right. Can they see where it's jagged and it appears to look broken?
Yes, that's a broken piece of a denture.
Can you actually see where it's jagged or not really?
Shadowing, but it's a broken denture without a doubt.
Okay. Your Honor, would I be able to hold up on the record the pieces to ask the question by any chance?
Well, you have to ask the witness whether he recognizes what you're holding up.
Well, they're all broken pieces, so it's going to be hard. It's what you're looking at in a picture, but I have the dentures in my hand, and it's very hard to determine here. That's the problem.
Your Honor, before we even get there, this
Right.
is going to be a preliminary step. 4 through 7 are full exhibits.
Right.
Do we maybe want an offer of proof from Mr. Stanley of, he never actually said, I assume he's saying they're his, but we don't have any record of what these even are.
There's no evidence of that at all. I have no idea what they are.
Right.
It's the mirror image of the picture that the court clerk just showed on the screen.
Yeah.
All right, never mind.
Okay, I mean, it's up to
It's
you.
going to be
but-
hard for this question, Your Honor, because they're ground down and they're cut with a power tool. It's sort of hard to ask this question on a video. So let me move on to a new question, if I may,
Okay.
please.
Yes, sir.
All right, thank you, John. All right, let's go a little bit off track here for a minute. Are you aware back in 12/27/2018, I made an offer to the court about this case? That would be entry number 115. And I take that back. That's 1/9/2029, 2019.
I don't remember anything off the top of my head, especially if you're not giving me any specifics.
Well, it's entry number 115. And the law says that you're supposed to make an offer to the other side about how you can basically resolve this issue without relying to a court of law. So on number 115, I made an offer to you about just replacing my dentures. Were you ever aware of that?
Is there documents that I can look at?
No, it's just my offer. It was a statement that was entered to the court, and your attorney, being your advocate, under penalties of perjury, spoke on your behalf. So I want to know, were you ever aware of me making an offer to you to resolve this? Was that
You never. I'm sorry. You never wanted to contact me directly, even at McDougal.
I did. I made an offer to the court that was answered. It went to your attorney, which he is your advocate, which basically he's speaking on your behalf under penalties of perjury of either you're lying or telling the truth.
Section, we're getting argumentative and it's been
To
answered.
sustain, I'm not concerned about legal issues. Offers to settlement or offers to settle are not admissible. What I am interested in is any other visits that you had with the dentist or any other notes that the dentist wrote concerning your dentures, sir.
Well, I'm just trying to lay a foundation here. Did your attorney
Right, well,
ever-
just ask him about any other visits you had or any other notes that he wrote.
Well, I'm trying to lay down the foundation that there was an offer made to you from me.
I'm not,
Objection.
sir, I don't want to know about offers to compromise. They're not admissible and they're not relevant. Ask him about, if you have no other questions about visits that you paid to the doctor concerning your dentures or other notes that he wrote, then I'll conclude that the direct is over.
Yes, back to your special defense that you entered on March 8, 2019. You basically stated on your third special defense, you said that if I may read this for the court.
Go ahead.
The plaintiff caused any allegations, harm, injuries, or damage with his own negligence, recklessness, or intentional misconduct. Can you explain your statement about that?
Can you put it in front of me?
Well, it's your own document, and you entered it. This is your sworn penalty to perjury from 2019, what
Right.
you stated.
I'm wondering, Mr. Finucane, whether you can, I guess it's part of your answer.
Yeah, it's, for the record though, it's not sworn statement.
I know it's not sworn. I'm just
All right.
disregarding plaintiff statements.
Understood. If you give me one moment, I can show
Yes,
him the
sir.
answer.
Yeah.
Can I rephrase that question if I may?
All right, go ahead,
Please,
rephrase.
please just give us a moment to look at the document.
All right, let them look at the document first.
That's fine, yeah.
Thank you.
I might have.
Excuse me?
Okay, all right. Third special defense, it reads, plaintiff calls any alleged harm, injury, or damages with his own negligence, recklessness, or intentional misconduct. That's what I just read.
Right, so can you decipher this for me of how are you stating, did you witness me ever breaking my dentures?
I witnessed your dentures after you ground them down, yes.
That you saw me ground them down?
I saw you when you brought them in and I noted that they were ground down. I wrote that down in the chart note.
Right, so did you ever witness me grinding them down?
No, but I saw you after you ground them down. I saw the
minute.
evidence of them.
You just stated you saw me after I ground them down, so you saw me grind them down?
Okay, you asked two separate things.
Okay, did
I saw
you
your
grind
dentures.
them down? First
I've
question.
never seen you ground your dentures while you're in the dental clinic. I saw your dentures later on and noted that they were ground down by you. And you, when I asked you, how did this happen? You said, I ground them down with the Brillo pad.
I stated that you
I
told, you're stating under penalties of perjury. I told you I ground them down.
And I wrote it down in my clinical
I
note.
don't care what you wrote down. I'm asking you today under penalties of perjury. I told you I ground my dentures down.
Yes, and that's why I wrote it down in the clinical note.
So basically, you're telling me that I sawed my dentures in half too?
If we can go to my clinical note, I can read it to you.
What your clinical note basically is hearsay. So I'm asking you under oath
Objection,
today,
it's not hearsay.
under penalties of perjury, today.
Mr. Stanley, it's technically correct. It's full exhibit anyways. But, right, so I mean, Mr. Stanley, so you can either ask him for his recollection without looking at the note, and we'll undoubtedly hear about the note on cross, or you can ask him about the note itself.
So you wrote a note stating that I told you I ground these down. That's what you're stating under penalties of perjury today?
Correct.
Okay, do you have any document of any other inmate or me signing a paper stating I said that besides your hearsay testimony today?
Objection, it's not hearsay.
It is
Right.
hearsay.
I'll just disregard. Believe me, I know the rule of hearsay. I'm just disregarding. Excuse me, sir. I'm just disregarding Mr. Stanley's statements about legal issues, rules of evidence, penalties of perjury. Those are rulings for me to make. Just ask him questions about what he did, what he wrote, what he saw. The rest of your question was fine.
Do you have any statements from me stating that I ground my teeth down or I sanded them down?
Yes, I wrote it down when you said it to me at the
You
end
have
of the
a
appointment.
statement from me that I said that?
I took your words
Listen,
and I wrote them down
me-
because it was quite
I'm not asking you what you
unusual.
wrote down.
All right,
Stop
Mr.
stating-
Stanley, if you keep
Your Honor.
interrupting the witness, excuse me, sir. If you keep interrupting the witness, direct examination will be over.
Okay,
I'll give
so
you
can I
one-
ask the question all over again? I want to rephrase that.
And
you have
then,
any-
and Mr. Stanley, listen to me. Go ahead and ask the question. I think the question is proper.
You have
Listen,
any
but listen
statements
to me,
from-
sir. Mr. Stanley, listen to me. I think the question is proper, but I also want to hear the answer. So do not interrupt the witness. Do you understand that?
Okay,
Thank you, sir.
yes or no? Okay, yes or no question. Yes
All right.
or no? Do you have any statement from me, signed from me, that I said I ground them down? Yes
No.
or no? So besides your hearsay testimony today, you don't have any documents to verify a fact that coming out of my mouth, do you?
I also have the evaluation by Dr. McDonald noting that your denture was modified.
Correct, but does
He wrote a
it,
clinical note too.
correct. And does that modification show that I did it or you did it?
He didn't say, but I was in the room when he saw you.
So again, does it say you did it or I did it? What's his diagnosis?
As I said before, I never modified your denture.
So you say, and I'm telling you, I never modified. So what does the doctor's note say? Does he say you altered it or did I alter it?
Can we go to it?
I'm happy to show the witness the document if that's what's being asked.
Do you want to do that, Mr. Stanley?
Yes, and if you could put it up on the screen, because I'd like to see this document of
Yes.
his testimony.
It's like closer to mine to go down. If you go scroll, it's easier for me to see. Yeah, there it is.
So for the record, we're on page 73 of Exhibit B at the bottom of the page.
Thank you.
All right, I'm gonna just read his chart note from Dr. McDonald.
Make clear what.
Okay. It's Exhibit
Can
B,
the court
page.
pull it up so I can see?
Yes, Mr. Stanley, please hold 1 second.
Clarify who writes what.
Okay, okay.
Can you
All right,
confirm, Dr.
so-
Cuevas, this is where you're going to read from?
Yes, it is. All right, so the date is.
Just one second while I find it. Okay, I have it. Go ahead.
All right,
Okay,
can we
so,
scroll this down
the-
we can see. You're at
All
the
right,
bottom
so
of the.
The top portion of the page is my note, and his note, Dr. McDonald's note, starts at 12/13/2016.
Okay,
All right, it says S, complaint of lower partial denture, needs reline. Bite is off on right side. Oh, examine. Cast partial has loose right clasp, occludes well on both sides. Framework fits well, saddles lift slash, I can't read that word, slightly. I think it's move, lift slash move slightly. Full upper denture has weak suction, has been altered by inmate. Tightened clasp, AP, no reline or remake indicated for partial PLD, partial lower denture. And that's his signature and that is his stamp, Craig McDonald, DDS.
So now can you scroll that down some so I can see where you said inmate ground them down? I'd like to see that.
Okay, it says specifically has been altered by I/M.
I still don't see where it's saying that. I'm trying, you're in the middle of the page, like at the bottom.
Your Honor, may I?
Yes, enlarge it if you can.
Well, I'm looking at the
Particularly
bottom of the page.
Right, next, that's helpful. But just on the left side, Dr. FUD, was that full upper denture?
Correct. Full upper
Okay.
denture has weak suction, dash, has been altered by IM, that's short for inmate. Tightened clasps, AP, no reline or remake indicated for partial lower denture. That's his signature and that is his stamp, Craig McDonald, DDS.
So basically, we would need to pull him in for an expert witness because of that statement. I would like to cross-examine him about where I ever said inmate altered it when I'm telling you the defendant altered this. So again, you're stating that you said that you've never seen me after my dentures. So can you explain to me of your testimony about a reline? What does a reline mean?
I never noted anything about a reline. That's Dr. McDonald, or if I did, I'd have to read my chart note.
So can you elaborate what a reline means?
He's talking about your lower denture, and if I recall at the beginning of this case, you said you never had any issues about your lower denture. This is all about your upper denture.
Correct. So so you wouldn't reline a partial, wouldn't you reline a top denture about
Yes, you would reline a partial denture. That is, yes, a lower denture, yes, you do reline them.
Okay, so basically, did I ever have my top dentures relined?
I never relined your denture.
I didn't say you did. Did I asked you, did I ever have my top dentures relined?
Yes, but not by me.
Correct. So basically, when they were given back to me, who gave them back to me after they were relined?
The person who relined them?
So it was not you that gave them back to me to readjust them, to refit them, to make sure that they're right with the blue strips that you see?
Correct.
So basically, after they're relined, you're telling me today under open court, today under oath, that you never gave me my relined dentures back. Is that what you're testifying today?
Again, I've never relined your denture. I've never adjusted your denture.
I never said that. I said, who gave them back to me after they were relined? Where were they given to me back and who gave them back to me?
The person who sent them out to be relined would be the person who gave them back to you.
And that would be who?
Not me.
You were the one that sent them out. You're the one that gave them back to me. So show me a document that someone else had them relined and they did all the care for me.
Objection. First of all, if that's plaintiff's burden.
I'll sustain it. The witness is not obligated to make your case, sir.
I'm not saying that, but if you're
Right.
stating that.
I am. So next question.
So if my dentures were relined, so whoever took my dentures to reline is the person that gave them back, you're stating, right?
Correct. The dentist makes the determination that a reline is indicated. They do the procedures to reline the denture. The denture gets sent out to the lab. The lab does the hard process reline, and then it comes back to the dentist, and the dentist who sends it out is ultimately the one who gives it back to you.
So can we show, can you produce some kind of a doctor's note or whatever of who sent them out and who gave them back? Because I'm telling you under oath, it was you So if you didn't do it, then you show me a document where someone else did it then.
Objection, that's not his burden.
That is the heart of this matter today, that he altered them after they were relined.
Mr. Stanley, don't make statements, just ask questions. Do you have any other
Okay.
questions?
So show me a document.
Excuse me, sir. Do you have any other questions before we complete direct
I
examination?
do. I'd like to see a document of who sent them out and who gave them back to me.
Well, what's
If
your
it wasn't
question?
you.
What
If it
question
wasn't
do you have?
If it wasn't you, show me who then took them and who gave them
What-
back.
Ask questions, sir. Don't give the doctor orders or
Okay.
attempt to lecture. Do you have any more questions?
Yes. So can you produce a document to show me that anybody but you took them and gave them back to me?
Objection, can we please move on to a new topic?
Well,
This is-
I'll just excuse me, I'll just rephrase the question. Doctor, do you know who relined the plaintiff's dentures?
As I understand it, the original dentures were relined, not by me. And then with his new denture, after delivery by Dr. Kasabji, he sent it out for reline as well.
So who gave them back to me?
If you know.
It's written in the chart. I'd have to scroll down to it, down.
If you could just have a moment to look at the chart, Your Honor.
Yes, of course, of course.
Just scroll. Like, it's before 2017. All right, okay, now scroll from here. Wait, scroll up. Okay. Yes, Exhibit B, page 75. Scroll up a little bit. It says 12/10/2014, 10:12 a.m. McDougal. Inmate here for delivery of full upper. Relined full upper. Delivered full upper. Still not great suction. Will need adhesive. He can talk without it falling now. Prescribed use adhesive as needed. I can't read that word at the top. I can't read what that says above her signature, but below on the side it says left buccal flange. Reminded, no relines, no new full uppers, Linda Reichler, DMD for 5 years. And then I believe you also had another reline before that.
So I'm asking you for a question on the record. Where is the document that shows who gave me the relined dentures back?
Again, the
If you know.
clinical note is there. Yeah, it's right there.
This just said that they were relined. It doesn't say that person gave them back to me.
Well, that's the way it works. When the
That is
when the
not the way
dentist
it
sends it
works.
out for a reline, they're the ones that give it back to you.
So where does it say that Linda Reichner gave me my dentures back? Because it's not saying that at all.
It says delivered FU. Still not great suction. Will need adhesive. He can talk without it falling now. Prescribed use adhesives as needed. I can't read that word to the left, to the right of it. And left buccal flange, that's her signature. Reminded, no new
Can you throw that
relines
up to me?
or new full uppers for 5 years. Linda Reichler, DMD.
No, I didn't mean to blow it up. I meant scroll it up so I could see the bottom of this document.
Did you guys get the impression when the dentist said delivered FU, he wasn't talking about full uppers? He put a little bit more emphasis on that.
So whose signature is that on the bottom right-hand corner?
That's Dr. Linda Reichler, DMD.
On the bottom right-hand corner? Because that looks like your name.
Oh, no, that's a separate date. That's my note. Go to the date above it. It says 12/10/2014. That's December 10th, 2014, 10:12 a.m. McDougal. My note starts on 26 February 2016.
And can you read me this document if you can, please?
My note or Dr. Reichler's
Yep,
note?
From the February 16th statement on the bottom of the
Okay,
top.
all right. So just to be clear, 26 February 2016 is over a year from Dr. Reichler's note.
I didn't ask for that. I asked you to read
Okay,
it to me.
all right. So I'll read my note. Subjective, can you cut back this denture? I am a gagger. Objective, patient indicated complete upper junction of hard and soft palate marked with Dr. Thompson's stick. Edge of the complete upper is adequate with post-stem to seal posterior border. Patient complained of having to use denture adhesive with denture. Patient had suction without denture adhesive. Assessment, posterior extension of the complete upper is adequate. No need to adjust posterior border of the complete upper. Patient argumentative. Patient had complete upper relined on 10 December 2014 and has not written since. Plan treatment complete. That's my name and signature.
So basically you stated that you never saw me after it was relined. You're stating here now that I asked you to modify them. And now you're stating, you don't say anywhere in this document that you ground them down before you gave them back to me.
Objection, compound question. and
Compound, you
mischaracterized.
asked three questions. Just ask one at a time.
So my question to you is yes or no. Does this document show you where after I asked you to modify them, that where does this document show that you did not alter them? Because I don't read that anywhere.
You can't answer that yes or no. It's a where question.
No need to adjust posterior border of complete upper.
These are your footnotes, correct?
Yeah, it says no need to adjust. Hold on, I'm reading it from up here. No need to adjust posterior border of complete upper. Patient argumentative. Patient had CU relined on 10 December 2014 and has not written since. Plan treatment complete.
So did I ask you or did I not ask you because they were so thick to modify them in this statement?
You asked me and I saw no need to modify them.
So you're telling me that you never modified them on this day?
Correct.
So how did they get ground down then?
You did.
I did. So basically I have access to power tools to grind them down?
You ground it down with a Brillo pad.
Oh, really? So that's how I ended up with powder in your office all over my lap from your Dremel tool?
Objection, argumentative.
Just ask
Did
questions.
you say you ever grind them down with a Brillo pad? Really? Did you?
No, I certainly did not.
Yeah, okay, so you did not see them down. So basically you're testifying hearsay. Do you have a statement from me saying I ever ground them down? Yes or no?
Can we read my next chart note? Can I read my next chart note?
Do you have a statement from me that I ever ground mine down or I told you that?
Yes.
You have a statement from me? So pull it up. On
Yes, and I wrote it down.
No.
It's on 20 May 2016.
Stop altering the question. The question is, do you have a statement from me, signed from me, that I altered them? Yes or no?
A statement from you? Yes. When you said it to me, I wrote it down.
So show me my statement that I altered them and I ground them down.
It's on,
with my signature.
it's on Exhibit B,
With my
page
signature
74.
on it.
Oh, well, it's not your signature.
Well, that's what I just asked you. Listen to the question 3 times now. Do you have a document with my signature on it telling you that I ground them down? Yes or no?
Do I have a written document signed by you? No, but signed by me.
With my name on it, signed by me, that I altered them. Yes or no?
No, certainly not. Certainly
So
not.
then you're putting words in my mouth because I never said that. So how are you testifying for me when I'm telling you I never said that?
Go to page 74 of Exhibit B. I can read my chart note to you.
That's your statement or it's my statement?
It's my clinical note.
No, basically, you don't have a document from me that shows that I said that with my signature on it. Is that what you're testifying
No, but I have
today?
my document saying you said it to
I
me.
don't care about your statements at all. I'm asking you about mine. These are my questions to you. Show me a document with my name on it that I told you I ground them down. Because if not, your statements are hearsay.
Your Honor, can you
All right,
please answer
Mr.
the question?
Mr. Stanley,
Well,
you're
not
making,
putting words in my mouth,
Mr. Stanley,
because I never said no such thing.
Mr. Stanley, don't interrupt me. Do you understand that?
And just like me.
Do you
don't
understand
interrupt
that,
me,
sir?
'cause I never said no
All
such
right,
thing.
Sir,
So don't
here's
put
your
words in my
here's
mouth.
your warning. Here's your warning. If you interrupt me again, direct examination is complete because I cannot make this direct examination happen. You won't listen to me. You just want to hear yourself talk. I am trying to tell you, you may not make statements on direct examination. You may ask questions only. If you want to ask, do you understand that?
Yep, so I want to see a document to verify that I said that, not a hearsay testimony. I want to see a document that I
Right.
said that and I signed the paper.
He's answered your question. He's trying to answer your question on
Is
page.
this document?
Mr. Stanley, don't interrupt me. He's trying to answer your question by pointing to a note on page 74. He's already answered your question that he does not have a signed statement from you. He's answering a different question that he has a statement from you. Let me hear the witness answer. If you don't let him answer this question, direct examination is over. Do you understand me, sir?
So I withdraw that
Do you
question.
understand? Do you understand me, sir?
Yeah, and I understand this. I withdraw that question and I move to my next line of questioning.
Okay, fine.
So
Objection, Your Honor. I would like the witness to be able to answer.
Well,
If
you'll
I
have,
withdraw, there's no
excuse me,
question on the table.
Mr. Stanley, don't interrupt me. Do you understand that? The witness will have an opportunity on cross to answer the questions that Mr. Stanley has withdrawn. I'm glad to hear you're moving to the next line of questioning. Let's go to another visit or topic.
So in your special defense that you filed on March 8, 2019, you stated that I caused this injury to myself on your third special defense. But yet though today under oath, you can't produce any documents that I've ever signed anything. Yes or no that I caused my own injuries, correct?
Do
Yes
I
or
have
no?
you signing a document? No, but I have my own.
Well, I'm going by what you said, that you said I caused my own injury. So you don't have any documents today that I stated it or I signed it that I caused my own injuries, correct?
That you stated it? Yes, it's in my clinical note.
Why don't you just answer the question? Do you have answer?
Objection, badgering.
All right, Mr. Stanley, he's answered the question. Unless you have a different question, direct examination is over.
So basically, under oath today, under penalties of perjury, you have no documentation of me, signed by me, to support
All right.
your statement of March 8, 2019, that I caused
All right,
my own
direct examination is over. Thank you, Mr. Stanley. Mr. Finucane, it's 4:33. I'm not sure how much.
Well, I still need to testify under oath for my own behalf.
No, you already have testified,
I
Mr.
never
Stanley.
testified on my own behalf yet, Your Honor. Because I have other special witnesses to testify under oath.
Right. What you testified this morning. We spent a lot
I
of time.
did not.
Yes, you did. So it's time for cross-examination, but I need to know from Mr. Finucane
So how about my
whether
next witnesses then?
Mr. Stanley, if you call a witness and ask him questions on direct, then defense counsel is entitled to cross-examine him. If you object to that or interfere with that, then I will strike the witness's direct testimony because each side is entitled to cross-examine the other.
Absolutely.
Good. All right, Mr. Finucane, would you, we don't have a great deal of time. Would you prefer to start now or at the next court meeting?
Your Honor, I'd prefer to start the next court meeting. In fact, I think I would just reserve my right to simply recall the doctor in my case in chief.
Okay. All right. So, excuse me, let me just follow up on that. You can do that. And then there would be no further, no redirect examination of Dr. Cuevas at this time. His testimony would be complete until your case. That's what you would like, Mr. Finucane?
Yes, Your Honor.
Okay. All right. That's fine. So, Mr. Stanley, I'm not sure I know of any witness who could testify as to what, as anything in his own or her own firsthand knowledge about your dental care that occurred before the filing of the complaint in February of 2018. But if you give me one or at most two names of people who did treat you before that time, I would consider granting an application for subpoena.
Okay, Your Honor, I would like to pull in any administrative directory from DOC to clarify, because you're hearing both sides of the story of the administrative directory, when we need an expert witness testimony.
Right, I'm not going to allow expert testimony because you did not disclose any experts. So do you have any fact?
I gave it to you about my witnesses, and then if we need the doctor we brought in of his sworn certified statement saying due to his negligence.
Mr. Stanley, listen to my question. Do you have any fact witnesses, particularly people who may have treated you before the time you filed your complaint, who you would like to call as witnesses?
Yes, I have the doctor that came from Farmington Medical that examined me at Radowski Correctional, and I can give you that name for it to bring him in.
When was that?
I believe that was 2020, I think.
All right, that's after the filing of your complaint. I want to know.
Right. If I can finish, if I may.
Okay.
He is his director, as well as he knows both sides of the two coin here, and he will testify to the fact of his certified statement. Due to my dentures being ground down by this defendant, and he would clearly testify this under oath, he needs to be brought in. So he will be basically the litigator to hear both sides of the story about the administrative directory. He's his supervisor about how things are supposed to work, and I don't have to wait 5 years for new dentures, as well as he would testify due to the fact that my bone is now deteriorated. There's nothing left for an option about that besides implants.
Mr. Stanley, I think there may be evidence that, let's see, that you made this statement before 2018, so I might allow that. But let me see. Yes, the note was written in December 16, I believe. So who is this person?
We have the doctor, it's his supervisor. I'll spell it. Kasabji. And if we would like, we could even bring in the person that wrote this document. That would be Liza Bump.
Hold on. I want to get your applications for subpoenas.
Okay.
Because I know you filed that. I have that in my file.
I don't know if you had them. They sent them all back to me, Your Honor.
No, I believe I do have a copy of that. But I'm trying to locate it right now.
Now, would the court be subpoenaing them, or would you be relying on me to service?
Okay. I see. This is no.
Just to be clear, these are doctors that provided care in 2020 after the lawsuit's filed.
Right. So that's where I was confused, because I thought he was referring to a note or a statement that the plaintiff made that he altered his own dentures, which did occur.
That was Dr. McDonald. That was a different doctor.
Yes, that's true. So what I would be interested in hearing is any doctor who treated you before the filing of the complaint, or took or talked to you or interviewed you or made notes about your treatment.
Well, this doctor here, the one that saw me at Radowski, and then they referred it back to the head medical examiner, and he came to Radowski to review me about.
Right, but what I'm interested in is what happened to you before you filed your complaint. What happened after you filed your complaint is not part of this case.
Well, we have the administrator, Ricklin Leitner. She was part of it. And she was his supervisor also. That was from 2018. I can spell it for
but
you.
No, well, you filed the complaint in February of 2018, so I'm only concerned about people.
This request from January 20th of 2018. It's my exhibit on 1 to 17. It's page 9. And it's to do with, she's the supervisor. I know she was at the time. I don't even know if she's still available or not. So it's Rickner, R-I-K.
If we're talking about, I can maybe help here. If we're talking about Raquel Leitner, she was a health services administrator, not a treater. And my understanding is she no longer works for the Department of Correction, has not for some time, and I don't believe she's in Connecticut anymore.
So again, if we could just bring in the supervisor from Farmington Medical, that doctor's name I gave you, Kasabji, they can basically speak on everybody's behalf. We can get to the bottom of this once and for all. With this one person, we give testimony about the injuries, and that I would not have to wait 5 years for a new
did you make out?
Testimony.
Yeah, it sounds like it. That's why I'm asking for any possible witnesses who treated you before 2018. Someone who treated you after that would be rendering an expert opinion as to the treatment before that, which I'm not going to allow. But you did make out 41 witness subpoena applications. Was Dr. Kasabji one of those?
You know, I don't even think I have my witness list with me right now.
All right, so here's what we should do. We need to reset. So what I'm suggesting is, if you make out new witness subpoena applications and specify what you want them to testify about, in particular, your treatment before you filed the complaint in February of 2018. Let me finish. I was gonna say that I will review those, but
it's number 36 of that doctor that appeared to show that's his supervisor, and it's as well as he's administrative directory of this, and he would verify one. Instead of he say, she say about this administrative directory about when they applied new dentures, he could testify to the fact, am I entitled to these new dentures before 5 years, or do I have to wait 5 years? So it would be proper to get just anybody in, not for a second opinion, but to give a valid claim of this administrative directory that clearly says, and from what I'm reading and I've spoken to a supervisor, you're entitled to an additional set every 5 years. You do not have to wait 5 years to fix them. So therefore, again, almost anybody on this witness list would almost be a valid.
Well, Mr. Stanley, why don't you file new applications with 1 or 2 names of people who treated you before you filed the complaint, and I will review them. And if they
people are retired, that's the problem we have. So
well, that's your problem. This case was filed in 2018, and so some people have retired, but I'm the one who wanted to try to move this trial forward. You didn't want to start the trial.
Well, how about a Robert Rickson? He's the Chief Operation Health Service, and he's number 38. He had basically first-hand knowledge of everything.
Mr. Stanley, please do what I say. File a new application for subpoenas with 1 or 2 people who treated you before. Mr. Stanley, if you don't let me finish, then your case is over, and I'll hear the defendant's case.
Who's retired and who's not?
Mr. Stanley, I can't tell you that. You'll have to ask other people, but let me finish my statement. The problem I had with your 41 witness subpoena applications was that you said the same thing for every one of them, and I'm not going to allow you to call 41 witnesses. I will consider allowing you to call 1 or 2 witnesses who treated you before the time you filed your complaint to testify about your medical condition. So if you can file a new application with 1 or 2 people who treated you before you filed your complaint, I will take a serious look at it.
The problem is half these people have retired. If the court acknowledged these subpoenas a year ago, they would have been retired.
Right. All right. So if you can't do it, then you've completed your case. Is that what you're saying?
The point is, you yourself, Your Honor, this court sat on these subpoenas over a year and sent them back to me denied. If you properly,
I just told you the reason that I denied them. You're not listening to me, so I'll say, sir, excuse me, sir. I will say it one more time. I will let you file an application for 1 or 2 witnesses who treated you before you filed the complaint, who can testify, although they may be dentists, essentially providing fact testimony as to their observations and treatment. If you file an application stating what they would say, if you don't do that or don't want to do it, then you are resting your case.
All right, can
Understood?
I ask you a brief question, please?
Yes, sir.
if I may? Okay, how about if you grant me permission to just bring in anybody that can verify, to verify the administrative directory about this dentures waiting 5 years or not 5 years. We only need one person that's up to par today to verify these documents. So we don't even have to go and searching for witnesses that aren't there. We don't have to go on a goose chase. I would be permitting to let the defendant pick somebody from the administrative directory that can come in to testify, or even a grievance coordinator, because they are possible to do it. Somebody that's on deck today just to verify these documents that, look, is this true or not true? And that would prove, never mind who ground down, it's not he say, she say anymore. These documents, does Mr. Stingley have to wait 5 years? Yes or no? That would be the bottom line.
Okay, that's not a bad suggestion, actually. So
does
Mr.
the state agree with that?
Well, let's find out, Mr. Finucane.
If that is the sole issue left for evidence in Mr. Stanley's case, I can make an offer of proof that it will be addressed in my case in chief. In fact, the defendant's going to testify about that extensively. And we have evidence in the record about it that's full exhibits that Mr. Stanley did not go over, that we will be going over.
Yeah. So, Mr. Finucane, let me just clarify. I thought Mr. Stanley was talking about the administrative directive.
I am.
Yeah. And
the administrative directive does not address, I mean, it's in the record. Your Honor can read it. It does not say what I think Mr. Stanley thinks it says. There are policies that address the issue Mr. Stanley wants to get into that we have put into evidence and that I can represent to the court. Dr. Cuevas will be testifying about in our case. Okay. So if that's the only issue he has left as far as his case, it's going to be addressed in our case, and he will have the opportunity to essentially recross or cross-examine Dr. Cuevas on that. And if at that point Your Honor thinks it's sufficiently contested not on the evidence and you need to hear more on that limited issue, then I suggest we address it at that stage. But
Mr. Stanley,
that would be my thought.
Yeah.
Your Honor, if I may. Yeah. Again, it's a he say, she say. We're not going to take his side or my side. Okay? So let's not be a referee. Let's call in one of these administrative directories like that doctor, and he can testify what these documents verify. Does Mr. Stanley have to wait 5 years? Yes or no? This case is over.
Mm-hmm. So do you have a witness, a person who is familiar with how these administrative directives are implemented in McDougall at the time?
Well, as of today's date, this doctor from 2020, which is his supervisor, would come in, and that's at Dr. KAS ABJI, and he would testify under oath about the administrative directory. So
right, but the question is what happened in 2018 and 2017. So do you have a witness who can testify about how the administrative directive worked at that time?
Well, that's why this doctor would come forward now stating very clearly that, one, you don't have to wait 5 years or even 7 now, back then, that you're entitled to a new set. I got documents from all doctors here, as well as other jails.
All right, so you want to
take my word.
You want to call Dr. Kasabji?
We could bring him in. We could ask him over to bring in the administrative directory, and we would ask him questions on the record about, instead of you taking my side or the defendant's side, this 5-year issue is where the dentures, where the bone gets deteriorated. Mm-hmm. So even if we overlook about how they got broke, let's look about administrative directory, why you didn't give me new ones.
Yeah. Well, if you, are you familiar with Dr. Kasabji, either Dr. Cuevas or Mr. Finucane? Is he in the prison system?
I personally am not familiar with him. My understanding is
Dr. Cuevas?
He's the current dental director for DOC.
Yes, he is,
Oh.
Your Honor.
Oh, okay.
And
All right.
he signed many of the documents that's,
And was he in the dental service in 2018 and before that, Dr. Cuevas?
I don't exactly recall when he started, but during the period that in 2018, I believe it was Dr. Benoit, but Dr. Kasabji came in after 2018, started state service and everything.
Right.
Yeah, I believe
So-
Dr. Benoit was the dental director during all, if not most, if not all, of the times in question before the lawsuit was filed, and he does not work for DOC anymore, is my understanding.
So who took his place? Do you know?
Dr. Kasabji, right?
Dr.
Yeah.
Kasabji took his place, but he came in after, I
Right.
don't know the exact date, but
Who took his place as dental director? These people also see patients, I believe, too, so they may not take the exact place in the facility as a dentist, but they, is my understanding, right, doctor?
Yeah.
Well,
Would
which
you
would you
have-
prefer, Dr. Kasabji or Dr. Benoit, Mr.
Well,
Stanley?
Dr. Benoit retired, they thought they said.
Apparently, yeah, or left DOC service.
So if this person took his place, that's why I was trying to have him step up to the plate where
All right.
basically we could each side ask a couple questions and have this over.
Okay, and
But
Dr.
just to be clear, I don't want there to be surprises, Your Honor. If he tries to ask Dr. Kasabji how to interpret a directive or a policy or a practice from before he worked for DOC, we're going to object. He would have no basis to know any of that, right?
Yeah, that's the problem I'm trying to solve is.
Well, Your Honor,
Yeah,
here's,
go ahead.
here's the problem now. We've got over 10 years you didn't give me no dentures. So even if it wasn't back then, even now, you still didn't give me the dentures to
No.
the year
I'm
2021.
No, that's not correct. I'm only concerned about what happened before you filed your complaint.
Right, but if he said I was entitled, let's say that he's right.
So,
now.
was, maybe you remember, Mr. Stanley, was Dr. Kasabji in the dental service at DOC in 2017, 2018?
I tried to reach out to other doctors and every time this defendant kept ending up with my paperwork, just like my grievances. I don't know how, but every time I wrote to reach out to anybody besides him,
All
I
right.
never got a straight answer from anybody.
All right. Well, it's not up to me to prove your case. So how much time do you need to file applications for subpoenas for one or two more witnesses on this
Well,
topic?
if the court agrees to it today, I'm asking, I've done it before in the past of other criminal goods, that you could order the court clerk just to subpoena this one doctor.
No, well,
We would be
I
good
would
to
like to
go.
respond in writing to the applications as well. I'd like the opportunity to respond.
all right. So is the doctor already included in your applications? I think you might have said he was number 37 or something.
Yeah, something like that. Hold on.
But the problem, Mr. Stanley,
He
is
was
if,
number 36.
yeah, the problem is if he was not the dental director at the time you filed the complaint, then he really would not be in a position to say how the administrative directive was implemented at the time.
But
So
here's where it would be relevant, Your Honor, because if he stated, this defendant stated, I'm only entitled to every 5 years, so why didn't you wait over 10 years to give it to me? So therefore, again, you waited 10 years.
But we need someone who is familiar with how the administrative directive was implemented before the time you filed your complaint. So I will give you 2 weeks to file an application for subpoena for such a person. And Mr. Finucane, you can have 2 weeks to respond to that, and
Your
then
Honor.
I will decide.
Your Honor, if I may, half
We-
these people are all up to date to now. You're asking me to do something impossible. Half these people
No.
that you want to come in that were part of the case back then.
No,
they're retired.
I'm not. It's your case to prove. It's your responsibility to find witnesses. If you don't have a witness who can testify as to the time period in question, then we won't hear the witness.
Now,
Now,
how about this then? If that's the case, then, Your Honor, let's bring in the Commissioner of Correction, Angel Cuevas, and he was here during that time. He can testify.
all right, I've decided. I've ruled on that, Mr. Stanley. So the next court date will be determined. I mean, if we could try to set one now, let's do it. It's going to take a while to bring in the next witness, if any. So
are you denying on the record for me to bring in the Commissioner of Corrections where he was available back then?
What I told you, sir, you didn't listen to me. I told you may file applications for subpoenas for 1 or 2 witnesses who can testify about what they did when you saw them as a patient, or even how the administrative directive was implemented before the complaint. I've already addressed that, sir. Now, we're going to address when the next court hearing is. It's going to take a while, because if I do grant an application for subpoena, then it'll take a while until we can get that witness. So,
Your Honor, if I may briefly, I'm trying to bring to your attention now, instead of you wasting my time and I wasting your time, you're going to have me submit applications and then you're going to just deny it. So I'm asking you today, Angel Cuevas was been administrative directory. He knows about it from the past. He was here. So if you grant me to file with the Commissioner of Corrections, I will draft it up and submit it to you. But if you're just going to rubber stamp it denied, why are we even wasting my time?
Right. This is a case. I'm not going to have to explain this, sir. This is a case about dental service. I'm not calling the commission.
Available. We're only talking about
right. Okay, sir. Mr. Stanley, I have ruled on this. I have told you time after time that you may file 1 or 2 applications for subpoenas for people who you think can provide factual testimony as to what happened before you filed your complaint. If you don't do that within 2 weeks, your case is over. Okay? Now, Mr. Stanley, I have just explained this to you for about the 3rd or 4th time. It is very simple.
My case is over if I don't have any expert.
Because you have.
Basically, you're going to rule against me because you're taking his hearsay testimony. How can that case be over if I don't have any witness?
I said what I said was, or what I can clarify, your case in chief is over. Okay.
So I will can we just pick somebody today on the record that is still available on this witness list today?
I have given you numerous opportunities and you have failed to do so.
I have no access.
I have given Mr. Stanley, okay, I'm going to just consult with Mr. Finucane indirectly through the clerk as to what's a convenient day. You refuse to listen to me. You continue to interrupt me. Court is adjourned. Good night.
So you're not going to answer me on the record today of which one of these witnesses
stands adjourned
is still available?
One moment, I'm going to take out the VC. Should I take out the VC right now?
Yes.
Tatum?
Yes.
Okay.
Thank you.
One moment.
I warned you guys. I warned you before it even started. I told you it was crazy. The thumbnail says most obnoxious defendant ever. I don't think I got it wrong. My goodness. And to the 40 people that managed to make it this far, thank you so much. I know. Oh, crap. And the you got to figure though, it's really not over. I just don't yet know when the next hearing is. I only need sleep so that I can wake up and get more cases in the morning. No, you're right. He's technically the plaintiff, the inmate plaintiff. Oh, man. You deserve a trophy. Just wait. I have the design in mind already. You just wait. It's coming. Oh, yes. Yes. Thank you guys so much. I had such a blast. And yes, Pegleg Finance, just for you, I will go to bed. I think I'm kind of being ordered to. If that face doesn't say it all. He's telling me something, aren't you, baby? Aren't you? You see, Mama, it's time to cuddle. It is cuddle time. All right, guys. Be safe, be well, sleep sweet, and much love.